by placing your jeopardy in your life, you shoot, well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, this is, I apologize, PHL-OTP 00001127 at page 5. And I quote, "But if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility." Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, "Just do it right. We have our trainings that you can only kill if your life is in danger, and you are there performing the duty of a law enforcer. That's about it." Now I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find. And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech which the prosecution either missed or ignored because it doesn't suit its case. And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this, "I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today. Make no mistake about it. I repeat again for all and for everybody's consumption. Do not kill if you are not in danger of losing your life." Well, it goes on. You can see it there on the screen. Well, of course, the prosecution knows that we are going to argue that many of these speeches, in fact, the majority of these speeches, I would say, contain this exhortation to the lawful use of self-defense. And the learned counsel, Mr. Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel concept of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask your honors and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had the speech of 2 pages prepared, but to his regret, it didn't come from the heart. And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colourful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy, quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth, and that hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to bruise the prosecution on the matter is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers. The same goes for another witness's outlandish assertion that bodies were thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced. As for counts 2 and 3, Ms. Croft showed us some maps with coloured dots to indicate the magnitude and geographical spread of what the prosecution alleges, without, of course, proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, for this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the appeals chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432 in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient. Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered, but she neglected to contextualize these numbers by reference to other parts of the same report which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages. So, if I may just conclude, the only thing that is widespread here, or rather spread wide, is the utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory, with respect to the definition of the targeted population, is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting two alternative propositions, hoping that this pre-trial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, comprised prison detainees, history, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? It was not as if it had been denied the arrest warrant for El-Hishri that it had sought. Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10th February 2025, the prosecution rushed out its application for Mr. Duterte's arrest, believing that a unique opportunity to apprehend him had arisen. In this application, the prosecution defined the attack perpetrated by Mr. Rodrigo Duterte as being aimed at the entire population of the Philippines. Let us now fast forward to 10th July 2025. The pretrial chamber, this same pretrial chamber, ordered the arrest of Khalid al-Hishri for an attack on an objectively identifiable civilian population of detainees, while finding no justification to suspect him of crimes committed against a discrete subsector of that population, exhibiting characteristics distinct from those of the general population. Well, as you can guess, the prosecution didn't like that decision and hastened to appeal it. Not, I would suggest, out of any true concern for the purity of international humanitarian law, but rather because it put a spanner into the works of the Duterte case. That is, the only other active case that it is prosecuting before this court. After all, if we apply the resulting logic of Your Honour's decision in al-Hishri to the prosecution's case theory in the Duterte case, at least as it stood as of 10 July 2025, then alleged drug pushers and alleged criminals would be deemed a separate, subjectively defined subgroup of the general Filipino civilian population, displaying different characteristics and, as a result, excluded as targets of the attack. So, 8 days passed between this decision of yours, Your Honours, and the notification of the confidential version of the prosecution's pre-confirmation brief on 18 July last year. And I'm prepared to wager that while beavering away with their attempt to appeal the al-Hishri decision, the gurus on the top floor of the Office of the Prosecutor were also frantically discussing how to deal with this inconvenient fly in their conceptual ointment. They had to think of a way to accommodate this pretrial chamber's ruling while not compromising their appeal. So, lo and behold, and rather unsurprisingly, the pre-confirmation brief contained a new feature, namely the second scenario to which I referred earlier, that the target of the attack was not the Filipino as a whole, but the suspected drug pushers and criminals. Now, even if the former president did promulgate an organizational policy of eliminating suspected criminals and drug pushers, which he most definitely did not, this policy did not and could not constitute an attack directed against a clearly definable civilian population. Firstly, the segment of society victimized cannot be said to display objective characteristics distinguishing them from other members of society and thus rendering them susceptible to an attack. After all, how does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count 1, where there were no HVTs or high-value targets or PRD lists or kill lists or what have you? It is not as if criminals have identifying features such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. It is a shifting and mutable concept. It is a subjective determination. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group such that they can be deemed a civilian population for the purposes of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection, and as cited quite clearly in the Al-Hassan confirmation decision at paragraph 149, The prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorising an investigation in the Kenya situation, where at paragraph 81, the pre-trial chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole and not merely against randomly selected individuals. So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole or at a subjectively defined subgroup of perceived or alleged criminal offenders. The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly, even according to the prosecution's own witnesses, who talk about quotas of neutralization that had to be met, and their motives for target selection, which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards. With that, Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration. Now, I have racked my brain for many a month pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after Rodrigo Duterte pulled his country out of the International Criminal Court? After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, it didn't take too long for the penny to drop. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. there is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b). But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the pyramid of Giza. The most they can do is allege that they're cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso, understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers, or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case, and that is not for want of a desperate attempt to find one on the part of the prosecution with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone. Let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges levelled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. Normally, I would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability, as pleaded, contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defence has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte or even indicating his participation in or control over any one of the 49 incidents alleged in a document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole. And where these documents will not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters I would respectfully submit are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability levelled at Rodrigo Duterte. As we all know, in order to prove criminal liability through indirect co-perpetration, there is a need to show a common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was, in addition, wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is, of course, entirely preposterous, and, I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33, inclusive, of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in the prosecution's mind and nowhere else. Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data. But the cardinal rule of such a category of evidence is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances. What we can say with a degree of certainty, which reaches more than a substantial degree of certainty, is that no inference can be drawn from the comments of crime-based perpetrators. And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses. Or witnesses. Where are they? Number one. Interviewee: at least more or less than 10 buy-bust operations. Where somebody was shot, asked the interviewer. Yes, sir. Interviewer 1. Okay. And on those 10 occasions, was the shooting justified? Interviewee: yes, sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. And the third one. Witnesses who said, the PNP never said kill those people. Another quote. From what I recall of the incidents that I was at, all of them had guns, and they were pointing them at the pusher-buyers, or they were pointing their guns at the pusher-buyers. At the operations I was at, I'm talking about the operations I was at, the reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher-buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication, and that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress to neutralize and not to kill criminals. That's what's stated in the PCB. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties. That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it. After all, one does not fight crime with kind words and gentle admonishments. The fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible. Trust me, had any one of the unreliable, insider, criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims, the prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, the allegations concerning the activities of the so-called Davao Death Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of the so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Now, thinking like a prosecutor, I would say that the reason why the prosecution has fixated De La Rosa issued a pre-drafted command circular number 16 of 2016 on 1st of July of that year, formally launching the anti-illegal drugs campaign nationwide in express pursuance of Duterte's campaign promises. There is no dispute that CMC number 16 of 2016 mentions Project Double Barrel, which was indeed modelled after Davao City's policing strategy and was directed at the neutralization of illegal drug personalities nationwide. But here we come to the crux of the prosecution case. The manifestation of the criminal plan in writing. Neutralization as a euphemism for murder. Ms. Robin Croft certainly thought so when making her submission on behalf of the prosecution, highlighting the word in bright red and presenting us with a slide where the word neutralization forms an integral element of the common plan to import an element of criminality into what would otherwise be a perfectly anodyne legal document. The prosecution resorts to relying on speeches and interviews given by Ronald de la Rosa, Bateau, within a day or two of him being appointed the chief of Philippine National Police. For example, in an interview relied on by the prosecution at footnote 136 of the pre-confirmation brief, De La Rosa explains how tok hang means knock and plead, and that it is a totally legitimate police strategy. However, the citations relied on by the prosecution to infer that tok hang was a criminal modus operandi are completely taken out of context. I shall just cite one question and answer from the media interview on which the prosecution relies at paragraph 27 to prove that De La Rosa, when talking about instilling fear in the hearts of drug users, was actually proposing a policy which was anything but criminal and totally supportive of the main tenet of the defense, namely that the only use of force would be that envisaged by way of self-defense. And I quote, question, "Sir, you mentioned about instilling fear. When you instill fear, how do you ensure that you do not violate human rights?" Answer, good question. We will see to it that the police operational procedures are being followed in every legitimate police operations. When they see that the police are really determined to go for them legally, he stresses the word, and many of them go down, maybe they'll get scared. That's PHL OTP 000-16403 at page 13. In any event, what the prosecution has not told you, and what it has not shown you by way of its opulent images on the video screen, is that the supposed criminal blueprint set out in Command Circular 2016, number 16 of 2016, is totally negated by the content of the document itself. Let us take a look at paragraph 8E and F of the very same Command Circular, number 16 of 2016, which states quite clearly that all operations should strictly observe the rights of the accused enshrined in the Philippine Constitution, as well as international law and human rights. Why, I ask you, did Mr. Edward Jeremy, counsel for the prosecution, in his very eloquent and gilded address, not screen this part of the Command Circular? After all, this Command Circular, as elaborated by Ms. Robin Croft, was the very essence of his criminal common plan, in writing. This is the basis, so Mr. Jeremy stated, for the criminal agreement to kill high-value targets. And if that were not enough, the lawfulness of Command Circular 16 of 2016 was reiterated 3 weeks later on 22 July through the initiation and issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. I think there, Madam President, if I may, we can take a break, obviously with your permission.
Bien sûr, maître, je vous remercie, Captain, je vous remercie beaucoup.
Thank you, counsel. Thank you very much. If you can also indicate the numbers of the documents that you have referred to, that will be good.
Sa punto ito, makakausap muli natin si Professor Romel Regalado Bagares. Professor Bagares, anong masasabi niyo doon sa unang bahagi ng submission of merits ng depensa?
So, gaya nga ng kaso ng bago, napaka-relevant talaga dito.
Yes.
Walang ibang ebidensya, puro press release, human rights reports, NGO reports, yun kasi yung nangyari dun sa bago. No? Wala, pero sabi ko rin nga, sa bago walang written policy, dito meron. At sabi ko smoking gun yun, sinabi niya hindi smoking gun. Ano? Kasi nga, talagang ito yung pinagkakaiba dito sa ang kaso nito at saka ni Bago. At inaasahan ko rin talaga na sasabihin niya na bakit doon sa kaso ng Bago, wala namang matibay na ebidensya na maglilink doon sa mga sinabi ng Pangulo at saka doon sa mga pagpatay. No? So, inatake niya yung causation theory ng prosecutor. Isang malagang makita dito, sinabi niya rin, no? Tingin ko, medyo malakas yung puntos niya dito. Yung dokumento mismo, merong nagsabi na human rights ay ay susundin ng mga kapulisan, ano? Dahil
Yes.
at sinabi niya na ang dokumentong ito, hindi man ito criminal modus operandi. Ang dokumentong ito ay patungkol sa krimen, kung paano puksain ang krimen at hindi patayin yung mga civilians. So nag-focus siya doon sa word na neutralization at sabi niya, hindi ibig sabihin niya na patayin yung mga civilians without due process. Kasi doon mismo sa dokumento, merong nakalagay na susundin ng kapulisan yung human rights, no? So ang theory dito ni Attorney Kaufman, ganito, no? Kung meron mang pagpatay na illegal, hindi ito malilink doon sa dokumento mismo, kundi meron mga scalawags, no? Merong hindi sumusunod, deviation from policy. And you cannot blame that on the president. Yun ang sinasabi niya.
Attorney, balikan ko lamang itong punto na to sa dokumento. No? Ang pinupunto pa ni Attorney Kaufman, hindi naman daw ito kautusan na atakihin ang general population, bagkus atakihin ang mga pinaghihinalaang kriminal. So what is he trying to establish or accomplish by arguing this?
Well, sinasabi niya kasi, yung kasing crimes against humanity, ano, yung isang elemento doon, targeting civilians as a policy.
Okay.
Sabi niya, parang preposterous yung sinasabi ng prosecution na yung buong Pilipinas yung inaatake, ano, ng policy ng dating pangulo. Hindi ganyan, no? At in fact, doon sa as the policy is worded, sabi niya may discretion yung mga mag-i-implement. At yung exercise ng discretion na yun, hindi mo yun pwedeng sabihin na si Presidente Duterte pa rin na may kasalanan. So, sinasabi niya essentially na well, kung mayroon mga gumawa ng mali, no, o mali yung exercise ng discretion, hindi si Presidente yun, kundi nag-implement in violation of the policy. Yun ang depensa niya, no? And that is actually what was done in the case of Bagbo, ano? Dahil walang written policy, pero ang sinasabi ng Bagbo, yung mga generalized killings, no? Hindi ibig sabihin na dahil maraming pagpatay ay directed yung pagpatay. Kasi sabi sa Bagbo ng korte, wala namang ebidensya na talagang merong common control, may joint implementation, merong indirect co-perpetration circle of people. Dahil nga sa walang koneksyon na nakita yung korte doon sa mga pronouncements ni Laurent Gbagbo at yung mga pagpatay na sumunod.
Professor, sa punto po bang ito, mahalaga po ba na magpasok na ng aktwal o bagong ebidensya ang depensa kasabay ng kanilang pagkontra sa mga naging unang pahayag ng prosecution? No? I mean, kasi at this point, diba, rebuttal ang nakikita natin. Paano ba yan titimbangin ng mga hukom ng ICC?
Well, kasi of course, no, napakarami ng mga ebidensya na sinabit yung prosecution at yung depensa dito. Nakita lang natin yung summation, yung main outcomes, no, ng kanilang dokumento. So nakita natin kanina yung contextual arguments ni Attorney Kaufman. Sinasabi niya, taken out of context yung mga statements ni Duterte. At kahit yung ebidensya mismo ng mga prosecution, yung mga cooperating criminal witnesses, ano, or yung sa atin yung mga insider witness, yung mga statements ng mga insider witness ay tend to tell us that, you know, the operations were really proper. Na kaya lang sila gumante kasi tinutukan sila ng baril. Yun yung mga ebidensya, mga selected pieces of evidence na pinakita ng prosecutor, ano, ng depensa rather, no. Makikita natin, no, na yung mga standard na defenses ay ginamit naman ni Attorney Kaufman dito sa kanyang initial presentation.
Kasi nga po, ang sinasabi ni Attorney Kaufman, yung mga naging pahayag ni former President Duterte, hindi naman daw ito utos na magpatay, kundi utos na gamitin ng anumang kailangan gamitin para depensahan ng sarili kapag mag-aaresto ng mga umano'y drug pusher. So, kayo po, paano nyo titimbangin yung ganito? Kasi parang ano siya parang very subject to interpretation. He said, she said, parang ganon.
Well, actually, he was addressing two other alternative modes of liability. Nakikita, ang madalas kasing nire-report dito sa atin, yung unang principal mode of liability, yung indirect co-perpetration. Actually, may dalawa pang alternative modes of liability dito na kasama sa charge sheet. Ano? Yung isa is yung ordering or inducing at yung pangalawa ay yung aiding and abetting. No? Yung ordering or inducing, walang common plan pero nag-utos siya at yung utos niya ay nagbunsod ng pagkamatay ng mga tao na illegal. Yung inducing naman, alam niya na merong kasama siya na gumagawa ng krimen, nagbigay siya ng tulong. So itong dalawang alternative modes of liability actually are accessory crimes. No? Hindi siya dito principal author or designer. No? Kung hindi, accessory lang siya. No? Nevertheless, yung range of penalties, if proven to have happened, will still be the same as the principal crime under the rules. So yun actually yung sinasabi dito ni Attorney Kaufman na well, meron kayong alternative na arguments, pero kahit yun, wala kayong direct evidence. No? Actually, yun din, no? Kasi hindi natin alam yung mga complete na data. Hindi natin makikita dito. Napakarami. No? Pero I think, halimbawa, doon sa policy, no? I think the prosecutor can address with the fact that, you know, all those 6,000, yung sa human rights argument, 6,000 plus official deaths arising from the Tokhang, no, na supposedly nanlaban. Now under the manual operations of the PNP from 2013, which was active, which was live when Bato de la Rosa was PNP chief. Sinasabi doon na tuwing may mamamatay sa police operation, dapat dadaan ng inquest yan. Meaning, i-inquest ng DOJ yan para patunayan na walang irregularidad na nangyari sa pagpatay, walang foul play. Ano? Ngayon, pag titingnan natin, dahil may kaso niya sa Korte Suprema, no, ay yung unang writ of amparo case against the drug war, ni isa walang maipakita yung PNP, no? Na report ng inquest. Ano ibig sabihin niyan? Well, sasabihin ng prosecutor, nakita natin na meron kasing inner circle. Yung mga tao ni Duterte nung siya ay nasa Davao, inappoint niya ngayon sa mga mahalagang ahensya ng pamahalaan. Kasama yung DOJ. Sino yung dapat gumagawa ng inquest? Yung DOJ. Bakit wala kahit isang report sa 6,000 pagpatay?
Attorney, para i-reinforce ang kanyang point dun sa pag-question sa causal link between the president's statement or former president's statements and the murders, sinabi ni Attorney Kaufman, wala daw ni isang witness na naipakita ang prosecution na in-order siya o inutusan siya and he actually went out and killed someone. Kailangan po ba ganun ka-direct, ganun ka-literal ang ma-establish na causality para maipin sa dating Pangulo ang liability?
Yung point na I think doon yun sa second mode of liability, yung ordering.
Yes.
No? Pero doon sa indirect co-perpetration, hindi naman kailangan merong direct, no? Kailangan lang ipakita na meron isang grupo, merong common plan, merong joint control, merong criminal intent, no? At merong essential role ang Pangulo doon sa joint commission of the crime na yon, no? And in this case, according to the prosecutor, meron talaga kasi may inner circle, meron silang policy. Kung ano yung ginawa sa Davao, nireplicate lang yun in a grander scale pagdating sa naging presidente ng Pangulo, nationwide na siya, at yung mga taong kasama niya doon sa Davao, in-appoint niya sa key law enforcement agencies to ensure the implementation, no, using state machinery to implement the alleged murderous policy.
At saka it has been widely reported, Attorney, na yung mga nagpakilalang dating DDS, sina Matobato, sina Las Cañas, hindi ho ba ang claim nila ay tumanggap sila ng direct orders mula sa dating Pangulo to carry out the killings?
Tama po yan. No? But right now kasi, no, at this stage, it's very rare really that the pretrial chamber will allow the presentation of a live witness, no.
Okay.
Mangyayari doon sa trial talaga.
trial
Pero
na.
dito puro dokumento pa lang. So hindi pa po natin talagang unless magkaroon ng exception. Pero wala naman tayong nakitang order at request the part of the prosecutor to present a live witness, no. So hindi talaga ginagawa yan dito sa stage na to ng pre-trial.
Okay.
At Professor, nabanggit ni Attorney Kaufman na parang isa sa mga pinunto niya, bakit daw tumagal o bakit naghintay ng 4 na taon bago inimbestigahan? Why did it take the ICC 4 years after President Duterte pulled out before actually investigating? Sa tingin niyo po ba may merito ang ganitong klaseng argumento o pagpunto ng depensa?
Mukhang jurisdiction pa rin ang tinutumbok nila dito,
Jurisdiction yan.
Yes.
As I said kanina, pwede niya namang iulitin yun. Ano? Kasi pag na-address na yun ng pretrial chamber earlier, no, sinabi na wala tapos na yan, no? Kasi malinaw naman na yung ibig sabihin ng judicial proceedings kasama yung gawa ng prosecutor, ano. At yung time element kasi yun ang sinabi ng minority view doon sa appeals chamber decision na nagsabi na may jurisdiction, ano. So inulit na lang yun. Pero actually pag tingnan natin yung practice ng ICC, minsan yung kaso ng Afghanistan 15 years na, no, hindi pa tapos yung preliminary examination, tapos nagkaroon ng PI, tapos na-suspend, ano. So matagal talaga based kasi nga yan sa mga ebidensyang available, no. Pero ngayon mas malinaw na kasi nagkaroon ng mga maliwakang reforma, no, pagdating sa timeline. So kagaya nito, alam natin 60 days merong period na binigay yung rules ng procedure ngayon ng ICC. Dan dapat after this pre-trial proceeding, within 60 days meron ng ruling on the confirmation of charges. But nevertheless, you know, it really takes time because this is the nature of an international kind of proceeding, very complex kasi yung
Pero kasi nga po, 'di ba, parang sinasabi na nga po na eto nga nagkaroon na nga ng ruling on jurisdiction kasi nga pinayagan nga na umabot pa dito sa pre-trial chamber. Pero yung the fact na paulit-ulit siyang binabanggit ng defense even with previous rulings. Strategy na lang po ba ito para at least in the mind of the public parang isipin nila parang may punto ba ito or hindi?
Well, aside from that, no, as a lawyer myself, no, you try your best to actually put into the record your objection on jurisdiction from the very beginning. Kasi it's part of legal strategy to show that you've always been a persistent objector to the claim that court had acquired jurisdiction over your client, ano? At consistent yan kasi meron silang pending appeal, no, sa appeals chamber on that very question from the pre-trial chamber order dismissing their motion to dismiss on the ground of lack of jurisdiction. So it's actually the defense being consistent with the argument.
Attorney, pati yung common plan, kinwestiyon ni Attorney Kaufman. Ano bang tinutumbok niya dito?
Yun nga, no? Kasi ang teorya ng prosecution mula sa Davao na export sa Manila, yung mga personalities na katuwang niya sa Davao, naging PNP chief, naging PDEA chief,
Yes.
naging DOJ chief. Ano? At kaya naging madali yung implementation. At kung hindi naman siya naging presidente, wala ding ganung klaseng drug war. No? Yun yung common plan doon. At sabi ng prosecutor, well, may written policy, yun yung circular na in-issue ng PNP. And in fact, hindi lang yan, no? May dalawa. Tapos yung Malacanang din, nag-issue din ng administrative order suspending the if you recall, to suspend the implementation of double barrel because of the Kian de los Santos killing. At pagkatapos ay binalik yun, reloaded na. So may mga written policies, but the principal one really here is the Oplan double barrel memorandum circular.
Tapos ang sinasabi niya, hindi nga daw, parang malabo naman daw na makakapagpresenta sila ng patunay na nag-meeting itong mga tinatawag na co-perpetrators para pag-usapan itong common plan. Is that even required?
Hindi naman. Ano? Kasi yun nga, maraming maaring, pwede kasi magkaroon ng inferences. Inferences at saka based on the actions carried out by the key personalities. And what goes well, at least at this point in time, because this is not yet a process requiring proof beyond reasonable doubt, for the prosecution, pinakita nila na meron talagang written policy na kakaiba. And this is unique kasi may written policy matching that with the pronouncement of the president, and then there's statistics, the scientific study showing the distribution of killings, that these are not random killings.
Yes.
There's a pattern to the killings, and the pattern shows that this is pursuant to the written policy.
Professor, kasi ilang beses rin binanggit ni Attorney Kaufman na parang kung ano man ang mga speech or pahayag na sinabi ng prosecution or sinight ng prosecution, meron din naman silang maipapakita ng mga naging pahayag ni dating Pangulong Duterte na pangontra din daw doon. So parang kumbaga pagdating doon sa mga naging statements ni Pangulong Rodrigo Duterte, meron daw silang pangontra doon. Pero kung titimbangin po yung mga naging statement ni Pangulong Rodrigo Duterte versus kung ano man ang sasabihin or ano mang naging pahayag ng mga testigo, alin po ba doon ang mas bibigyang diin ng korte?
Well, kung titingnan natin yung standards, yung preponderance of evidence, which is equivalent to a strong indicia of guilt, that if not rebutted could lead to a conviction, na mas marami yung mga statements ng Pangulo all those 6 years. If you correlate that with what happened the next, yung one time, big time, and I think it's very difficult actually to say that that was not the intention of the president, and he, in fact, campaign promised na there's going to be bloodshed. And the prosecution actually had a theory for that, na inatake ni Attorney Kaufman, sabi niya, merong parang dalawang anyo yung presidente, yung kaliwa niyang mukha, sasabing hindi, yung pangkanang mukha, bahagi na kanyang labi ay nagsasabi ng oo, Yun yung sinasabi ng prosecutor na sasabihin niya na legal pero babawiin niya rin, and that is consistent across all of the statements made by the president, and I think that the scientific studies will really go into that, yung patterns ng killings, yung scope ng killings, sino yung mga pinatay, mahalaga yun, And plus, of course, the one that I pointed out, that the very requirements of the PNP itself with respect to deaths arising from a police operation, no? Requirement yun na magkaroon ng inquest. Pwede mong i-excuse siguro yung 10 or 50 na walang reports. Pero 6,000 plus walang reports kahit isang maipakita yung PNP, well, that tells you something, no? And that should go into the argument of the prosecution in their submissions to the court.
Attorney, nabanggit nyo kanina, binigyang diin ng prosecution yung word na neutralize, to mean kill.
Exactly.
Ito ho, si Attorney Kaufman, ang sinasabi niya, ang neutralize ay euphemism. Hindi siya exactly equivalent to kill.
Patay. Well, alam niyo, naging beat reporter din tayo ng matagal at sa mga police reports.
Yes.
Pag sinabing neutralize, patay talaga yan. Di ba?
Correct.
Sa joint operation reports,
Yes.
pag sinabing neutralize, patay yan. So I think there should be some documentary submissions on the part of the prosecution on the meaning of neutralize in police reports.
Professor, balikan ko lang po yung naging tanong ko kanina kasi nga ang narinig natin, rebuttal pa lang so far, di ba? At ang inaasahan natin kasi, parang ang intindi natin kapag submission of merits, meron ka rin ipipresenta na bagong ebidensya. Aasahan ba natin na pagkatapos itong break na ito sa pagbabalik ng depensa, meron pa silang mga ibang ipipresenta or pwede bang ipagpatuloy lang nila hanggang bukas na puro rebuttal lang at okay lang yun?
Well, dapat meron pa kasi binigyan sila ng panahon na ngayon para sa kanila, no? I would expect that there should be more on the other details kasi ano pala ang natalakay dito, yung elements of the crime, yung mga statements ng pangulo. So meron pa dun sa dapat kasi detalyado yung presentation ng prosecution dun sa individual cases, So kailangan kasi sabihin ng prosecutor na yung mga pagpatay na yun ay walang pattern yun, no? Na there's no yung individual na examples, yung non-exhaustive list or representative cases na pinakita na ng prosecutor. Kailangan ipakita yun ng depensa na well, these are really random and these are not pursuant to a policy, but if at all, sinabi niya na kanina, nanlaban, self-defense, puro self-defense, or deviation from policy by scalawags who wanted to embarrass the president. Remember, during the time, Senator De La Rosa, when he was PNP chief, was talking about ninja cops also. No? So, siguro, dadating sila dun sa punto na yun, papakita nila na kung meron mang pagpatay na illegal, hindi sa amin yan. Kung hindi, may mga scalawags. And in fact, we prosecuted them. I guess they should talk to that on that point with respect to the Kian de los Santos plus the other a handful of prosecutions dealing with foot soldiers rather than the brains of the policy.
Attorney, lihis muna ako sa mga specific points na ni-raise ni Attorney Kaufman at dumako saglit dito sa kanyang style. He is quite the speaker, he's quite the debater.
Yeah.
Sa mga ganito mga proceedings, gaano kahalaga na magaling magsalita, convincing, passionate ang abogado ng either prosecution or defense? Kasi hindi naman ito jury system, hindi naman jury yung magde-decide ng kaso.
Hindi po. Mahalaga po kasi yung rhetoric dito kasi yung International Criminal Court is a mix of civil and common law, Yung common law part, yung advocacy talaga. And si Attorney Kaufman is one who was really raised in the adversarial tradition, like the Philippines,
Yeah.
Na may adversarial tradition tayo. In fact, yung binanggit niya, I think he's on leave right now, si Karim Khan. He was noted as a defense counsel. Before he was appointed as a prosecutor, the head of the prosecutor, Karim Khan was well respected because he had won quite a few cases,
Okay.
not a few cases, as a defense counsel. So magkakilala sila dyan. At people really held in high regard Karim Khan as a very able lawyer, as a defense counsel. So this is actually the first time we're seeing that live here, right? Napapanood lang natin yan sa mga palabas.
Sa pelikula ko na napapanood to sa mga series.
Yeah, di ba?
Mga legal
Where
drama,
rhetoric is really important, And that's why it's also wrong to compare it to a jury, because the judges are not the jury, and the judges are trained lawyers. So when you say that, they tend to be, they might be influenced by the persuasion
Yes.
Oh, I don't think that goes into the heart of it, because in the first place, the judges here are trained. They're not ordinary citizens as in a jury.
Oo. So hindi sila basta-basta
Should be-
hindi sila basta-basta madadala sa galing ng pananalita.
po. Pero yun nga, no, makikita natin may konting insulto, no, na swak. Mga ganun talaga, no? In any British court, you will encounter those kinds of rhetorical strategies of lawyers.
In fact, nung day one nga, natanong ni Pia kay Dean Pangalangan, sino bang kausap talaga ni Kaufman? Parang nag-a-appeal siya to the Duterte supporters dahil yung kanyang paraan ng pananalita at mga argumentong kanyang pinalutang.
Tama po yun. No? And I don't think that politics can be discounted here, because in the Philippines, this trial is also connected to a lot of things in the Philippine political realm. No? 2020 it is just around the corner, and the results of the elections might also influence how things will turn out. No? So, kaya importante din talaga para sa tingin ko, para kay Attorney Kaufman na i-address yung malaking constituency na yan ng dating Pangulo.
Tingin niyo po ba, Professor Romel, kapag nahahaluan ng politika ang mga argumento, either ng prosecution or ng depensa, nakakatulong po ba ito sa kanilang kaso? I mean, at least in terms of yung sa pagtanggap nito ng judges. Kasi syempre iba pag sa publiko eh.
Well, sa international legal processes, hindi talaga may iwasan. In fact, marami tayong kaso. Sa ICJ, that was raised, no? Has been raised in a few cases. At sabi lang ng mga international tribunals, possible na mayroong political angle, but the most important thing is that even if there's a political angle to it, there is also a legal angle. And our focus will be on the legal question. So we can set aside the politics, but that's really for the counsel to do, no? But the court will say, in the ICJ, we have several cases dealing with that. The WHO advisory opinion and such, leading cases, no? Sinabi ng ICJ, International Court of Justice doon, now, whether or not there is a political reason for these actions, it's beside the point. What is important for us is that there is a legal question. And our ruling will address the legal question, not the political one.
Sa puntong ito, Professor, kasi syempre pre-trial pa lamang po ito, no? Hindi pa siya yung aktual na paglilitis kasi hindi pa natin alam kung matutuloy nga siya sa paglilitis. Pero kayo po sa inyong karanasan, dapat po ba lahat ng pinakamabibigat na ebidensya nilalabas na dito? Or dapat ba meron kang ititira pa sakali nga umabot sa aktual na paglilitis?
Well, nasa strategy naman yan. No? At alam naman ng mga prosecutor yan na yung kailangan lang natin dito is substantial grounds. Hindi pa proof beyond reasonable doubt. And besides, as I've been saying, actually, wala naman ditong ebidensya na maitatago. Kasi yung ICC, pagkakaiba niya sa ibang korte kagaya sa Pilipinas, merong doctrine of equality of arms. Ibig sabihin, kung ano yung ebidensya na meron yung prosecutor, kailangan may access yung depensa dyan. Even, especially evidence that will tend to exculpate from liability a defendant or an accused. It's a mandatory requirement for the prosecution. Ganun din sa depensa. Kung meron siyang ebidensya, hawak nila, ano man yun, kailangan available din yun sa prosecution.
So unique ito sa ICC, Prof, no?
Yes, equality of arms tawag dyan, doctrine of equality of arms. Sa Pilipinas, hindi po ganun. No? Pwede yung
Taguan ng
prosecutor
ebidensya
Oo
yan,
nga,
di
so
ba?
walang gulatan. Wala
Itago
palang
mong
gulatan
ebidensya
dyan.
mo kasi, di ba? Keep it close to your chest.
Although, the court has tried to limit that possibility now because of the new rules, no? Pero generally, don't really have that rule. No? Walang express rule on doctrine of equality of arms in domestic courts. That's a standard that you will find observed strictly by the International Criminal Court.
Okay.
Attorney, bago magsimula itong day 3 ng confirmation of charges hearing, nagkaroon ng allegation na yung mga ICC investigators daw ay pinondohan ng certain political personalities at naglabas nga po ng pahayag yung Office of the Prosecutor, itinatang yung allegation. Ito hong mga ganitong developments, I don't know, can we call them noise surrounding the hearing? May effect ba ito at all?
I think what we're seeing here is an attempt to sully the legitimacy of the proceedings. Pero alam mo, yung Rome Statute, meron din yung rules dealing with that, yung obstruction or violation or an attempt to tamper with the administration of justice. No? Nasa Rome Statute. pwedeng magkaroon ng sanctions ang International Criminal Court dyan, ano?
Sanctions against who?
Against the perpetrators, ano?
Okay.
Pwedeng magkaroon ng ganyan, no? Na magkakaroon ng reklamo, no? Kung magkaroon ng formal na complaint. But I don't think that will actually affect in any way the conduct of the proceedings, in a sense that, you know, the court will stop the proceedings, no? Because of that, no? Besides, the court is really very zealous of its independence, no? As we have seen with the response of the courts, no? But also, you know, look at the kinds of allegations being thrown at it, no? Yung credibility ng mga allegations na yun, dapat tinitingnan din natin kung meron pa talagang basehan. So, it's shot through with contradictions and such, no?
Professor, bago po tayo nag-umpisa kanina, nag-report po, nag-ulat yung aming kasamahan na si Marisol Abdurrahman at sabi nga niya na syempre yung ibang mga kaanak ng mga biktima naroon, no? Kinakabahan sila kasi first time nilang maririnig kung anong sasabihin ng depensa. Tingin niyo po ba parang tamang estratehiya po ba yon na pagdating sa submission of merits ng depensa na naroon pa rin yung mismong mga kaanak ng mga biktima? Or tingin niyo po ba dapat minsan ipinagpapaliban na lang at iniiwan doon sa mga kanilang abogado na lang na sila ang makinig? Kasi syempre baka maapektuhan din sila sa pakikinig.
Alam po ninyo, sa teorya ng katarungan, no? Actually, it's part of giving justice to victims by actually allowing them to have access.
Okay.
No? Isipin po natin, nasa dahig po yan. At napakamahal ito para pumunta doon. At kaya nga po, meron pong office ng Common Legal Representative for Victims, di ba? Kasi disenyo yan na makikita natin sa ICC lamang. Merong specific na office that takes care of the interest of the victims. No? Dito actually, hindi po sila litigants. No? They are participants, but they are not strictly speaking parties. And that's why they need to have a separate lawyer. And the lawyers, the Filipino lawyers plus the one that heads that belongs to the office of Common Legal Representative, they don't get to decide what strategy will be used by the prosecutor or whether or not new evidence will be presented or whether or not the charge sheet will be amended. Hindi po yung pwedeng gawin ng mga victims, lawyers, ano? Pero pwede silang mag-submit ng questions with leave of court, no? On a witness, for instance. Pwede rin po silang mag-submit ng observations pagdating po dun sa protection ng rights and all that. No? That's why you see Attorney Butuin, Attorney Andres talking on behalf of victims, because that's part of the design of the ICC, that the victims are really given a voice. They only become proper parties pagdating po dun sa question ng reparations. Kasi may personal interest po sila doon, yung injury na personal sa kanila. Didinggin po ng korte yan pagdating doon sa reparation. So doon lang po sila properly parties. Hindi po sila litigants talaga in that sense. No? Iba po yung disenyo ng ICC for that question.
Minsan kasi 'di ba parang may tendency na makalimutan natin na iba talaga yung takbo pagdating sa international court. Kasi ang nakikita lang natin, ang nakasanayan natin local courts, 'di ba? Parang dalawa lang yung partido, meron ka lang depensa, meron kang prosecution, meron yung biktima, meron yung suspect o yung nililitis, yung akusado. So, I guess kailangan importante na tandaan natin na iba yung takbo dito pagdating sa international courtroom.
Tama po, ano.
Attorney, yung latest pa, yung pinayagan ng korte ang dating Pangulo na hindi dumalo sa kanyang hearing on detention. Bukas, I think this is scheduled tomorrow. Tanong ko lang, how is it in the defense's advantage ang hindi pagdalo ng dating Pangulo?
Well, di ba, theory nila, walang jurisdiction yung korte. Na illegal, walang legitimacy in the whole proceeding.
So it's a statement, kumbaga.
It's really consistent with that approach. That they don't in any case recognize the legality and validity of the whole process. And that should supposed to be important because there's a rule in the ICC that you have to revisit every year.
Yes.
The question of whether it's still proper to hold someone in detention, someone who's facing a proceeding, no? So requirement yan, nakalagay sa rules yan, kaya every year. And, you know, I guess that's also their way of saying na we don't really recognize the jurisdiction of the ICC. And besides, you know, I'm being held against my my wish, my volition. And in fact, I was not properly taken to court. I was kidnapped.
Yes.
So whatever you say there, wala naman talagang masasabi kayong maayos dyan dahil in the first place, kinidnap ako.
Tapos, hindi ho kaya, may posible din na ang sinasabi ho kasi ng depensa, the president is frail and weak and incapable of standing trial. Pero sinasabi ng ICC experts, he is fit to stand trial. Hindi ho kaya parang pag hinarap mo sa paglilitis ng dating Pangulo, malalaman ng lahat na he is actually capable.
I think sa issue na yun, hindi kasama yun, no? Yun lang legal basis for holding him in detention.
Okay.
No? But there's a separate rule where the court can always monitor of course, after 2 years, the defense can say, well, this was the situation 2 years ago, but right now I think that you have to look at the evidence. And the court can once again revisit that question of the fitness of the former president to stand trial. Because it goes into the principle of due process.
Well, Professor, siguro 2 minuto na lang at mag-uumpisa na ulit yung pagdinig. Ano po expectations nyo dito sa ikalawang bahagi ng pagdinig?
Well, yun nga, sabi ko kanina, detailed, no? And I expect the defense to now attack the individual cases to show that these are not part of a pattern killing, nor are they related to policy.
So, kumbaga, iisa-isahin na dapat.
Ayun dapat yun.
Alright. So, titignan natin kung yan ang actually na magagawa nila. Kasi nga, so far, puro rebuttal pa lang ang naririnig natin. So, even kayo po, Professor, talagang inaabangan nyo na kung ano yung mismong maisusumiti pa nila. Maidadagdag pa.
At nire-rebut individual prosecutors.
Oo.
Sinabi ni ganito prosecutor, ganito, but it's not true or hindi consistent. Anyway, abangan natin kung magkakaroon nga ng direct i-refute isa-isa, individually, yung mga individual cases na binanggit ng prosecution.
Alright.
Prof, babalikan po namin kayo mamaya. Thank you very much.
President, Your Honours, before the break, we were discussing Command Circular number 16 of 2016 and the issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. This directive instructed investigative units on how to perform their responsibilities in the case of armed confrontation during the implementation of Operation Double Barrel. The document also included an exhortation to monitor human rights violations perpetrated by PNP operating units. The term neutralization itself is, of course, not defined anywhere in any of these documents as meaning to kill, a point the prosecution itself conceded at that moment in time when it was seeking the opening of an investigation. And I refer, Your Honours, to ICC 01 on 21, document number 7. So, the prosecution, throughout its pre-confirmation brief, invites this chamber to find, by inference, that neutralization means murder, and even carves it in stone as its formal statement of the common plan. But we, the defence, can show that the term neutralization can only mean the use of self-defence where officers' lives are endangered. For this, the text of the circular must be read in the context of the governing framework and other PNP directives. It is our submission that across the political, legislative, judicial and law enforcement contexts, the consistent articulation has always been that neutralization denotes lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald de la Rosa, Bato, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, De La Rosa, testifying before the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which De La Rosa referred, which incidentally was published in 2021. Neutralization, and I quote, "A police intervention in strict accord with the use of force continuum and/or principle of proportionality on the use of force purposely to contain or stop the unlawful aggression of the offender. This may include an arrest, capture, surrender, or other acts to subdue the suspect." It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this. It was aware of De La Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which De La Rosa was referring. In fact, we know that they didn't, because it's not on their list of evidence. Within the judicial sphere, when the terminology was examined before the Supreme Court of the Philippines, in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill. The Supreme Court of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The Court observed that the wording was neither novel nor introduced during the Duterte administration. It had already appeared, for example, in the 2014 revised PNP Manual on Anti-Illegal Drugs Operations and Investigation. In other words, the term formed part of the existing police vocabulary. The Court further clarified that the mere inclusion of the term in a circular does not render that instrument unconstitutional, especially where the circular expressly mandates compliance with internationally accepted legal principles, public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis, nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill. The judicial record does not sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework, the prosecution's witnesses no less, are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill. Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
Maître, je suis désolée de vous en...
I'm sorry to interrupt, counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
if I may, Madam President,
Merci beaucoup,
of course,
Thank you very much.
an understanding with the Learned Chamber's legal officers that we would be able to provide references after the hearing. But of course, the document that I was referring to is PHL OTP 00090518-R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16 of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue. The fifth indicator of a common criminal plan, as alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald De La Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with De La Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts, to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, "if you resist." That's PHL OTP 0000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 00090340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone. And God forbid we're not alleging that Aguirre did anything wrong. Especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4. And I read out the relevant passage which is highlighted once again. They are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated, and even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit, he excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal. Turning to the sixth indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief. None of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality. I would suggest that it is within the bounds of acceptable, albeit extreme political discourse to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. You can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed indicator of criminality, which is based on the names created for the two police operations Double Barrel and Tokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte. But this does not indicate a meeting of minds, as I will elaborate shortly. The eighth factor, purportedly evincing a plan of agreed criminality, is set out and coming to the ninth category of circumstantial proof for a common criminal plan. The prosecution relies on what it believes to be the Duterte's administration's unabashed publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published. In two government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft so helpfully pointed out in her presentation, and are not insubstantial, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations had been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen involved in the murder of Carl Arnaiz, who were later convicted and sentenced to life imprisonment. These policemen were affiliated with the Caloocan City Police Station, and where, so the report mentions, 1,000 personnel belonging to that station were sent for retraining. To conclude, this document, far from being evidence of a conspiracy hatched between co-perpetrators, is in fact a testament to the Duterte administration's respect for the rule of law and written proof of its intolerance for rotten apple police officers. As for the second official publication, which is supposed to substantiate the criminal plan, we turn to the 2016 annual report issued by the Philippine National Police. The statistics are quoted, with all respect, in a misleading fashion. The tables used by De La Rosa, and particularly the pie chart, show a remarkably low incidence of deaths in comparison to arrests and voluntary surrenders. Obviously, the misleading aspect of that is the prosecution's representation of the statistics, not De La Rosa's. So, coming to the 10th and final source of circumstantial evidence, supposedly supporting the mutually agreed nature of the criminal plan. And this is the fact that the extrajudicial killings, to quote the prosecution's words, followed the same patterns and modus operandi, with the perpetrators covering their tracks. But here, let me ask a question which begs an answer. If the Duterte administration was so barefaced as to openly declare its intent to kill drug users and pushers and celebrate this, as the prosecution argues, in official governmental publications, why would it encourage the perpetrators to go to such lengths to disguise such an intent? I mean, of course, anything's possible. But I'm just pointing out the internal contradiction in the prosecution's case theory. In any event, as they say in English, there is more than one way to skin a cat. And the differing types of modus operandi that we have encountered in the prosecution's 49 incidents of murder involve all conceivable modes of butchery, ranging from strangulation, suffocation, to stabbing and shooting. Now, assuming that the prosecution can overcome the hurdle of proving the existence of a common criminal plan, how has it shown that the so-called co-perpetrators coordinated between themselves to reach a mutual agreement to execute it? Well, it hasn't. All it can do is show a selection of comments made by Mr. Duterte's closest colleagues in government, and all of which take their rhetorical cue from him. The prosecution then artificially defines the intended individuals, the identified individuals, as a collective of co-perpetrators. Now, common law jurisdictions, such as the one I come from, are familiar with these issues in the context of the law of conspiracy. The federal rules in the United States, for example, allow the statements of co-perpetrators to be used as circumstantial evidence, one against the other, to establish the existence of a conspiracy, but require that these statements be made during and in furtherance thereof. Narrative venting, which is what all these supposed co-perpetrators did, the ones identified by the prosecution, does not further the criminal objective. In furtherance thereof means that the statement relied on must advance the objectives of the conspiracy, such as through reassurances, updates, or actions taken to avoid detection. Now, I do realize, Your Honours, that there isn't too much jurisprudence on this matter, but let us look at it logically. Where can one really draw the line if it is sufficient to infer a mutual agreement to execute a criminal plan if we rely only on the statements of the people in the vicinity of a criminally verbose suspect because of the same quality of verbosity it alleges? This is what could be called bootstrapping logic, building on limited information with the very same information in an attempt to validate that information or to create a structure there without. Put simply, the prosecution has advanced its cart before its horse. It has merely selected a number of individuals working alongside the former president who made similarly offensive comments and has then called them co-perpetrators. Instead of seeking evidence which might shed light on the interactions of these individuals between one and another, and construing a criminal conspiracy therefrom, should the evidence even support such a hypothesis, the prosecution has taken its preconceived and predetermined premise of a criminal plan and forcibly superimposed it on these individuals. The artifice of the prosecution's working methodology in conjuring up this criminal collusion becomes even more apparent if we examine the evidence.
Magandang hapon po. Huling araw na ng confirmation of charges hearing ng International Criminal Court Pretrial Chamber 1 kaugnay ng kinakaharap na crimes against humanity ni dating Pangulong Rodrigo Duterte.
Buong pwersa pa rin ihahatid ng GMA Integrated News ang pinakabagong balita kaugnay ng pagdinig mula sa The Hague, Netherlands.
Ako po si Pia Arcangel.
At ako po si Ivan Mayrina. Ito ang Duterte sa ICC, special coverage ng GMA Integrated News.
At huling araw na
Go
nga
ahead.
po ng pagdinig at inaasahang itutuloy ng depensa ang paglalatag ng kanilang mga argumento.
Nakatakda rin magbigay ng closing remarks ang prosecution, common legal representative sa mga biktima at ang depensa. Ngayong araw din isasagawa ang pagdinig para sa review of detention ni dating Pangulong Rodrigo Duterte.
Kuha po tayo ng live update mula sa The Hague sa The Netherlands at naroon ngayon si Marisol Abduraman. Marisol?
Pia, pasado alas 9 na ay tama pa yung oras natin, no? Hindi na natin na-monitor, pero yun nga, no, itong ang huling araw, although the fourth day, ng pagpapatuloy ng pagdinig dito sa confirmation of charges ni dating Pangulong Rodrigo Duterte. Napag-usapan ninyo ni Ivan kung anong mga inaasahan natin ngayong araw. Ito rin ang binanggit sa atin ni Attorney Nicholas Kaufman na meron daw siyang 1 oras ngayon para magsumiti ng kanyang mga final merits bago ang kanyang mga closing statements. So aabangan talaga natin lahat yan. At isang mahalagang bagay din na kailangan din nating abangan ngayon, ito yung pagpapatuloy pa rin nga doon sa hearing ng kanyang continued detention dito sa ICC, at inaasahan, base sa impormasyon na binigay sa atin ni Attorney Cristina Conti, in an hour lang daw ay meron na kaagad parang somewhat decision or resolution ang korte hinggil doon sa kanilang magiging sagot kung magpapatuloy nga ba ang pag-detain dito sa dating Pangulo. At kagabi, mabanggit lang natin, Pia Evan, matapos ang third hearing dito sa ICC ay dumalo sa isang misa, nagpamisa ang mga kaanak ng mga biktima kasama ang ilang grupo na sumusuporta sa kanila at nagsagawa rin sila ng candle lighting para ituloy sa pagpapatuloy ng kanilang panawagan sa mga biktima ng di umano'y extrajudicial killings. Sa panayam natin sa ilang kaanak ng mga biktima, mas kampante na raw ang kanilang pakiramdam ngayon, although palagi naman nila itong sinasabi, pero sabi nga nung mother na yung lang daw na napakulong nila ang dating Pangulo that they never imagined it would happen, para sa kanila isa na raw itong hustisya. Pero syempre hindi raw dito nagtatapos ang kanilang panawagan dahil gusto pa rin daw talagang managot ang mga dapat managot doon nga sa pagpatay sa kanilang mga kaanak at sa iba pa na pinaniniwalaan nga na naging biktima nitong EJK. So aantabayanan natin itong mga mangyayaring kaganapan at syempre habang nagpapatuloy ang hearing, walang mga aktibidad dito ngayon yung mga kontra Duterte. Meron tayong nakita na ilan kanina na pumasok na rin doon sa public gallery para tunghayan nga itong huling araw ng pagdinig. At sa mga oras na ito, nandito na rin, maaga aksyon na nagsidatingan ang mga taga-suporta naman ng dating Pangulo na maagang nagtipon-tipon dito and we believe magkakaroon sila ng maikling programa ngayong araw. Pia.
Marisol, linawin lang natin kung ano yung magiging takbo ng confirmation of charges hearing sa araw na ito dahil sabi mo nga, ito na yung huling araw. So ipagpapatuloy yung submission of merits ng depensa tapos magkakaroon ulit ng break at pagkatapos ito, closing statements na agad mula sa prosecution at sa depensa. Tama ba yun, Marisol?
Yes, that's right, Pia. Kaya talaga napakahalaga nito. Although ang sinasabi nga, is an hour enough for Attorney Kaufman para mailatag niya? We will try. Titingnan nga daw nila kasi ito rin ang inaaban ng prosecution kasi mukhang parang kukulang daw 1 oras. Pero let's see, Pia, kung anong mangyayari. Pero so far, yung mga binanggit mo, yan ang kailangan nating abangan para sa huling araw ng hearing.
At kahapon, Marisol, nabanggit mo, nagkaroon ka ng pagkakataon na makausap si Attorney Kaufman pagkatapos ng hearing at sabi nga niya, the former president is in good spirits, not necessarily in high spirits, pero sabi niya parang nabibigyan naman daw siya ng update tungkol sa mga kaganapan dun sa mga pagdinig. Anong reaksyon dito ng mga taga-suporta ni Pangulong Duterte?
Unfortunately, Pia, hindi kasi sila nagkaroon ng pagkakataon ng mga taga-suporta na marinig nila ito. Although we understand na ibalita na rin ito natin, we yet have to get the reaction about doon. Pero kahapon, Pia, alam mo, mabanggit lang natin, paglabas pa lamang ng mga kaalyado at mga abogado ng dating Pangulo, ito sina Attorney Delgra, sina dating E.S. Meljaldea, nakita kasi nila na nakangiti. Tapos parang feeling nila it was a good news for them. At sinabi rin naman talaga ni Attorney Salpanelo na yung prosecution was shattered. So halos magpalakpakan sila talagang ngiti dahil para sa kanila good news ang hatid ng mga abogado ng dating Pangulo dahil yun na nga hindi kasi sila nakakanood ng hearing, Pia. So bukod sa kanilang pag-abang sa live streaming, syempre inaabangan din nila ang mga magiging reaksyon naman nito mga Filipino lawyers na nandito ngayon sa ICC para mag-observe nga dito sa hearing. So natuwa sila doon. So I would assume, Pia, na magandang balita rin para sa kanila ang sinabi ni Attorney Kaufman sa atin kahapon na the President is in good spirit at yun nga, palagi naman daw niyang ina-update ang Pangulo sa nangyayari. Kinorek pang hata ni Attorney Kaufman, hindi raw siya in high spirit because how can he be in high spirit na patuloy pa rin naman siyang nakakulong. So, in good spirit lang daw ang Pangulo at yun, kumbaga parang ipinapaubay na raw lahat ng dating Pangulong Rodrigo Duterte sa kanyang defense team ang kahinat na ng kanyang kaso. Bagamat piano, paulit-ulit pa rin nating sinasabi na hindi ito kinikilala ng dating Pangulo. That's the very reason kung bakit nag-waive siya ng kanyang right para dito nga sa hearing ng confirmation of charges. Pia.
Alright, thank you Sola. Si Ivan, meron din mga katanungan.
Sola, isa lang, yung tungkol dun sa hearing on the detention, will that follow immediately after the closing statements?
We don't know exactly, Ivan. I'm sorry kung saan siya i-discuss, ano. Pero sa pagkakaalam natin, batid sa nakuha nating information, yes, sa huli siya after ng mga closing statement. Tapos tinanungan natin how soon can we have the result. Sa impormasyon na binigay sa atin Attorney Conte, in an hour meron daw yan. Kasi kaya isa rin yan sa abangan natin. Hopefully, kasi agad naman silang nag-update yan sa kanilang website. Or baka dito mismo, Ivan, makakuha tayo kaagad directly ng information from ICC kung ano nga ang kanilang ayaw sabihin ni Attorney Conte ang tawagin na desisyon, pero syempre sa atin, para maintindihan na rin ng ating mga kababayan ang magiging desisyon ng pre-trial Chamber 1 hinggil doon nga sa kanilang apela na yan, Ivan.
Alright, looks like we have a long day ahead. Maraming salamat. Babalikan namin dyan, Marisol Abdurrahman. Samantala, kabilang pa sa mga hinimay ng depensa sa Day 3 ng confirmation of charges ang pagpuna ng prosekusyon sa mga talumpati noon ni dating Pangulong Rodrigo Duterte. Ay kay Attorney Kaufman, hindi raw napatunayan ng mga ito ang criminal intent ng dating Pangulo at namimili lang daw ang prosekusyon ng isasama para tumugma sa kanilang naratibo. Kung 20 talumpati raw ang naipresenta ng prosekusyon, 35 naman ang nakita nila na nagpapakita ng paghikayat ni Duterte sa mga alagad ng batas na sumunod sa batas. Wala rin daw patunay na extrajudicial killings ang malawakang patayan mula nung mayor pa si Duterte hanggang sa maging Pangulo, taliwas sa inilabas na mapa ng prosekusyon. Kinontra rin ni Kaufman ang iginigiit ng prosekusyon na ang mga pagpatay ay pinuntirya ang buong populasyon ng Pilipinas. Wala rin daw nakuha ang prosekusyon ng witness na nagsasabing narinig nila mismo si Duterte na nag-utos ng pagpatay kaugnay sa 78 insidenteng tinukoy sa 3 counts ng kaso. Sa loob ng 60 araw, inaasahan maglalabas ng desisyon ng pre-trial Chamber 1 kung itutuloy sa paglilitis ang kaso.
Sa kabila ng mga bira ng defense team ni dating Pangulong Rodrigo Duterte, tiwala naman ang Office of Public Counsel for Victims na sapat ang mga ebidensyang inilatag ng prosekusyon para ituloy sa paglilitis ng kaso.
I think that the prosecution made a very good presentation in relation to all the elements of the crimes, not only in terms of the theory and how to apply the notion of widespread and systematic attack and crimes against humanity, but also at the level of concrete evidence showing a pattern in the killings, showing how Mr. Duterte was implicated in the patterns, showing the policy.
Sa Day 3 ng confirmation of charges hearing kahapon, ilang beses na binasag ng depensa ang mga argumento ng prosekusyon. Git ng lead defense counsel na si Attorney Nicholas Kaufman, nabigo ang prosekusyon na maipakita ang direktang ugnayan na mga itinuturong hitman sa dating Pangulo at sa mga anilay mahinang kalidad ng ebidensya. Tinutulan din ng depensa ang interpretasyon ng prosekusyon sa salitang neutralize, na ang ibig lang daw sabihin ay pag-aresto o pagpigil at hindi pagpatay. Para kay Office of Public Counsel for Victims Head, Paulina Masida, inaasahan na nila ang ganitong estratehiya ng depensa. Tinutulan din daw nila ang puna ng depensa na walang iisa o coordinated criminal plan at maaring rogue acts lang ang ilan sa mga pagpatay.
But these crimes and these killings were certainly not isolated or spontaneous. We are talking of thousands of killings.
In good spirits daw si dating Pangulong Rodrigo Duterte ayon sa kanyang abogado. Sabi ni Attorney Nicholas Kaufman, nakausap niya ang dating Pangulo bago ay 3 araw ng confirmation of charges hearing kahapon. Paglilinaw ni Kaufman, hindi nagmo-monitor si Duterte sa mga pagdinig.
How is he?
I went up to the prison and I told him everything that was going on. I give him a report, of course. I'm counsel and I'm expected to give my client a report of what I'm doing for him. It would be unethical otherwise.
Nang matanong naman tungkol sa naging sagot ng Malacanang sa kanyang mga argumento, tumanggi na siyang sagutin ito.
You've heard my submissions. What I said is what I said.
You have a message to her?
To Claire Castro?
Yes, sir.
Nothing really. You know, if she wants to invite me to Manila, I'd be happy to come and we could discuss the interim release of Mr. Duterte.
Sapat bang ebidensya para sa kasong crimes against humanity laban kay dating Pangulong Rodrigo Duterte para ituloy ang kaso sa isang paglilitis? Yan po ang tanong na layong sagutin ng 4 na araw ng Confirmation of Charges hearing. 3 po ang maaaring maging resulta ng pagdinig. Kung meron pong sapat na ebidensya laban kay Duterte, kukumpirmahin ang kaso at itutuloy ito sa ganap na trial o paglilitis. At bubuo ang presidency of the court ng trial chamber na bubuuin ng 3 hukom na hindi po kasapi ng pre-trial chamber. At kung hindi naman sapat ang ebidensya, tuluyan ang ititigil ang kaso. Pero kung wala pa pong katiyakan, pagpapaliban ang pagdinig at uutusan ng mahukom ang mga taga-usig o yung mga prosecutor na magbigay ng karagdagang ebidensya. Magsasagawa po ng karagdagang investigasyon o kaya'y amyendahin ang kaso kung sa ibang krimen tumuturo ang ebidensya. Kailangan po maglabas ng desisyon ng mga ICC judge sa loob ng 6 na pong araw matapos ang Confirmation of Charges hearing.
At para mas lalo pa nating maintindihan itong isinasagawang Confirmation of Charges hearing, makakasama po natin ngayon, Public International Law Professor at author, alumnus ng Hague Academy of International Law at Dean ng Graduate School of Law ng San Sebastian College, Recoletos, Manila, Dean Rodel Taton. Dean, welcome. Thank you for joining us.
Thank you for inviting me.
Magandang
Thank
hapon,
you.
Dean.
Magandang hapon po sa inyong lahat.
Ang dami natin.
Ang dami natin pag-usapan.
At saka ang dami na rin kasi nating nasubaybayan.
Yes. 3 days worth of arguments. Yan.
So Dean, I guess, umpisahan na natin kasi huling araw na po ito, day 4 of the Confirmation of Charges hearing. Ano po ba yung expected na natin na mangyayari ngayong araw na ito? Kasi ngayon pa lang, sinasabi na ng prosecution, baka kulang yung 1 oras na submission of merits na natitira for the defense to present a solid argument daw.
Yes, exactly. I think kulang yung 1 hour for today. Kasi kahapon parang medyo, ako personally, nakita ko na medyo nakulangan ako sa presentation ng defense. Especially that there are so many items na sinabi ni prosecution on this case. No? But we'll see how they will make use of the time of 1 hour for this closing, not only closing statement, but closing time to present whatever their attacks on the questions doon sa pinaresentan ng prosecution.
Dean, balikan natin yung mga nakarang araw. For the prosecution, do you think overall they did enough para magpresenta ng reasonable evidence or reasonable, sapat na dahilan para tayo ay magpatuloy sa trial?
I think with the elements of the crimes against humanity under the Rome Statute, the prosecution has done its duty, especially that the burden is with them. No? For the past days, ang burden ay nasa prosecution para maipakita yung ang systematic, widespread attack sa civilian population and also in relation to the death, in relation to the war on drugs. No? And for yesterday, the defense presented his direct attack on the allegations of the prosecution on this case, where they basically wanted, the goal there is to, of course, destroy the evidence of the prosecution. No? So, inaisa-isa nila doon, especially on the question on direct personal responsibility ni former President Duterte, where sinasabi na wala namang direct na ginawa. No? Kasi nga indirect actions yung accusations against him.
Exactly, Dean. Napansin natin, parang hindi naman nila itinanggi na nagkaroon ng mga pagpatay. But at every step, pilit nilang nilalayo sa Pangulo, sa dating Pangulo, ang mga naging pagpatay na ito. Halimbawa, wala naman daw direktang nagsabi na inutusan siya, kaya siya pumatay. O kaya, yung halimbawa, yung common plan, nagkaroon daw ba ng pagpupulong between the former president and these other co-perpetrators para planuhin at isagawa itong executions na ito? So sa tingin mo, Dean, nag-succeed ba ang depensa na i-insulate, ilayo ang dating Pangulo dito sa mga aligasyong ito?
Understood that that will be their argument, no? Especially that pinapakita dito na may ibang perpetrators na sinasabi. Pero walang isang plano, hindi sila nagtipon-tipon for this. But we have to take note that there is no such thing as conspiracy, no? Dito sa kaso na ito, and we are looking at individual personal responsibility in international law. And kung titignan natin yung mga kaso na decide na in relation to the Rome Statute before, we can see that they do not look into the literal meanings ng word dito, but tinitingnan natin ito dito sa, for example, sa elements ng crime. There is some flexible definition, flexible understanding, and interpretation on this side, especially doon sa direct or indirect co-perpetrator. Because here, we can see that there is control on the part of him as president. In fact, meron tayong konsepto sa international law na command responsibility for international criminal crimes.
Actually, yun nga yung gusto ko sanang tanungin, attorney, no? Because sabi nga po nila, international law is very different naman kumpara doon sa nakasanayan natin. Ang gusto ko lang balikan, kasi kahapon po, parang idinidiin na ni Attorney Kaufman or ng depensa, parang gusto na nilang mag-discredit ng mga witnesses. Parang sinasabi nila, the witnesses presented by the prosecution, ito naman ay self-confessed murderers, so bakit daw sila paniniwalaan? Especially if they were given an exchange of immunity or whatever, di ba? So, karaniwan po ba talagang ginagawa sa pre-trial pa lang na nagkakaroon na ng effort to discredit the witnesses of the prosecution?
Kasi we take note here that the goal of the defense here is to destroy the evidence na pinapresenta ng prosecution. And that is the purpose dito. And titingnan natin dito that the evidence required is simply substantial grounds, no? Which is beyond speculations, pero may credible evidence, no? So, kung titignan natin, understood that the defense would say that walang direktang ginawa si President Duterte, and all the direct attacks on the arguments of the prosecution are expected, and I think he did well on that, plus the fact that he wanted to frame it as a political issue and on humanitarian issues as well, no?
Nakakatulong po ba yun kapag ginagawa yun na parang pinapalabas na this is a political issue?
In terms of the International Criminal Court, I think that this is not something that the court is interested at. Kailangan ng korte na makita kung ano ang pattern na sinasabi, kung ano ang elements ng crime. Because I understand that even in the opening statements ni Kaufman, he was saying that kasalanan ito ng media, this is political in nature and all that. And this kind of framing is not addressed to the court, but maybe on public opinion, to the supporters. And I think that's one thing, and consistent naman ang defense on that.
Ngayong araw, attorney, inaasahan magbibigay ng closing statements. What can we expect from those closing statements? Of course, hindi naman siguro natin ma-expect na uulitin nila yung point by point na mga niraise sila, di ba? I mean, there's simply not enough time for that.
I think they will focus on the major points that they wanted to emphasize, and for the
Kumbaga, recap ba to? Ganyan? I-recap nila?
Siguro, kung baga sa rebuttal, kung sa mga debate natin na ordinary, no? Pero you focus on the major points na gusto mong i-emphasize so that makita ng court na, pwede nating pag-isipan itong portion na to na, wala palang direct link, direct na ginawa si former President Duterte on this, looking at the element. So, I think that is the entire thing na gagawin nila for this remaining few hours. Although very limited, but kailangan nilang i-present sa korte on the final form ang kanilang argumento. Kumbaga summary, but kumbaga nakatutok doon sa pinaka-problematic areas on the part ng depensa. I-present nila yung mga problematic areas na present ng prosecution, and in the same way that the prosecution is expected to strengthen its case, and also the weakness of the defense.
And of course, I would expect more impassioned, stronger calls to action. Kasi si Attorney Kaufman, ang gusto niya, ibalik sa prosecution itong kanilang charge sheet, and then in the interim, i-release nyo ang kliyente ko. Yun ang gusto nyo mangyari. Ito namang mga biktima, for example, this is the last vote. Huwag nating hayaang maiwan ang mga biktima in their final quest for justice. So we will expect more of that, Attorney, I guess.
We will expect more, especially that here we're talking about, for example, with respect to the victims. Of course, ito ang victims, pakita nila dapat na there is humanitarian aspects, because of course this is a crime against humanity, but really that there are real people here. There are real victims of the actions ng gobyerno that is systematic, widespread, and all that. And that will be discredited by the defense as well.
All right, well, Attorney, abangan natin lahat yan.
Ito na. Mukhang nagsisimula
Criminal
na yung
Court is now in session.
kaapat na
L'audience de
araw
la
ng
Cour
confirmation
pénale
of charges hearing.
internationale.
Panoorin po natin.
Please be seated. Veuillez vous asseoir.
Judge Motor. Good morning, everyone. I'd like to welcome everyone in and outside of the courtroom. Court officer, kindly call the case.
Madam President, Your Honors, situation in the Republic of the Philippines in the case of the prosecutor versus Rodrigo Duterte, case reference ICC 0121, 0125, and for the record, we are in open session.
Judge Motok, thank you very much. I would like to ask the parties and participants to confirm that the team composition is the same as yesterday's. Good morning, Madam President, Your Honors. I can confirm that indeed the OTP is represented by the same staff members. There have been a few changes over the days, but they are all here. The presiding judge, thank you very much, Deputy Prosecutor. Ms. Masida, for the legal representatives of victims. Ms. Masida, good morning, Madam President, Your Honors. Same composition as yesterday. Finally, the defense, Mr. Kaufman.
Good morning, Your Honors. We remain the same. Merci beaucoup.
Thank you very much. I would now like to call upon the defense to address the court and to complete their submissions on the merits. We have to add the time that the defense did not use, but you can use all your time. We will have a break at 10:30, and then we will continue in the afternoon. So, Mr. Kaufman, please proceed, and you must respect the Chamber's decision regarding redactions. Otherwise, I will be obliged to interrupt you each time so as to protect victims and witnesses. Mr. Kaufman, please go ahead.
I do indeed thank Your Honours for that consideration. And we did, in fact, have a short version prepared and a long version prepared. So I'll be reading from the long version, and that was specifically so that we could accommodate the redactions that have been so insisted upon, and we respect that, of course, by the prosecution. So I now turn, with respect, Your Honours, to count 2. And this concerns the alleged murders of high-value targets during the presidential period. And before addressing the individual incidents that the prosecution characterises as involving so-called high-value targets, the defence makes a preliminary observation. The term high-value target appears throughout the prosecution's brief as though it is evidence of a coordinated plan to eliminate targets. With respect, that inference cannot be sustained. The existence of a prioritization category within a law enforcement campaign does not establish a criminal plan. HVT was an operational classification used by law enforcement, and in this sense, it is no different from a similar acronym in another country where I have clients. APOTS, or Australian Priority Organisation Targets. HVT is not a code for an instruction to kill or a witch hunt. It was a prioritization tool within anti-drug operations applied across regions and units on the basis of intelligence assessments, alleged position within drug networks, or inclusion on watch lists. Classification does not imply selection for murder, any more than it is proof of unlawful intent. The prosecution itself acknowledges the existence of formal operational frameworks, including police circulars and structured campaigns. Within those structures, individuals could be designated high value for purposes of operational attention. Many HVT operations, in fact, resulted in arrest or surrender, albeit some resulted in fatal encounters. For this reason, each alleged HVT incident must be scrutinized on its own evidentiary foundation. When the incidents falling under Count 2 are examined individually, the pattern we submit is similar to those incidents falling under Count 1. Namely, heavy reliance on insider testimony, wishful and selective reading of police reports, and dubious and tenuous linkage to Rodrigo Duterte. Now, the operations cited under Count 2 were conducted within the framework of the lawful war on drugs, and as such, operational contexts are consistent with planned law enforcement activity, including buy-bust operations and coordinated arrests, rather than preordained killings. The evidence for Count 2 incidents consistently shows that the deaths occurred during armed confrontations in which force was used in response to an imminent threat, in accordance with the rules of engagement repeatedly articulated by President Duterte, namely that lethal force was permissible only where life was in danger. Across the Count 2 incidents, there exist contemporaneous documents, whether it be arrest warrants, operational records, or firearms recovery reports, all of which reflect legitimate police operations that escalated into exchanges of gunfire. The general record does not substantiate a theory of wanton execution, yet the prosecution seeks to rely, once again, on the testimony of criminals spilling their hearts with a tacit understanding that they will never be prosecuted. In 4 of the 5 incidents, contemporaneous reports document the recovery of firearms at the scene, indicating that the weapons were used against police and prompting a responsive use of force. In incidents 12, 13, and 14, the operations were authorized by judicially issued search warrants. We have diagrams on the screen being shown. I'm not going to stop. They will be presented throughout my presentation continuously, all in an attempt to save time. Those circumstances are squarely within operational legality and fundamentally incompatible with a pre-planned murder. Incident 14 is particularly instructive. 4 individuals were arrested alive. To us, that demonstrates selective and not indiscriminate use of force. In incidents 10, 13, and 14, gunpowder residue was detected on the victim's hands. At a minimum, that forensic finding is consistent with an exchange of gunfire and not consistent with a straightforward execution narrative. And the prosecution and the victim's representatives simply can't have their cake and eat it. They can't say in one breath that drugs and guns were planted on victims and therefore dispute crime scene evidence, while at the same time complaining about the lack of crime scene evidence. Yet the prosecution virtually disregards these objective and forensic indicators in favor of narrow and often uncorroborated insider testimony. This is best illustrated in Incident 10, which rests almost entirely on P1160's assertion that a firearm was planted at the scene of the crime, and the official report fabricated. Yet P1160 expressly accepts that he did not witness the planting of the firearm and merely assumes that it must have happened, before conceding that the firearm may already have been present. Once again, we are in the realm of inadmissible conjecture. We know that an investigation followed that incident. The opening of an inquiry is not consistent with the intention to conceal wrongdoing. Beyond that, as I've just mentioned, the record reflects the detection of gunpowder residue on victims' hands in this particular incident. A forensic indicator consistent with an exchange of gunfire and inconsistent with the witness's testimony, which is notably, once again, uncorroborated. Incident 11. This is the sole incident in count 2 where direct linkage to Mr. Duterte is advanced. And this linkage rests entirely on voice recognition by an individual who claims to have overheard a telephone conversation and recognized the president's voice while being physically moved from one location to another. The alleged recipient of the telephone call himself was never interviewed, and another person present, on whom the prosecution relies for corroboration, did not hear the conversation. After all, would it not have been an item of interest to all those present in that specific location that the President of the Republic himself had condescended to discuss matters of such a criminal nature by way of telephone? So the ridiculous assertion stands solely on the word of one single individual. The only other corroborating witness, the one who heard nothing, acknowledged a personal resentment that he harbored for the then President, Rodrigo Duterte, for reasons you will find in PHL OTP 000164220-R01 at 0022, lines 695 to 708. Once again, I can't mention the reasons because it's redacted. Voice recognition in uncontrolled conditions, while being physically moved, and uncorroborated by any forensic or documentary evidence, cannot constitute substantial grounds for confirmation, particularly where it forms the sole mechanism for attribution. Incident 12. This incident relies heavily on a central witness whose credibility is seriously compromised by retaliatory motives he admits to harboring against Mr. Duterte. This can be found in OTP tab 55 at page 27. Line and another reason that we cannot mention in open session, but which can be found in PHL OTP 000-15167-R01 at page 0008. For this particular incident, the case record demonstrates that this operation was conducted pursuant to a judicially issued search warrant, with operational reports and documentation concerning the recovery of firearms. To display such an extensive contemporaneous record, one would expect the prosecution to produce forensic evidence capable of undermining the reliability of these materials, evidence demonstrating fabrication or inconsistency sufficient to reduce their probative value. None, however, has been forwarded, because none presumably exists. Incident 13. This relates to the killing of Mayor Espinosa, whose name I can mention, and Raul Yap, who was shot in a police cell. The prosecution's case is largely premised on a witness who claimed to have heard but admitted not to have seen anything. Thus, there is nothing in the prosecution's evidence to contradict the alternative theory proposed for this incident, which is that there was a firefight between the victims and the officers in the police station Leyte sub-provincial jail. Nor is there a need to enter into these conflicting accounts because the prosecution's own evidence exculpates Rodrigo Duterte for responsibility for this incident. Not that he admits any connection to it. After all, according to the prosecution, on 1 August 2016, Rodrigo Duterte gave Espinosa a 24-hour ultimatum to surrender. And surrender he did the following day. 4 days later, Rodrigo Duterte commended Espinosa for surrendering to Ronald de la Rosa, commenting that it was just as well that he did. So if we look at it from the point of view of Rodrigo Duterte, that is where the incident ended, despite Mr. Jeremy exhorting us to believe otherwise. What happened thereafter, as awful as it may be, had nothing to do with our client, and not one witness can say that. The prosecution's narrative in Incident 14, the raid on the house of another person who I can mention, the mayor of Ozmiz City, rests exclusively on a witness who, for reasons we cannot explain in open session, is wholly unable to provide complete or reliable testimony for reasons that can be found in D36, tab 181, lines 128 to 155, and lines 191 to 212. Contemporaneous documentary police reports reflect that this police operation proceeded pursuant to 6 judicial search warrants, something hardly consistent with a premeditated murder scheme. After all, if the intention was cold-blooded murder, why go to the bother of involving a judge? Official investigative materials also indicate that officers approached the premises, announced the execution of the warrant, and were met with gunfire that struck a patrol vehicle and injured an officer, prompting a return of fire. This directly refutes what Ms. Masita so categorically claimed on Tuesday, namely that none of the arresting officers were ever harmed during the operations. Transcript. T5, page 44, line 24. In every case, the victim was killed, and none of the arresting officers were harmed. The exchange of fire, as reported, is supported by the fact that gunpowder residue was found on 7 individuals, including on the mayor himself, and a paraffin test turned out positive on the person of one of the victims, indicating that he had discharged a firearm, something totally negating the gun plant theory proposed by the prosecution's only witness. It is also worth stressing that 4 individuals were arrested alive following the operation, and that one of them was subsequently sentenced to life imprisonment after the domestic courts rejected claims of evidence planting. That fact alone is not consistent with a theory of indiscriminate execution, but is rather consistent instead with arrest and prosecution within the boundaries of the law and not indiscriminate use of force. So to summarize, across incidents 10 to 14, count 2, we see absolutely no evidence whatsoever of any attribution to Mr. Duterte on the granular level, nor do we see any evidence of a mutually agreed course of conduct on the upper hierarchical level of government involving Mr. Duterte and his alleged so-called co-perpetrators. The record reflects police operations conducted at unit level, sometimes under judicial warrant. P1166 describes operational discretion resting with the local team leaders and characterizes planned killings as rare and locally motivated. P1066 clarifies that to neutralize, that word which has been heard so often in the last few days, neutralize referred to lawful enforcement, not killing, the prosecution's own witness. The Senate committee report refers to rogue uniformed police. To conclude, the evidence reflects decentralization, not control required under indirect co-perpetration. And for these reasons, confirmation on count 2 cannot stand. Now, I'm going to start count 3. We have until 10:30. I'm conscious of the time allotted to me. So count 3 relates to the barangay clearance operations during the presidential period. Incident 15 marks the beginning of the barangay clearance operations. Now, from this point forward, a familiar pattern emerges in the prosecution's narrative. The same modus operandi, to employ Mr. Jeremy's language. Routine buy-bust operations are recast as sham exercises designed to conceal extrajudicial killings allegedly ordered from some unspecified source from above. Mr. Jeremy claims a target was identified through the use of lists. Well, there's nothing wrong with that. As one witness, an intelligence officer, explains in his testimony, the use of lists is a normal standard procedure. Once validation was conducted on a person, X, a file on that person would be created as a result of intelligence operations. Then, so claim Mr. Jeremy and Ms. Croft, the target is murdered and reports are falsified and rewards are paid out. This, Ms. Croft suggested at transcript 5, page 23, lines 11 to 13, is the systemicity of the pre-planned attack. But this is not the case. The defense can point to contemporaneous official records generated across different units or organizations that show clearly that in the majority of these incidents, the evidence reflects legitimate law enforcement operations involving spontaneous and reported exchanges of fire and uses of force subjected to forensic and administrative review. These are not clandestine acts hidden from scrutiny, Madam President, but rather recorded operations consistent with self-defense in the course of policing. And where the evidentiary record supports competing inferences, including the inference of a lawful armed confrontation and the inference of an unlawful execution, well, and with this I will conclude, in dubio pro reo. 10:30.
Merci beaucoup.
Thank you very much, Mr. Kaufman. So I've understood that you would like to use the time that remains to you, and you still have 20 minutes, actually. I understood that you wanted to use that time. Yes, I would, but I'm not so sure if I can conclude in 20 minutes.
C'est possible. OK. Nous essaierons, Madame.
Ouais, donc vous avez la...
Judge Motek, very well. It's still you. You have the floor. Proceed.
Across incidents 15 through 49, the Chamber will repeatedly encounter contemporaneous buy-bust or warrant-based documentation, reported exchanges of fire, gunshot residue findings, ballistic testing, immediate hospital transport, internal investigations, and in some cases, prosecution and conviction of officers. Against all of this evidence that you've just seen on the screen here, the prosecution offers single insider accounts of alleged stagings, uncorroborated assertions of weapons planting, and nanlabans, unsupported by any forensic evidence, often speculative, frequently contradicted by the alleged co-participants, or yet, more often, complete silence from the alleged co-participants, as they were never even questioned about the incident. And most importantly, despite Mr. Jeremy's assertions on Tuesday, wherein he claimed that the police reports were repeatedly falsified to legitimate the operations as acts of self-defense, copy-paste reports in which victims were frequently blamed for their own deaths, there is zero proof, none, that the only existing contemporaneous documentary evidence is fabricated or unreliable. No proof whatsoever of this supposed falsification in the entire case record. And on this point, let us just clarify a basic principle, that a state document with the appropriate stamps and signatures and what have you is prima facie reliable, or in other words, it carries a presumption of administrative regularity. And if the prosecution seeks to displace that document and call the entire state apparatus into question, then the burden rests on it to produce credible, objective evidence rebutting that presumption. Bare allegations or reliance on single prosecution witnesses cannot suffice to overcome this presumption of authenticity and correctness, nor should the burden shift to the defense to prove that those documents are not falsified. Now, we do not deny that in some instances the record may reveal unlawful conduct by individual officers.
Alright, so sa punto ito, ibig sabihin yan may redacted portion na. At syempre, sa umpisa pa lang, di ba, Dean, pinaalalahanan na ni Judge Julia, si Attorney
I-interrupt
Kaufman.
kita pag may binanggitan na hindi na dapat banggitin. Dean, lihis lang tayo konti. Pakikwento what happens during this time.
Kasi kung nasa sa gallery ka, if you're watching there sa gallery, pag may redaction, ino-off yung audio. At the same time, parang sinasara ang cortina na blinds there sa gallery. Because from the gallery, you can see what's happening below. So sa baba kasi siya, ang mga judges.
Nakikita natin may salamin di ba? To divide the gallery from the everybody else sa courtroom. Hindi tulad nung korte natin dito or sa mga nakikita natin sa pelikula na kapag nasa audience ka or nasa courtroom ka, nandun ka mismo, right behind.
Public trial talaga, na talagang nasa harap mo. Pero ang setup nila is parang nakatingin, kapag ako ang audience, nakatingin ako dun sa baba, tapos on the left and right, there are interpreters. Kasi there are interpreters there na may French, may English, may Arabic, may Russian or whatever. And they are continuously doing their job as well.
And again, the primary purpose of redaction is the security
to protect
of
the witnesses. At the same time, baka mapangalanan, no?
Kanina, Dean, okay, sige, babalikan natin kasi nagpapatuloy.
08, in which the police proclaimed that 32 people were killed in Bulacan big-time operations, and then went on to refer to this as one single operation in which 32 victims were killed by the police in Bulacan. But what Mr. Jeremy failed to tell you, Your Honours, is that one of the prosecution's own witnesses explained clearly that he investigated these deaths in an official capacity soon after the killings and found that 33 people were actually killed in different municipalities and provinces in central Luzon, but that their bodies were delivered to Bulacan. This was not, as Mr. Jeremy suggested, a single incident of mass murder, but rather an improper aggregate of a series of law enforcement operations over the course of 24 hours, executed in large geographical area, and for which we have no evidence in the case record. There's no evidence on the perpetrators, victims, motives, manner of attacks, methodology, in essence, nothing to link them to an alleged fantasy common plan. Everything is just stitched together enough to give it a veneer of organization. I now turn to incidents reflecting documented armed confrontations. And as mentioned when I first turned to this count, the documentary record, which has not been displaced by any evidence proffered by the prosecution, reflects attempted arrests, resistance, and responsive use of force. And you've just seen some of the documents up there on the screen. Let's turn briefly to Incident 17, for which the prosecution has relied on a witness who stated that the planting of evidence was an open secret in the locality and province more generally. However, another witness, working in the same locality, P1208, states otherwise, that he was never involved in illegal operations resulting in deaths, was not aware of extrajudicial killings disguised as lawful operations, and confirms that there were no standing orders to kill. The operational objective, he explains, was arrest, lethal force only when the circumstances required it. And you can find this information in Defense tab 96. And we see this pattern again and again and again. In Incident 40, for example, P1131, who worked with the individual alleged to have shot the suspect, stated clearly that the killings occurred only in circumstances of lawful use of self-defense. That can be found at Defense tab 74, and you can see it on the screen as well. This type of testimonial evidence is also corroborated by documentary and forensic evidence. Incident 15, the prosecution again resorts to its usual pro forma narrative of stage killings or nanlabans. But what it has not done, of course, is prove this. Whereas I urge your honours to look at the screen, where you can see detailed documentary evidence about how this incident came about, and I summarise: a spontaneous exchange of fire after the suspect discharged a firearm, ballistics testing of the officer's weapon, affidavits by the police officers involved, and formal review and investigation of the officer who fired his weapon. Now, I'm not going to sit here and bore you with all the evidence we have on every single one of these incidents, but what I will tell you, Your Honours, is that we have this type of forensic evidence proving attempts, arrests, armed resistance, and responsive and sometimes disciplined use of force in no less than 13 incidents. I don't know where Mr. Butoyan got the idea from that there's no forensic evidence left in the case record. And may we remind you, Your Honours, until the prosecution proves otherwise, which it has not, these state documents remain prima facie, authentic, and reliable. For incidents substantiated by a single witness narrative and unconfirmed by alleged co-participants, I refer Your Honours to no less than 9 incidents. One prosecution witness, P1160, is the sole testimonial evidence for at least 3 incidents, while another 6 incidents are premised entirely on the testimony of P3. Now, what's interesting about these incidents is that P3 alleged that he was only one of a group of 3 or 4 perpetrators, and these other perpetrators are actually also prosecution witnesses. Yet none of the other witnesses corroborated his version of events. Not one. A couple of incidents alleged by the prosecution appear on its own evidence to be unrelated to drug enforcement, and thus questionably part of the fantasy common plan or organizational policy. For this, I would refer you to incidents 31 and 41, which involved targeting of 2 individuals, again, because of non-drugs related conduct. I'm not sure whether I can mention the type of conduct without revealing the identity, so I shall refrain from doing so. The prosecution has not presented any evidence to substantiate any nexus to anti-drug operations in either of these incidents. And for this, I refer you to D36, tab 158, at page 4. On the perpetrator's own account, the trigger for the killing was a personal grievance relating to property damage. There are numerous incidents against unidentified or improperly identified victims. The victim in incident 45 is described as a minor, just as in incident 38, another incident on which Mr. Jeremy focused on Tuesday. And, by the way, on the subject of the killing of children, of course it ticks the right boxes for the prosecution insofar as it pulls the heartstrings. But apart from Kian de los Santos, the prosecution has not, despite its emphasis on children, presented to this chamber during these proceedings any evidence that even one victim, apart from Kian, in its 49 incidents was a minor. No birth certificates, no corroborative evidence, nothing. While incidents presented as involving minors are indeed grave, Article 61 requires proof, not emotion. It is for the prosecution to prove that the children were involved in these incidents, and not for the defense, once again, to prove a negative. Now, this evidentiary deficit extends even further. The Bulacan Provincial Office provided a certificate indicating that it had no record corresponding to the names of the victims, whose names have been redacted on the slide, which we will show you. Okay, but we'll pass on. But their names have been redacted. And these are alleged police killings, yet no operational report. Indeed, no contemporaneous documentation whatsoever has been produced. So on what does the prosecution base its claim that these individuals were murdered by the police other than P3? The prosecution relies almost exclusively on the account of P3 echoed by P8. And this is rather ironic. Does the prosecutor claim that P3 is corroborated by P8 when the source of P8's information is in fact P3 himself? Bootstrapping logic, once again. The alleged direct perpetrator, P1201, stated during his interview that he had never participated in an operation involving a child. The other officer allegedly present during both incidents, P1131, was never questioned about these events by the prosecution. And that admission, we submit, is not neutral.
Nako, Dean, meron po akong tanong dun sa isa sa mga nabanggit niya. Well, actually, in general, di ba, meron siyang mga binabanggit na statements, di po ba? At parang yung mga nabanggit na ng mga witnesses, tapos sinasabi niya, but actually, it doesn't work that way, ganyan. Yung mga pinagbabasihan ba nila, Dean, both the prosecution and defense ng mga statements, same testimonies lang po yun? Kasi di ba, all evidence is made available to both the prosecution and the defense?
The defense is trying to ruin the evidence presented kung ang testimony ni P3 ay yun din ang subject ng attack ni defense.
Pero yung mga testimonies na yun that they're mentioning sila, P3, ganyan, sino po yung kumukuha ng testimony? Investigators po ba or prosecution?
I think there are statements na sinubmit sa prosecution, or the prosecution also did their job in analyzing all the evidence, no? And also remember that the victims were also represented and they are also submitting their evidence.
So yung prosecution mismo ang nag-interview dun sa mga witnesses?
Ideally, the prosecution has a hand on the evidence to be presented, no? And they have to look into the statements, not only the statements, but the credibility of the witness here. And also even the videos, the scrutiny of the videos and statements lang, na sobrang dami.
No? Be characterized as manifestations of a centrally designed OTBT-based common plan, because they quite clearly fall outside of that plan. And it does not reflect what the prosecution on Tuesday described as the systematic features of a national network operation. Instead, according to P3, the motive was personal financial gain through the sale of bodies. And if P3's account is accepted, it reflects opportunistic actions for personal gain of the most macabre kind. As held in Al-Hassan, an opportunistic act committed for personal profit without more falls outside the common plan. Now, just to finish up quickly on the issue of identity, in Incident 43, even the alleged perpetrators are not identified. Without identification, the Chamber cannot assess their institutional affiliation, chain of command, or attempt to make any possible linkage to Mr. Duterte. One more thing, Your Honours. The prosecution focused for some time on Incident 23. I can mention his name, Mr. Benjamin Vizda. Mr. Jeremy displayed compelling footage of Mr. Vizda's arrest and then
Yung pangalan na yun, yung binanggit, parang naka-unredacted yun eh. Isa yun sa mga pinangalanan dun sa, I believe, dun sa HVT, dun sa count 2. But, I don't know. Hindi natin matukoy kung tuwing kailan nagre-redact dito sa mga nagpapatuloy na hearing.
They are very careful sa mga pangalan tsaka sa mga ebidensya na binabanggit dito, no. That's why I think although they were referred and particularly identified also by the prosecution and submitted.
The fact that while handcuffed, he attempted to grab the gun of one of the policemen, leading to a struggle and prompting the motorbike to fall over and the policeman to shoot Mr. Vizda twice in self-defense. And that this PNP report appears to be corroborated by another prosecution witness, whose testimony fully aligns with the substance of the police document. Mr. Jeremy claimed that the PNP reports were false, relying solely on the allegation of one witness that the scene was staged. This witness claimed that the handcuffs were removed from the victim, that the body was loaded on the tricycle a few minutes after being shot and then brought to the hospital. However, his account is contradicted by the very picture the prosecution has shown you on Tuesday. Indeed, it appears that the prosecution is submitting documentary evidence which undermines its own witness's testimony. As you can see here, handcuffs are on. The body is on the ground rather than on a tricycle. Photojournalists are also present. This contradiction was even noted by the prosecution's investigators at the time of the interview and was put to the witness. And when confronted by the investigators, what did that witness say? I don't know if I can.
Kanina, di ba, Dean, right before nung pag-umpisa ng hearing, sinabi na ni Judge Julia na kay Attorney Kaufman, mag-ingat ka sa mga redactions. Meron bang kaso ng mga, halimbawa, citing in contempt pagdating sa ICC?
I think so far na na-observe natin, warning pa lang. And
okay.
I think the lawyers here should be observant and also comply with the warnings. Otherwise, maybe mapapatawan din sila ng penalty.
Pag ganito po ba, tingin niyo po ba...
But there is no evidence that Mr. Duterte knew of Vizda, that he directed the operation, or that he approved its planning, nor has the prosecution demonstrated that the incident would not have occurred in substantially the same way absent his alleged contribution. 2 minutes left. Without proof of control over the commission of the specific crime, Article 25, 3A cannot be satisfied. And finally, with regard to count 3, the prosecution's witnesses themselves concede that there was no formal approval process. Targets were selected without validation, officers acted for personal reasons, and decisions were taken locally. All of this destroys the assertion that there was a mutually agreed common plan. I will elaborate. P1160 claims hierarchical transmission of policy within the police, while simultaneously acknowledging officers' autonomous killings for personal motives. Those propositions cannot comfortably coexist. P3 explains that certain officers acted outside any common plan and for opportunistic reasons. See Incident 38. In Incident 49, P1207 attributes instructions to local officers without evidence of communication or direction from higher authorities. And most significantly, P1207 P1207 states after a certain death, once again abiding by the redactions, Tokhang operations and killings ceased. This indicates, Madam President, Your Honours, that dependence on specific individuals, not an enduring organisational policy. A system-wide common plan cannot depend on the continued presence of a non-fungible local official. And with this, I conclude.
Judge Motok, thank you very much, Mr. Kaufman. All the arguments on the merits have been heard. We will now break for 40 minutes up to 10:30. And after we return, we will continue with the closing arguments or submissions, starting with the OTP. Thank you very much. Court is suspended.
Ayan, Dean, natapos na si Attorney Kaufman sa pagpresenta ng kanyang mga submissions para sa depensa. Iba yung level, yung extent ng detail niya, no? Iniisa-isa na niya eh. Ginigiba niya isa-isa yung prosecution evidence. Did he succeed?
I think as to the extent of the destruction of the arguments of the prosecution, although ang pinakapunto niya, that there was no direct link between these killings and former President Duterte, and that there is no personal liability, personal responsibility here, which is the goal here na dapat na harapin ni Duterte itong personal responsibility. And pinapakita nga, ang sinabi niya sa last statement niya, sinabi niya dito na walang common na plano.
Yes.
No? Pero pag tinitingnan natin ang na-mention niya na Article 25, kasi it relates sa direct participation, direct na paggawa mismo. This has been interpreted by the court in several instances, and they're saying that it should not be looked at na sa isang action lang, but we have to look into the pattern, the organization, even the scheme and the policy. So, and as we said earlier, may mga bagay na dapat maitahi mo doon, na hindi lang na dapat siya mismo ang gumawa nito.
Kasi kung may common thread dito sa naging arguments ni Attorney Kaufman, yun eh. Again, as I said kanina, para ini-insulate talaga nila ang dating Pangulong Duterte.
Ang point niya dito pati is circumstantial lahat ng mga ebidensya. Kasi sabi niya, no witness, no evidence can prove directly na siya mismo nag-utos niyan. So circumstantial and merely statements lang ang mga sinabi. In fact, they are discrediting the testimony and the personalities mismo ng witnesses dito.
Although yung isang point, at least for me, itong wala daw proof that aside from Kian de los Santos na may iba pang minors na namatay dito sa at least sa count 3. Can that stand? Para I think it's easy to debunk na kasi may mga ibang mga minors talaga na namatay.
Yes, that's something. Kasi ang pinaka-famous dito na actually mukha ng EJK is really Kian de los Santos. And even on the presentation, di ba, ng prosecution, they showed the picture of a child there. But kahit sinong ilagay mo doon, Kian de los Santos ang maalala ng tao.
Yes.
And I think there are evidence na sinasabi na hindi lang si Kian ang minor dito.
Yes.
Mas marami pa.
But it's a different story, of course, kung hindi naman naipresenta ng prosecution o hindi isinama. So, in that case, tama si Attorney Kaufman. Ganun ho ba yun?
Kasi ang nire-rely ni Attorney Kaufman dito ay sinasabi niya na itong statement for Kian de los Santos, halimbawa, and these are not supported by other evidence, and at the same time na ang isang circumstance lang yan. Hindi natin pwedeng lahatin na nangyayari yan.
Okay.
Dean, gusto ko sanang balikan yung sinabi ni Attorney Kaufman. Meron siyang nabanggit na, tama ba yung aking pronunciation? In dubio pro reo, meaning when in doubt, you rule for the accused. Pero nagagamit ba yung argumento yun sa pre-trial pa lang? Kasi di ba dito ang hinahanap pa lang naman natin is substantial grounds, hindi proof beyond reasonable doubt.
I understand na sinasabi niya dito na dapat wag na natin ipatuloy ito kasi obviously walang ebidensya ang prosecution. So wag na natin pang patiisin ang akusado dito. Kung alam naman natin na on its face problematic ng evidence.
Parang kahapon pa siya, gusto niya umuwi eh. Pack up na tayo, uwi na. Kasi walang ebidensya.
Although we have
Innocent yung
to
kliyente ko.
understand the threshold of evidence here, no? Substantial grounds lang. And dapat yung question ang innocence or guilt is on the trial na
Yeah,
mismo.
but of course, I would expect no less from a defense lawyer. So gagawin talaga niya yun.
Parang yung isa ko rin napansin kasi kanina din na parang ilang beses niya, maybe once or twice, no, na parang chine-check niya yung oras niya. May natitira pa siyang oras. Tapos sabi niya, I can stop, although marami pa akong sasabihin. I mean, strategy po ba yan? Ay, kasi syempre, di ba, parang iisipin mo kung hindi mo inubos yung oras mo, parang nagkulang ka sa sasabihin mo. Pero parang ito, parang nag-offer siya na, sige, pwede na ako huminto. Tapos sabi ni Judge Julia, hindi, go ahead, kasi meron ka pang 20 minutes. Is that part of the strategy?
Part of the strategy, siguro. At the same time, it's also the lawyer in him saying na you have to be conscious about your time. And kasi nga, madami yung pang pwedeng sabihin in this span of 20 minutes. No? And since may isang oras lang ang limited na pagsasalita nila, so they really have to work on this time. Otherwise, he would ask for additional time kung talagang hindi pwede. Pero he's so conscious because he's doing his job, I think.
All right. Alam mo, di ba sabi nga natin, this is the 4th day. Sanay tayo the past few days na parang kumbaga salita na. I mean, diba? Opening and then submission of merits. Pero yung kakaiba dito sa araw na ito, after both closing statements, meron pa yung hearing on the detention issue. Pwede yung i-explain kung anong mangyayari doon, Dean, yung doon sa hearing on the detention issue?
Kasi there's an issue on the detention, which is actually one of the questions nila. In fact, they have requested for an interim release dito sa detention and continuing detention of former President Duterte, no, and issues there on health, physical ability, and all these aspects, no, and I think there is a basis also in seeking for this, especially that it is allowed under Article 58 or under the rules of the Rome Statute.
On what grounds will the court rule for the accused?
For the interim release,
For the
interim release. And the interim release, if ever there are conditions, the court can impose certain conditions to ensure that he will be present on the trial if the trial proceeds.
Tulad ng anong mga conditions yun? Anong mga posibleng magpapayag sa korte na for interim release?
For the interim release, I think health condition, the mental state of the accused is or are considered, no? And plus the fact that, kasi 80 years old, may sakit, and the statements
tired
earlier...
and weak and frail.
Yes, ganyan. And these are serious, not only humanitarian considerations, no? But apparently, while he is on this investigation, he is still presumed innocent.
Pero expected po ba natin na magkakaroon ng decision on that today?
Today, I don't think so, that there is a decision on that. And maybe, kung nakita natin, no, ang decision ng pretrial chamber from the very start on this question na twice na or thrice na nadala, no, these are well written and klarong-klaro na there are reasons on the denial or probably on the approval if ever. So,
pero does it have bearing na ito ay dati ng sinubukan ng depensa? They already tried to get interim release, but it was denied by the court.
Kasi even if it was granted before, at any time, or it was granted or denied before, pwede namang baguhin siya in the course of the proceedings.
Pero
no?
periodic to din, di ba?
Yes.
Every once a year, I believe.
Na
Tama ba?
i-request.
Once a year?
Depende naman sa condition. No? So especially with the condition of former President Duterte na kawawa. And not only kawawa, but at least medical reasons. No? So, but there are also experts who were appointed by the International Criminal Court to look into the condition, physical condition and mental state of the former president, and they said he's okay. He can think well.
Which is what they said nga nung unang sinabi na ayaw dumalo sa hearing ni dating Pangulong Duterte. Sabi ng mga independent or medical experts ng ICC na he's physically fit, mentally fit.
Yeah, fit to stand trial.
To stand trial.
And if we look at the previous resolution ng korte, no, other than his personal condition, may mga outside na nakita and observations ang trial court, no, I mean ang pretrial chamber, including yung mga supporters, including yung mga capacity to influence if ever na lumabas siya, no, so which looks into his mental state and physical state, no. But we really have to look into the humanitarian condition, the humanitarian condition of the former president, no. And the case will continue despite the fact na pwede siyang i-release. But the conditions there that may be imposed, for example, on this neutral state or sa state na hindi siya pwedeng lumayo or hindi siya pwedeng itakas ng mga supporters.
Yung panawagan ng mga supporters niya na bring him home, malabo.
I think sa home na question, I think that's malabo. That's why we heard na there is a state na ayaw nilang identify before who
agreed to
yes, in
take him
agreement.
into custody.
If ever na i-release siya, pwedeng doon. Narinig natin Australia or Japan.
Yes.
Ganyan.
May mga familiar po ba kayong kaso from before, no, na nabigyan na ng interim release? Anybody who was on trial sa ICC na pinayagan?
I think the case of Duterte is quite unique because he's like this
Former head of
head of state, and the age actually, precursor to the International Criminal Court. There were instances where in the ICTY and in other cases na pinayagan out of the conditions, no. And also tinitingnan din dito ang kanilang weight of evidence maybe as against them or by evidence of flight, yung mga ganyan.
So, ang dami pala nating i-expect for today, no?
Yes.
Aside from the various closing statements. Pero, Dean, pagdating po ba doon sa closing statements, pwede pa bang maglabas ng bagong ebidensya? I mean, new arguments.
I think these are more on the rebuttal. Rebuttal at the same time, yung strength of your arguments, no? So siguro i-emphasize mo 'yon kung ako ang magre-rebut on that. So rebut the previous statements ng defense, and at the same time you focus on your horses na kung saan ang mas mabilis.
Magkakaroon din ba ng chance magsalita, closing ang CLRV, ang Common Legal Representative for the Victims?
I would presume that dapat. No?
Very confusing kasi sabi ko nga kay Ivan from the very first day kasi nga sanay tayo prosecution defense. Hindi tayo sanay na may isa pang partido
At
dyan,
yung prosecution,
common legal
andun yung side
representatives.
naturally ng victim kasi parang siya yung complainant di ba siya biktima? But dito po sa pagkakataong ito, hiwalay ang panig ng mga biktima.
This is where the uniqueness of international law is, no. Makita natin dito na may mga bagay na hindi natin nakikita on a normal case, normal hearing, and especially on the degree of the case. This is a universal crime, and there are many victims that are involved also. And of course, the accused is not simple, but not the accused still. Pero I think the suspect right now is powerful. It can be a government official, actually a president of a state, and the officials of a country. That's why we understand the actions of the court to protect the witnesses. Kailangang itago ang mga pangalan.
Kahapon, bilang tugon doon sa mga naging argumento or submission of merits ng depensa, after nung hearing, sinabi po ni Paulina Masida, who's the head of the CLRV, sabi nga niya na parang the burden of proof rests on the prosecution, but the witnesses must corroborate whatever the prosecution presents. Pwede niyo po bang ipaliwanag kung ano ibig po sabihin nito?
Yes, kasi dito sa prosecution, kung sino nag-aakusa, dapat ikaw naman talaga ang magpapresenta, magpapatunay na may sapat na ebidensya. Kasi kung walang ebidensya, ano pa ang ililitis natin dito? So, this is the goal of the preliminary hearing, para salain na itong ebidensya ay malakas or ito ay hindi. That's why, posible na ang ibang charges, there are 3 charges. Pwedeng ang charge 1, charge 2, pwedeng mag-proceed, pwedeng maiwan because of the evidence that is lacking, for example.
So, ang gagawin lang ng common legal representatives is to ensure yung, sabi nga nila, di ba, parang towards the end, seek reparation for the victims and to ensure their safety, that their rights are all protected.
Yes, and there is really a need to protect these victims. They are the ones na lumabas para labanan ang institusyon. They are the ones na lumabas para protektahan not only their rights but their families' rights over these accusations. That's why when I speak about reparations, may talagang naka-allot for them because of the damage done naman, no?
Din itong balikan ko itong mga pinresinta ni Attorney Kaufman, yung sa mga barangay clearance operations. Ito yung count 3 eh. Basically, ang sinasabi niya dito, walang proof na nagkaroon ng falsification ng mga police reports. Yung mga words na one time, big time, hindi naman daw necessarily talagang randomly may pumatay yung mga but these are actual legitimate police operations at may nanlaban at may lumaban at napatay. Pero meron din namang naaresto. Again, balik tayo doon sa sinasabi nila noong una. Cherry picking.
Yes.
So, of course, you will put forth arguments that will support your position. Pero
Parang
what do you think of
doing it.
gaano ba ito katibay para pasinungalingan? Kasi itong prosecution, limitado lang din naman. I mean, hindi naman lahat ng mga insidente ng nanlaban ay naipresenta nila.
And they are consistent with the allegation na talagang pinili lang ng prosecution ang ipepresenta. So on his part, pinili niya din and sinabi niya na ito lang din, and these are not supported by government records. And
Tapos yung mga testimonya, uncorroborated naman, ganyan.
And actually, government records ang tinitingnan niya.
Yes.
Siyempre, these are records provided by the police during that time. And we know that it is totally clean and very well praised actually, ng existing government during that time.
May word dyan, parang sanitized.
Sanitized. Not neutralized. Because the neutralized can be
Up for debate yun. Dean, kasi ilang beses rin sinabi ni Attorney Kaufman, diba, that there's no direct link.
Yes.
Parang yun yung paulit-ulit na sinasabi niya. There's no direct link between his client, the former president, and yung the people who actually carried out yung mga operations.
The officers acted for personal reasons.
Yes. So, pero pwede pang gamitin yung argumento na yun, given yung sinabi niyo kanina na in international law, there's what we call command responsibility. And also given that, yung charge naman dito is indirect co-perpetrator. I mean, di ba, parang technically speaking, narinig mo yung direct link, tapos narinig mo yung indirect co-perpetrator. So parang technically, pwede siyang gamitin or hindi pwedeng gamitin?
Kasi ang sinasabi natin dapat there is an intention, no? So saan ba ang intention dito ni Duterte? Pero if you look at may tinatawag tayo sa batas, for example dito na mens rea or kumbaga the mental state of doing the act. Is there an intention? So makikita natin dito even under the rules, under Article 25 I think, na sinasabi natin na may direct participation or direct involvement dito, no? But that's why we have to look at the concept at paano ba nag-evolve itong konsepto ng indirect co-perpetrator, no? Para mapakita na may personal responsibility, no? Pero titingnan natin dito sa action at the same time sa overall na aspect ng commission as to the systematic and the plan, the overall architecture of these alleged killings.
Din, balikan ko lang yung isang development kahapon. As everyone knows, nagkaroon ng press conference ang nagpakilalang retired Marines at sinabi nila, in-escort daw nila ang mga ICC investigators and all that. Ang allegation ay guilty ang mga ICC investigators of bribery and graft and corruption. And then ICC had to release a statement about that. Anong basa mo dito? Will that even play into what we are witnessing right now?
This is one thing because they are discrediting the ICC as an institution dito, no? Which is one of the points also raised by the resolution on the reason bakit hindi ibibigay ang gustong temporaryong release ni former President Duterte. If you have to look at the history of things, no? These are supporters' actions. And this goal, their goal, we don't know because obviously they are, I'm not sure of their motives and all that, but to really destroy the credibility and how the court will continue to function fairly and without any influence. So I think the ICC was correct in their action as well, that they have to of course stand clean on all this because otherwise the trust on the institution, at the same time there may be questions of their fairness and ability to render correct judgment or proper judgment
But
under
again,
the circumstances.
ito ba'y magkakaroon ng epekto? Will that even influence the judges in any way? Either way, kung baka magkaroon sila ng dahilan to consider in their that particular element in their decision?
Ideally, no. But of course, obvious na iba-iba ang judges dito. Hindi lang naman isang tao
Yes.
magde-decide. That there are several minds who will decide on this issue. And as the rule of law will always say that you have to stand on what the law is, and at the same time stand on fairness and what is just and fair under the
And
circumstances.
as pointed out by our resource persons partner, di ba? Ang sinasabi nila, these are trained lawyers themselves. Of course, alam nila yung mga iba-ibang tactics dyan. Perhaps, baka nga sila mismo ginawa rin yan when they were still practicing as prosecutors or defense lawyers. Pero ngayon, judges sila, though, they know how these things work.
And alam na nila, syempre, no? The lawyers will really do to discredit their actions. Also, the public. And remember that if we look at the history of the ICC, mga gobyerno ang kalaban dito. And some of them are existing presidents or rulers and their authoritarian governments, no? And they have a lot of supporters, offline and online. And right now, especially here, online, we cannot question that.
And capable of very creative moves like this.
So pero Dean, how do you suppose the judges, the current ICC judges, tune out or parang mute out all the noise surrounding the case? Kasi it's a very high-profile case, di ba? Maraming ingay na nakapaligid. So parang paano ba nila, hindi naman sila naka-isolate, di ba? Like a jury is. So paano nila dapat aralin yung mga argumentong iprinisenta? May sistema po ba yan? Based on your training rin po sa The Hague.
I think fairness, and at the same time integrity and justice are commanding not only instruments, but this is the box that we are supposed to get our idea on how this will be resolved. We know that there may be philosophical aspects on the part of the members of the tribunal individually, because others may be thinking about realism or about positivist. So their decisions can be influenced, but we look at what the law is, what is the evidence presented, and with the evidence presented by the prosecution and the counter by the defense on this, which could determine the innocence or guilt of the accused.
So, syempre, obviously, they can look beyond the rhetoric, di ba, presented. Kasi, syempre, yung mga salitang ginagamit pagdating sa opening, sa closing, talagang very, catered also to the public that is watching.
Yes.
Pero iba yung appreciation level ng mga judges.
Iba ang appreciation levels ng judges because ano ba ang goal mo when there is this argument on charge 1, 2, and 3. So sa elements tayo titingin, no? And the evidence, sapat ba ang ebidensya na sumusupport sa accusation, or are there contrary evidence that would destroy the evidence of the prosecution? And we really think that the political framing of all this, both sides can be called my political framing on the case, but I think this is part of the entire scheme, no, sa international criminal case like this, because sometimes it cannot even be separated. That is the questions on, is there a state responsibility or individual responsibility lang ba ito? But here we are talking about individual responsibility by the leader or any persons considered indirect co-perpetrators.
Alright. Okay, sa punto ito, hingi naman po tayo ng update mula kay Marisol Abdurrahman na nariyan pa rin siyempre sa ICC. Marisol?
Pia, oo, sa maikling panahon kanina na nakausap natin yung mga ilang nanonood doon sa nagpapatuloy pa rin na hearing, wala pa sila masyadong naino sa atin, pero yun na nga, kaabang-abang ang mga mangyayaring mga last remaining hours dito nga sa mga closing statement ng prosecution at saka ng depensa. At syempre, gaya ng ating napag-usapan kanina, Pia, inaabangan din etong ang hearing pa rin para doon sa review ng detention ng dating Pangulo. In the meantime, Pia, dito sa labas, tuloy-tuloy pa rin ang pagtitipo ng mga taga taga-suporta ng dating Pangulo, gaya ng inyo nakikita sa ating likuran. Ito yung mga ilan piya na nung mga nakarang araw ay actually nag-join pa sila doon sa public gallery para ma-witness yung hearing. Pero sabi nila, masaya naman daw sila sa mga sa naging kinalabasan ng pagpresenta ng defense team kahapon, kaya hindi na minabuti na nila na hindi na lang manood yung ilan sa kanila doon sa pang-apat at huling araw ng hearing. Natutuwa naman daw sila doon sa ibinilita rin ni Kaufman Pia na tinanong mo earlier kung ano ang kanilang naging reaksyon doon sa sinabi ni Kaufman na in good spirit. Para sa kanila, this is good news for them dahil kung in good spirit daw ang kanilang Tatay Digong, all the more na sila raw ay in good spirit dahil yun lang naman daw ang kanilang hangad. So mananatili sila rito hanggang mamayang alas 5 ng hapon kasi hanggang doon ang kanilang permit. Pero syempre titingnan din natin kasi we understand by 3 o'clock oras dito sa Hague ay we believe matatapos na rin ang hearing. Pero yun nga Pia, nagkaroon lang ng konting extension at syempre didinggin pa doon yung review ng detention ng dating Pangulo. At kanina rin syempre nakita natin ang mga ilang grupo na kontra naman dito sa extrajudicial killings at sumusuporta doon sa mga kaanak ng biktima na nandoon din sa loob at patuloy syempre sila na nagbibigay ng lakas ng loob at inspirasyon dito sa mga kaanak. Bagamat Pia, kung ikukumpara naman nakaraang araw, medyo mas kampante at mas malakas ang loob at mas nananalig sila na makakamit na nilang hustisya matapos nga ang pagdinig ng 3 araw at ngayon nga ang panghuling araw ng hearing. Pia.
Alright, Marisol, mukhang habang nalalapit yung pagtatapos ng hearing ay dumadami rin yung mga taga-suporta ni dating Pangulong Duterte dahil nag-aabang rin po sila ng kung ano magiging kahinatnan niyan. Makikibalita ulit kami sa iyo mamaya. Maraming salamat sa iyo, Marisol Abduraman.
Samantala, sa huling araw ng confirmation of charges hearing ng ICC, muli nagsama-sama mga kaanak ng mga namatay nung kasagsagan ng war on drugs. At mula sa Quezon City, makibalita tayo kay Rafi Tima. Rafi.
Ivan, bubulong lang ako kasi sa ngayon ay nagsasagawa ng candle lighting ceremony ito mga kaanak ng mga namatay noong war on drugs dito sa UP kung saan nagsasagawa sila ng grupo Watch. Naka-break ngayon yung confirmation of charges hearing kaya ngayon ay nandito sila sa may bahagi ng gusaling ito para magsagawa ng candle lighting ceremony. Bit-bit nila Ivan itong mga larawan ng kanilang mga kaanak na namatay noong war on drugs. Pakinggan na natin itong kanilang sinasabi. Iban ilan sa mga narito ay mga nanggaling na raw sa The Hague noong 2019 at nag-file ng kanilang mga reklamo. Yung ibang mga bit-bit na narito ay mga cellphone kung saan naroon yung larawan ng kanilang mga kaanak. Kanina ay nagsagawa rin sila ng protesta dito sa labas ng gusali kung saan nagsalita yung ilan sa kanila. Ayon sa mga kaanak nitong mga biktima ay bagamat malungkot pa rin sila dahil nare-recall nila yung mga nangyari sa kanilang mga kaanak ay may nakikita raw silang pag-asa dahil base sa tinatakbo ng confirmation of charges hearing ay mataas yung tsansa na matutuloy sa pagdinig yung kaso ng dating Pangulo kung kaya't ngayon ay pwede na raw silang mag-celebrate ngayon pa lamang dahil nga malakas yung kanilang loob na talaga matutuloy sa pagdinig itong nangyari sa kanilang mga kaanak. Ito ngayon na Ivan, isa-isang nagsasalita itong mga kaanak ng mga biktima para sabihin yung pangalan ng kanilang mga kaanak at lahat sila sumisigap ng hustisya para sa kanilang mga kaanak. So Ivan, siguro babalik na lang tayo mamaya kapag sila bumalik na dito sa taas kapag nagpatuloy na ulit itong confirmation of hearing of charges sa The Hague. Ivan?
Rafi, may nakausap ka ba sa kanila kung anong naging reaksyon nila sa mga argumento na pinalutang ni Attorney Kaufman para sa depensa?
Yes, actually kanina, Ivan, bago sila bumaba rito, yung isa sa mga kaanak ay nagsalita at nag-react doon sa mismong sinabi ni Kaufman na wala raw mga ebidensya at hindi raw totoo yung mga inilatag ng prosecution. Sabi niya, siya mismo ay nagpapasinungaling doon sa sinasabing hindi kumbaga walang plano dun sa ginawang pagpatay sa kanyang asawa. Siya mismo raw ay naka-witness dun sa nangyari sa kanyang asawa, kung kaya't sabi niya, siya mismo magpapatunay na hindi totoo yung mga argumento nitong si Attorney Kaufman. Ayon naman sa isang abogado na nagpaliwanag kanina dun sa mga nangyari at sa paglalatag ng depensa ng kanilang argumento, ay lahat daw ng mga sinabi ni Attorney Kaufman ay narinig na natin mula mismo sa Duterte administration noong dinidepensa nila itong war on drugs, kung kaya't wala raw bago dun sa mga sinabi ni Attorney Kaufman. So sa ngayon, patuloy pa nga rin itong kanilang sinasagwang candlelighting ceremony dito sa UP. Ivan?
Rafi, maraming salamat. Babalikan ka namin dyan.
Alright. So, nakikita natin, no, parang hindi natin natanong kanina kay Marisol kasi nga kung may pagkakataon na after ng mga hearings, kung nagkakasalubong yung mga taga-suporta ni dating Pangulong Duterte, pati na yung mga kaanak ng mga biktima ng drug war. Kasi syempre, very tense moments rin. At pag nasa loob, di ba, Dinet, sabi nga po ni Maris, tsaka ni Marisol, very difficult para dun sa mga kaanak ng mga biktima habang naroon sila sa gallery.
Yes, and I can imagine yung emotional side nito, no? Especially for the victims. But if ever na magkasalubong sila doon, because you have to remember that it's still ICC premises doon and it's a controlled space then. So medyo lahat dapat mag-behave doon at any time. Baka ano. But outside, for sure, magkakasalubong sila doon. But I really think that they really have to exercise restraint on their actions.
Attorney, napansin natin yung style ni Attorney Kaufman. Adversarial, no? As in, pinapangalanan niya, I don't understand why Attorney Butuyan said this and that. Yung iba nga, my friend, sabi ni Prosecutor Nichols, my friend. Itong si Kaufman, ibang estilo, no?
And I think that's the skill na binabayaran ng ilang milyon. Pero seriously, I
redacted daw yun.
Redacted. Oh.
And I think that's the goal of every lawyer appearing there, I think. And para maayos, hindi lang maayos, but maganda ang pagkadepensa mo, especially na you are pulling off a stint na you are defending a former president of the Republic of the Philippines. So, dapat with the expectation na dapat maayos yung ano mo. And ang style na to refer to the friend or to refer to the lawyer to make it more personal and mas maging iba ang impact nito, no? And I think that's normal for the lawyers and it's a good theatrics also for the supporters.
Sabi nga ni Professor Bagares kagabi, partner, di ba? Parang he doesn't necessarily agree with what Attorney Kaufman is saying, pero he is the lawyer. He is the defense lawyer that you would want on your side if you're being charged of crimes like this.
Kasi I guess that comes with being a defense lawyer as opposed to a prosecutor, no? Talagang mas forceful in a way ang presentation nila.
And I think you also have to know where you stand as a lawyer here, no? So, alam mong magdedepensa ka and imagine ang dami nagsalita for the prosecution pero sa defense ikaw lang. And with all the charges na binigay nila, so you have to stand your ground as a defense lawyer. You have to present your counter arguments sa kanilang mga ebidensya and argumento. So I think you really have to be smart, not only on the picture, but on the arguments.
Tsaka, partner, ang pinagtatanggol mo, siya mismo eh. Lumabas mismo sa sarili niyang bibig. Yung mga akusasyon laban sa kanya. So, I can imagine for a lawyer, for any lawyer, that's difficult.
And for a lawyer also, you know that while this is a case of Duterte, but you're also being tried here for as a lawyer and representative ng former President Duterte.
Kumbaga pati yung lawyer put to the test.
And na-judge na nga siya, di ba? Madaming tao na din. So, I think that's one thing. And from the lawyer stance, I think that he really has to stand strong, especially that marami din ang mga supporters ng kalaban, no?
Actually, napansin nga namin ni Ivan the past few days, si Attorney Kaufman seems very familiar na sa Philippine politics. Kasi parang yung sa opening statements pa lang niya, yung mga nababanggit niya, parang very particular to the Philippine
Even the
situation.
talk points.
Yes.
And yung narrative is, I mean, yung tinakbo ng kanyang opening statements.
And he has studied the case entirely. Not only on the storyline, but not only on the arguments, but the storyline. And he knows his audience, not only the court, but he also has supporters from the former president supporters. And hindi lang ito simple, no? So kung titingnan mo ang talking points, the arguments and all that, ang audience soundbites perfect for a supporter.
And very familiar. Parang indicative of how familiar he is with what's going on. Meron pa nga siya dun sa interview sa kanya kahapon, di ba sabi niya, kung imbitahin daw siya dito, di handa siyang makipag-usap kaya Undersecretary
Para
Claire
i-discuss
Castro.
daw yung interim release.
So talagang may palitan na sila. Exchange of statements already via media.
And yun nga, speaking of media, not only the media is being accused here by the defense, but also the role that media plays right now is very important, no? Especially that itong mga lumalabas sa hearing, mga reactions ng tao and all this, these are important also, no? Especially the public opinion right now is strong for both sides, no? And minsan tayo sa disinformation and misinformation.
Dean, let's talk about scenarios. Nakausap po si Dean sa unang hirit eh. Napag-usapan
Magkasama kayo
namin
kanina umaga?
No, the other day.
Sa araw naman. Okay.
Pag-usapan natin yung, should this go to trial? Are you expecting a long trial?
I'm expecting a long trial, especially that there are various incidences there to prove, for example, the systematic and widespread, no? So sa systematic and widespread concept pa lang ng elemento ng crimes against humanity, we are supposing na hindi lang ito isa, dalawa, para mag-prove na may system.
Actually,
and
49 incidents, I believe.
Yes.
Sa count 1. Sa count 1 pa lang yon. So, yung 49, i-discussion individually, ganun ba yun?
And I think kasi this will show the pattern. So, kung pattern ang ipipresent mo, so I think hindi lang isa or dalawa, but you have to prove the links here, no? So, that's the difficulty there. So, that's why kailangan i-present ang importante. At the same time, you have to be very conscious, baka mamaya makaligtaan mo ang missing link doon, no? Ang link mismo that would prove as to the pattern and the systematic and widespread.
Pag sinabi mong long trial, Dean, gaano katagal?
Ideally, based sa rules and sa number, and sa previous cases, no? I was looking at the previous cases, mga 3 years, 2 years, more than 2 years, 3 years or even more. So, siguro dito, since we will be starting, if ever matuloy, no, on the charges, for example, charge 1, siguro magsa-start pa siya in the 4th quarter.
So, later this year. No?
This year of 2026 or early pa ng 2027. So imagine na 2027, baka maabutan pa ng eleksyon.
At syempre kasi dito papasok yung paglabas ng mga testigo, di ba? And sabi nga nila, pagdating doon, I mean, kung gaano sila ka-stricto dito sa oras, pag witness na ang lumabas, hindi ka pwede maging stricto sa kanilang oras. You have to let them speak freely and for as long as they wish.
For as long as kina-clarify at kailangan ang statement nito, no? Para makuha ng court mismo ang katotohanan. Kasi remember that the witness here will be not only presenting kung ano ang gusto niya sabihin, but they will be subjected to cross-examination or even the courts can ask questions.
Tsaka, di ba, Dean, in the case of whether it's an acquittal or a conviction, ang pagkakaiba sa ICC, either the prosecution or the defense can make an appeal. Tama po ba?
So there are remedies here, no? So pwede silang mag-appeal, no? Nakita natin sa pre-trial pa lang, ang dami ng appeal, no? So every step may appeal process. Sa confirmation of charges lang walang appeal, pero there can be an appeal.
Na maski prosecution pwedeng mag-appeal. Okay.
So, halimbawa nga na acquit. So, in-appeal. Pending appeal, hindi pa rin pwedeng palayain ang akusado.
I think, sorry, it's on a case-to-case basis, I think, no? And sa halimbawa 3 years after, so we have to be siguro ang dami pang motions na gagawin doon on the release, no? And sana Tatay Digong will be strong to face all these challenges.
Pero, I mean, coming from the family themselves, parang hindi na sila umaasa na makakauwi pa raw
And there
ang
are-
dating Pangulo.
And there are many possibilities here because of his age and health condition. Maraming mga, of course, sa utak natin, maraming pwedeng mangyari. No?
Tapos din linawin din po natin, di ba? Nasa pre-trial pa lang tayo. So ibig sabihin, si former President Duterte sa ngayon, suspect pa lamang.
Suspect pa lang.
Oho.
No?
Pero-
Hindi pa siya formal case actually.
Hindi pa siya. So kapag halimbawa na-confirm any of the charges, siya ay magiging akusado.
Accused, yes.
Okay. So there's a difference between the suspect, the accused, and then eventually, syempre, kapag may ruling na either acquitted or convicted.
Yes, that's correct. That's why this time it's still the situation in the Philippines, no? Pagka na-confirm na ito ay prosecutor versus Duterte.
Aha,
So,
alright.
Dean, nagpapatuloy na ba?
Okay.
Okay.
Any
So,
minute. Parang mas mahaba yung break nila ngayon. No? Usually yung first break, 30 minutes. Ngayon, naging 40 minutes.
40 minutes daw. Tapos may delay pa, baka may mga kailangan. Ayan na. Hindi, no broadcast pa.
Okay.
11:30.
Maya-maya. So,
7 hours, diba? Ang difference.
At pagbalik nito, closing statements already of the prosecution.
Yes.
Tama po?
Yes.
Okay. And then after that, closing statements of the common legal representatives, and then break ulit, and then yung closing statements ng defense. Okay. Pag ganun po ba, pwede bang makipag-usap ang prosecution tsaka common legal representatives?
Kasi makita mo sa pwesto nila sa upuan,
sila yung
di ba?
magkakatibid, di ba?
So, pero hindi din sila pwedeng kung sa Pilipinas siguro yun na hearing, ang dami nating kwentuhan kahit prosecution guard. Pero doon, kita mo, they are behaved and kung saan sila nakapwesto, doon lang.
Kaya nga
Hindi pa din chumika.
Ito po, nagpapatuloy na ang confirmation of charges hearing sa ICC.
Please be seated. Veuillez vous asseoir.
Bonjour à tous.
Judge Motok, good morning once again. We will now move on to the party and participants' final statements. I would like to remind everyone that closing statements can only be used to respond to issues raised during the presentations, not to begin new arguments. So we will now be hearing from the prosecution, then from the legal representatives of victims until 12:30. At 1400 hours, we will hear from the defense. After that, we will begin the hearing on detention. Mr. Prosecutor, you may now proceed.
Good afternoon, or good morning, Madam President, Your Honors, and to everybody in the courtroom. Starting with what we heard today from my friend, it doesn't happen often in this case, but I'd like to thank him for his submissions, because everything he said, literally this morning, showed why this case should go to trial, and that we have met the standard of substantial grounds for confirmation. What my friend did today, going through these incidents, trying to pick them apart, that sounded like a closing argument after a trial. The types of issue he raised today and yesterday, well, in this incident, the first witness says X, the second witness says Y. That's what gets sorted out at trial. The witness that supports our charge is enough for the confirmation of the charges. Another example, he talked about police reports and that there has to be a presumption of regularity. You have to accept these as face value. Well, at trial, as we've stated in our brief, at trial we will show through witness testimony that these these police reports were often falsified. In addition, we'd make the point that during this period When my friend says, look at this police report, it says the victim had a gun. We say the gun was planted. That is what is for the judges at trial to sort out by hearing the witnesses. And we will also point out that during this period, when the reports came out, and Mr. Kaufman also talked about search warrants being issued, how could it be a crime if a search warrant is issued? That Mr. Duterte, as we made clear in our presentation, moved co-perpetrators from Davao to Manila and appointed them to high positions. So when he appoints the chief of police, and part of the chief of police's job is to kill thousands of people, it's not a surprise that the police reports don't reflect that. If they decide to murder Mr. Espinosa and Mr. Yap while they're held in jail, it's not surprised that that can be done when Mr. Duterte appoints the head of the Department of Justice. Similar, he talked about, again, I'll get to it, talked about neutralize, and how that is a neutral word and needs to be taken in context. I'll come to that a little bit later. But again, there's evidence in this case, some of which Mr. Jeremy went through in his presentation, that neutralize meant to kill. Whether he is correct, or whether we're able to prove it beyond reasonable doubt is another issue. Whether we're at substantial grounds is clear. We are. And I just say, again, responding to his argument about the documentation, that it's not unique to this case. In war crimes trials, crimes against humanity trials, where the very top leadership are the persons on trial, and when they're committing their crimes, they don't put it in writing often, let's go out and commit a crime. Mr. Kaufman will know this because we both worked together at the ICTY. During the trials for Srebrenica and the other Bosnian Serb army crimes, the VRS, every single order that turned out to be criminal, virtually every single order, had in the order from the General Mladic down the chain, respect the Geneva Conventions, treat prisoners of war properly, treat civilians properly in accord with the Geneva Conventions. That was in virtually every order, and it didn't mean anything. It was boilerplate as part of their cover-up. I'll move on to some of his points from yesterday now. He spoke at length in the beginning about Article 7.1 and an alleged problem or inconsistency with the Yale history case in our definition of the civilian population in this case. The law is very clear. All that Article 7.1 requires is that an attack is directed against any civilian population. That term, any civilian population in 7.1, is not limited to populations defined by nationality, ethnicity, or another distinguishing feature of that nature. It's a question of fact to be decided by the trial chamber. We have set this out, paragraphs 17 through 20 of our DCC. It is not particularly complicated. It is not blurry or ambiguous. We stated that alleged criminals in the Philippines are the civilian population, which are the object of the attack. That's a factual issue. So the position taken in the El History case, which is different, obviously completely, factually to this case, is irrelevant. Second, the issue in El History did not concern the definition of the civilian population. It was about the nexus requirement, under Article 7, and whether it is necessary for victims of the underlying acts or crimes against humanity themselves to be members of the population, it was a different issue completely. And we have defined the population in this case. That just reminds me of what he said today at one point. Oh, well, these victims weren't necessarily related to drugs or the war on drugs. Read our brief. Read the DCC. It makes it clear that it's criminals, including drug dealers, drug pushers, drug users. The incident I went through, incident 3, in my presentation on Monday, I made it clear the victims there in Davao were alleged thieves. That is why they were murdered by Mr. Duterte. Very quickly, he complained or spoke about the well, no, I'm going to skip that, Your Honor. It's not important. Moving on, he also made yesterday multiple comments that were inaccurate about the common plan alleged in the case. First, he said there was no direct evidence that even 2 of the co-perpetrators met in person to discuss the plan, the common plan. Legally, there's no requirement that they do so. However, factually, what he stated was incorrect. We have brought evidence of such meetings, and they're in our pre-confirmation brief. I won't go through it, but if you look at paragraph 27 and the items cited in footnote 135 of that paragraph, it sets it out. I'll come back now to the meaning of the term neutralize in the context of this case. It's open to interpretation in the abstract, but my friend, in trying to persuade Your Honors to take the view that neutralize didn't mean anything nefarious, quoted statement from Chief Ronald Bato de la Rosa, co-perpetrator de la Rosa, that neutralize did not mean to kill. That was a T006, page 31, lines 2 to 11. So he's been criticizing the credibility of our witnesses. Cites the police chief to say, the police chief who signed CMC 16, to say that neutralize is a neutral term that shouldn't be taken as showing any criminal intent. But we set out in our brief multiple witnesses for the mayoral period and for the presidential period who will testify that to neutralize means to kill. That's again set out in the brief, paragraphs 6 and 24. I'll read out just one example. This is ERN PHL OTP 000-15390-R01 at 0011, lines 345 to 346. Question of this insider witness. Okay, and the words eliminate and neutralize, what do they mean? Witness's answer, kill. You have to kill, whether it is a legitimate operation or not a police operation. So all of the dancing around about the term neutralize doesn't rise to the level where we would not be meeting our standard for confirmation today. One more example, my friend talked about it today. This is incident 13, in which the murder victims were Mayor Espinosa and Raul Yap. As we showed on Tuesday, Mr. Duterte, I won't play the video again, identified Espinosa as involved in drugs and said that he should be shot on sight and tracked down like a dog And Mr. Kaufman said, yes, but Mr. Espinosa surrendered. And then tried to portray the murder of Espinosa in a jail cell as legitimate self-defense. In a jail cell, there's a shootout. The telling point here, as we said on Tuesday, transcript 5, page 10, lines 9 to 10. In the PRRD list, it was brought up, I believe, in the presentation. These two victims of Incident 13, they are noted as neutralized on the list, not on the day they are arrested, not on the day they go to jail. They're marked neutralized on the days they're killed. So they were neutralized at the time they were murdered, per Mr. Duterte's government at that time. As I said in my submissions on Monday, right from the beginning, we acknowledge throughout his speeches, Mr. Duterte and some of his co-perpetrators, I used the term allies on Monday, referred to shoot to kill and self-defense, and that they sprinkled in these references to due process and legality. The evidence shows, as I said, that was only to build a veneer of legality, to create an impression of legality, and to give his lawyers something to say when this day came. And that's exactly what has happened. Mr. Kaufman has gone through, repeated these, when he can, as some kind of mantra that supposedly exculpates his client. It does not. As I said, this is the lawyer, Duterte, trying to build in a defense in case he was ever held to account for his crimes. The facts can't be denied by these sprinklings. He ran a death squad in Davao that he created. He ran it for over 20 years before he became president. His promise was to kill thousands, and he did. So it doesn't matter how many times he tried to throw in a caveat. And again, as I said, this is not uncommon in crimes committed by powerful figures. They try to build in a defense. One point Mr. Kaufman made yesterday, again, showing why this case is ready to go to trial and should not be dismissed. He refers to witnesses providing what he says is exculpatory evidence. He misstated these witnesses by saying they were OTP witnesses. They're not. We're not relying on them, but their statements are disclosed. We found these witnesses and interviewed them through the process that he portrays as somehow corrupt or biased or I don't know what. They provided exculpatory information, and we disclosed it. And that is somehow meant to say that this case should not go to confirmation? I mean, these witnesses are interviewed under 55-2. They're as suspects. Is it really unusual that when you're interviewing somebody who was involved in the crimes, that they say, I didn't do it? Does that mean that this case should not go to trial? Again, we go to trial. He can call those witnesses. The trial judges will listen to his witnesses, listen to the OTP witnesses, and then decide if we've proven our case beyond reasonable doubt or not. I'll speed up a bit, Your Honors, because I don't want to go over my time. He made a small point I just have to respond to, making a call. Why aren't there more investigations? Why aren't crimes being investigated now in the Philippines? Well, his client prevented all that by withdrawing the Philippines from the Rome Statute when he thought he might be prosecuted, thereby ensuring that we would not have jurisdiction after a certain period. Another point. My friend is trying to kind of have it both ways on how Your Honors should treat Mr. Duterte's utterances, his speeches, his words. On day 1, T0004 at page 30, lines 18 to 19, my friend said, Duterte's word was his word and the people knew it, end quote. Yesterday, worried about his client's confessions, that's what they are, he said, quote, this is at T0006, page 7, lines 5 to 7. He said, quote, one cannot rely on anything coming out of Mr. Duterte's mouth. All right, that's good to know if he ever decides to testify, and for his representations on interim release, that you can't trust a word that comes out of his mouth. But beyond that, as I went through on Monday, 3 times under oath, Mr. Duterte said in committee hearings, I have a death squad. Is Mr. Kaufman saying that his client is a liar and a perjurer who has no problem lying under oath? Limited use statements. I won't go through all the, frankly, nonsense that we heard about limited use statements. What I want to make clear, he tried to create an impression which is just not true. Not one witness has been granted immunity in this case. None. There is no such thing as virtual immunity or whatever he called it. He said something similar today. It's standard practice to use these statements when interviewing suspects under 55-2 who have rights, and they do not grant immunity. It just means the statement can't be used against that particular witness. And if they lie during those statements to us, to the OTP, then the agreement is void and they can be prosecuted. And his suggestion somehow that we should not interview the direct killers, Mr. Duterte's killers at the bottom of the pyramid, they shouldn't be interviewed? That's clinically insane from a prosecution point of view. And of course, some of those persons will get limited use statements if their lawyers request them. And finally, we're here in this court to prosecute the most responsible, and the most responsible is his client, former President Duterte, not the people on the ground who committed the killings. They are responsible, but they are not the most responsible. And unlike his client, the ones who have come forward have shown remorse for what they have done. His client, contrary to everything he said in the last few days, the last 3.5 hours, repeatedly admitted committing the crimes we're here for. His killings of his own people, the Filipino people. We saw some of those in our presentations. I'm sorry, I missed one point. He said there was no linkage of the incidents to Mr. Duterte. He said, my friend, not one incident where the direct order came from Mr. Duterte for one of these incidents. Well, he should look at incident 1 of the ones we have charged. And I'm afraid I don't have my site because I skipped around. But in that incident, the evidence shows that we have a witness who heard Mr. Duterte on the phone, who heard that the order came from Superman, his client's code name and nickname. Mr. Jeremy is helping me. It's at para 89 of our brief, Your Honors. So that was wrong. That is, I just wanted to reply. He said that several times. It's not true. Back to Mr. Duterte. He's proud of his killings. He wants to be remembered for them. Decades of murdering his own people, murdering the children of the Philippines. And he claims that he did it all for his country. He doesn't deny it. He says, as I said early on, it's a necessary evil. It's for the greater good. Doesn't matter how many kids I have to kill. I'll clean up the Philippines. Now I want to play a clip, Your Honors, if we can do that, James. This is, you'll see the beginning. I played just a few seconds of it. I'm going to play more of it now, about 2.5 minutes.
Na ginawa ko man ang lahat sa panahon ko para may konting katahimikan at mapayapa ang buhay ng Pilipino. Ang problema nito, ewan ko kung ang tingin ng ako'y raw yung o ganito na lang. Ito ganito na lang. O sabi ko, assuming na totoo, totoo talaga yung naririnig ninyo. Bakit ko ginawa yan? Para sa sarili ko? Para sa pamilya ko? Para sa inyo at ang inyong mga anak sa ating bayan. Ang higain ko na lang sa inyo, total, kung ganito man talaga ang swerte ko sa buhay, okay lang, tatanggapin ko yan. Eh, wala tayong
Excuse
magawa
me, counsel, you have 5 minutes left.
hulihin tayo kung ikulong tayo. Kaya lang, in the meantime, mag-contribute kayo, baski $5, $10, para paglabas ko sa prisuhan, pagawaan ninyo akong monumento katabi ni Rizal. Si Rizal may hawak na libro eh. Akin.
Okay, what do we see there? This is essentially Mr. Duterte's farewell speech. It was made on 9 March last year, 3 days before, as he says, he was apprehended. He was not going to surrender, apprehended and surrendered to The Hague. What did we see there? First, I won't repeat it, shows total, utter contempt for this court. Second, referring to, quote, his sin, end quote, he says, assuming that all the talk you hear is true, assuming it's all true, why did I do that? What is the talk that's all true? It's obvious. After he says that, he says, problem is, they think I'm the one who, and the crowd cheers. Again, he doesn't say it out loud, because he knows he's on video, he doesn't want the words there, assuming I'm the one who killed all these people. So he makes a little motion, crowd goes wild, and he smiles, because he likes that after he's made that statement. What innocent person has ever said, assuming I committed all these murders, it was for a really good reason? That's what they would like you to believe, that he doesn't mean it. And he says he did it not for himself, not for his family, but for the Filipino people, and it's obvious what he's talking about. He's talking about the murders. Again, the ends justify the means. Again, for him, the murders are a necessary evil for the greater good, as we heard right at the beginning of his career when he's teaching police officers to plant evidence. The end of that video, what does he ask for? He says, I might go to jail, what can we do? But when I get out, contribute money so there can be a monument erected of him when he's released from jail. And he describes what he wants that monument to be to himself, former President Duterte. A statue, not holding a book like the national hero Jose Rizal, but holding a gun. 3 days before his transfer to The Hague, this old man, you could see it still up there. What does he want to be remembered as? The man with the gun. And he's just taken credit for killing his own people. time for him to take responsibility for these crimes he brags about and glories in. Can we go to the next one quickly? I think I got about 3 minutes. James. This is tab 146.2. It's a quote from a speech on August 16th, 2017. What did he say? Quote, "I know I will have my own downfall. I cannot be president forever. I know that they will demand to answer for all this dead." End quote. And he was right when he spoke those words. He must answer for the dead. The victims demand it, justice demands it, and for purposes of confirmation, the evidence demands it. We have proven it to the level for this to be bound over for trial. We ask you to do that, Your Honors. Thank you.
Merci beaucoup, Monsieur
Thank you very much, Mr. Nichols. We will now go to the closing statements of the common legal representatives of victims. You have up to 12:30. Maître Andres will present the closing statements. George Motok, you have the floor, Mr. Andres.
Your Honors, good noon. In our closing statement, the common legal representative for victims will first rebut the defense submissions. Then we will provide the larger context why the confirmation of the charges against Mr. Rodrigo Duterte is vital for the victims, especially in relation to their communities and the Filipino nation. Your Honors, listening to the defense submissions on the merits yesterday and today was to me like listening to the parable of the elephant, wherein they want us to see only the parts of the elephant: the trunk, the tusk, the ears, the head, but not the whole of the elephant. We must look at the whole context. Madam President and Your Honors, it's also my duty as the common legal representative for victims to express the views and concerns of the victims. As they're watching these proceedings, they have stated, and when they heard the defense effectively submitting that the chamber should ignore the systematicity and the widespread nature of the attack, it's like their murdered loved ones are being murdered again. Having conveyed that as my duty, we will address the defense submissions in seriatim with 10 rebuttals. First, on Mr. Rodrigo Duterte's speech, defense argued yesterday that, and I quote, "relying on the former president's speeches as a means of proving criminal intent is impossible." I am quoting the transcript of yesterday at page 4, lines 5 to 6. But the victims convey that the Philippine context is vital in knowing and understanding the criminal intent and impact of Mr. Duterte's speeches. Under the Philippine Constitution, the executive power shall be vested in the President of the Philippines. Whatever the President publicly states is policy. And in the Philippine cultural context, when there is strong respect for those in government positions, especially the President, as head of state and as head of government, the words of the President is to be obeyed, no matter what. Especially for Mr. Duterte, he has portrayed himself as a man of his word. The defense even emphasized, and the prosecution also referred to this last Monday, that, and I quote the defense, "For President Rudy, his word was his word, and the people knew it." End of quote. And that's the transcript of Monday, page 30, lines 18 to 19. The defense even stated that, and I quote, Rodrigo Duterte was and will always remain a unique phenomenon, end of quote, referring to the transcript last Monday at page 30, line 14. Mr. Duterte was and is indeed a unique phenomenon in the public and vulgar way in which he uses words to dehumanize the victims of his anti-drug campaign, to excuse their murder, to shape the Filipino psyche to his murderous rhetoric, and to predispose the government agencies under his presidency to follow his words as presidential policy and as orders. And the records show that every time Mr. Duterte exhorts the killing, the murders of alleged drug users, people are murdered all over the Philippines. To our second rebuttal, we rebut the defense legal theory in its Thursday submissions vis-a-vis count 1, which contains 9 incidents of murder during the mayoral period of the suspect. The defense argues concerning count 1 that this is allegedly, and I quote, hardly widespread. And I'm quoting the transcript of 26 February 2026 at page 6, line 23. We strongly disagree. Widespread refers to the scale of the attack. Courts and commentators interpret it through several indicators, such as the large number of victims, the killings, the deportations, rapes, or other acts affecting many people. Geographical spread, wherein the violence occurs across multiple towns, regions, or a broad area. The long duration, the sustained attacks over time, rather than isolated incidents. The mass impact on the civilian population. The attack affects the population as a whole, not just a few individuals. The focus is on the quantitative magnitude. The attack is large in scope or effect. Systematic, on the other hand, refers to the organized nature of the attack. It is about how the violence is carried out, where there is pattern or methodical plan, repeated similar acts showing coordination, organizational policy or approval, wherein there's the involvement of the state or organizational structures, use of resources, logistics, weapons, or personnel deployed in an organized way. Regularity in pattern, not random or spontaneous, but structured. This is a qualitative criterion. The attack is carried out according to a plan, policy, or organized pattern. In the Nataganda case, the trial chamber has held in 2019 that, and I quote, the assessment of whether the attack is widespread is neither exclusively quantitative nor geographical, but must be carried out on the basis of all the relevant facts of the case. End of quote. In fact, in Nataganda, the trial chamber once again emphasized that, and I quote, the term systematic reflects the organized nature of the acts of violence and the improbability of their random occurrence. It refers to the existence of patterns of crimes evidenced by non-accidental repetition of similar conduct on a regular basis. End of quote. In reviewing the evidence in the record of this case, the only reasonable conclusion is that the attack against the specific group within the civilian population, individuals perceived as linked to drug crimes, was widespread and systematic. Contrary to the statistics shown by the defense, there is ample evidence about the high number of murders in this case. Third, on the death rate. Based on the 2019 trial chamber judgment on Nataganda, there is no requisite death rate in order to prove crimes against humanity for murder. Fourth, we rebut the defense legal theory in its Thursday submissions, which refer to the chapeau elements of Article 7 of the statute. The defense argues, inter alia, that allegedly, and I quote, this policy did not and could not constitute an attack directed against a clearly definable civilian population, end of quote. And I'm referring to the transcript of yesterday at page 10, lines 16 to 17. We disagree. Since the chapeau elements of Article 7 of the statute provides for, and I quote, widespread or systematic attack directed against any civilian population, end of quote. As the element of crimes provide, and I quote, attack directed against a civilian population in this context, elements is understood to mean a course of conduct involving the multiple commission of acts referred to in Article 7, Paragraph 1 of the statute against any civilian population, pursuant to or in furtherance of a state or organizational policy to commit such attack, end of quote. It is also essential to note that on the targeting of a specific category of civilian population, the pretrial chamber has held in the situation in the Republic of Kenya that, and I quote, the chamber takes into account the information relevant to the status of the victims, their ethnic or political affiliation, as well as the methods used during the attacks, end of quote. The same pretrial chamber in the situation in the Republic of Kenya further held that, and I quote, the issue of whether an act was committed as part of a widespread or systematic attack needs to be analyzed on a case-by-case basis with regard to each particular act, end of quote. Applying this legal principle to the case at hand, we have argued that the evidence on the record unequivocally shows individuals targeted by Mr. Duterte's anti-drug campaign overwhelmingly came from impoverished communities where social mobility is limited and opportunities are scarce. The same type of people in the same type of communities using the same modus operandi were targeted by Mr. Duterte's anti-drug campaign. People from the vulnerable communities, the poor and marginalized, especially in urban, informal settlements marked by high levels of poverty. Thus, we have shown last Tuesday, Your Honors, that Mr. Duterte's anti-drug campaign was really a war against the poor. Consequently, the document containing the charges was not, and I quote, muddled, end of quote, as argued by the defense in the transcript of yesterday at page 8, line 8. Rather, consistent with the chapeau element under Article 7 of the statute, the DCC in paragraph 17 refers to the, and I quote, widespread and systematic attack against the civilian population in the Philippines, end of quote, referring to paragraph 17 in the DCC. While the DCC in paragraph 20 specifies that this attack was against, and I quote, alleged criminals in the Philippines who were perceived or alleged to be involved in drug-related, including production, sale, and use, and other crimes such as theft and murder, end of quote, referring to paragraph 20 of the DCC. The latter, in paragraph 20, is merely a subset of the former in paragraph 17 of the DCC. Again, this framing in paragraph 20 of the DCC is synonymous with the framing in the situation in the Republic of Kenya, wherein police violence targeted perceived gang members. Fifth, the defense yesterday referred to Philippine Supreme Court issuances And I quote, the defense inter alia referred to, and I quote, Supreme Court of the Philippines in petitions challenging aspects of the anti-drug campaign, end of quote. Referring to transcript of yesterday at page 26, lines 10 to 11. Madam President, Your Honors, I and Attorney Buturian are familiar with these petitions referred to by the defense because we were actually the petitioners' counsels in those petitions. And we actually argued before the Philippine Supreme Court last 2017 on this issue. Nevertheless, the defense critiqued the prosecution's manner of using the quote, Duterte's administration's year-end report for 2017, referring to PHL OTP 0003-3355 or tab 139 for the defense. Specifically, the defense argued that vis-a-vis the, and I quote, deaths of 3,967 drug personalities, end of quote, that, and I quote, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, end of quote. And I'm referring to the transcript of yesterday at page 32, line 1. Nevertheless, Your Honor, the same Supreme Court decision or resolutions referenced by the defense has stated with respect to those 3,967 drug personalities who died in the anti-drug operations from July 1, 2016 to November 27, 2017, as indicative of the state policy of extrajudicial killings under the Duterte administration. As held by the Philippine Supreme Court in its notice of resolution dated April 3, 2018, which is PHL-OTP-003-3058, and which is tab 112 for the defense at pages 46. I quote the Philippine Supreme Court. Aside from the OSG's submissions in the present cases, we take judicial notice of the Duterte administration's 2017 year-end report, where deaths in cases related to illegal drugs and the internal cleansing conducted within the Philippine National Police are touted as accomplishments. And Your Honor, the next sentence is emphasized in the original resolution. The government's inclusion of these deaths among its other accomplishments may lead to the inference that these are state-sponsored killings. In the section Fighting Illegal Drugs and subsection Real Numbers, we find the following figures. And Your Honor, I will just quote the one that was in emphasis in the resolution. 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017. As well as 16,355 homicide cases under investigation from July 1, 2016 to September 27, 2017. 6. The defense referenced, again, the same Philippine Supreme Court resolution. But that same resolution held that nothing else to substantiate the OSG's claim of legitimate police operations. And I quote that specific portion in the Philippine Supreme Court's notice of resolution dated April 3, 2018, which is tab 112 for the defense at page 47. The Supreme Court held that, and I quote, "Apart from these numbers and their bare allegations, there is nothing else to substantiate the OSG's claim of legitimate police operations. The lack of any submission of the required information and documents leads this court to believe that there is no basis to the OSG's claim. It is Hornbook doctrine that bare allegations unsubstantiated by evidence are not equivalent to proof, i.e., mere allegations are not evidence." End of quote. Seventh, Your Honor. Again, in reference to the same Supreme Court resolution referenced by the defense, the Supreme Court also held there that the PNP cannot claim presumption of regularity on deaths occurring during police operations. Your Honor, I will quote that specific portion of the notice of resolution dated April 3, 2018, which is tab 112 for the defense at pages 47 to 48. The Supreme Court held, and I quote, "The PNP cannot claim the presumption of regularity in official functions because deaths are not supposed to occur during any of their operations. The presumption of regularity in the performance of official duty must be seen in the context of an existing rule of law or statute authorizing the performance of an act or duty or prescribing a procedure in the performance thereof. The presumption also cannot prevail over positive averments concerning violation of the constitutional rights of the accused." And Your Honor, in the next paragraph, all of it is being emphasized in the original. And I quote the emphasized portions. "The Duterte administration's 2017 year-end report states that there were 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017, and 16,355 homicide cases under investigation from July 1, 2016 to September 27, 2017. This is a total of 20,322 deaths during the Duterte administration's anti-drug war from July 1, 2016 to November 2017, or an average of 39.46 deaths every day. This court wants to know why so many deaths happened, as expressly reported under the section Fighting Illegal Drugs of the Duterte administration's 2017 year-end report. Next, Your Honor. The Philippine Constitution provides for the right of life in Article 3. Therefore, because of that right to life, there is actually no presumption of regularity if a person is killed during a police operation. And actually, the presumption is reversed. It's actually the onus probandi on the police to prove that his or her actions were within the lawful requisites of self-defense. In fact, Rule 15.4 of the 2013 revised PNP operational procedures mandates the proprio motu investigations if death occurs during a police operation. However, Your Honors, despite the at least 3,967 deaths under anti-drug operations, there was no proprio motu investigations for all of these deaths. 8, Your Honor. The defense yesterday referred to the Philippine National Police Operational Procedural Manual issued in 2021. But the same was irrelevant and a non sequitur with respect to how the PNP construed and applied the word neutralize under CMC 16-2016, from July 1, 2016 until March 16, 2019, which is within the temporal jurisdiction of the court. The defense recognizes that the same Philippine National Police Operation Procedural Manual was published in 2021, specifically in September 2021. And it was already after the temporal jurisdiction of this court. Hence, it's irrelevant with respect to this case. Ninth, the defense asserted that purportedly the Duterte's administration is, and I quote, intolerant for rotten apple police officers, end of quote. That's in the transcript of yesterday at page 32, line 20 to 21. This is not true, Your Honors. Mr. Duterte's administration has not criminally prosecuted the police officers responsible for the government-recognized deaths of at least 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017. In fact, the undisputed fact in this case is that the Philippines only investigated at
Excuse me, counsel. You have 5 minutes left.
At most 302 cases. And I refer to the February 27, January 26, 2023 decision of this chamber on the authorization pursuant to Article 18, Paragraph 2 of the statute to resume the investigation. The court here, the chamber has held, the chamber observes that at the time of the prosecution's request, the DOJ panel had referred to the NBI for investigation in case build-up 302 cases consisting of 52 PNP IAS cases, the non-Laban cases, and 250 NPS cases. And in paragraph 39, from the information before the chamber, it therefore appears that the DOJ panel review does not amount to relevant investigations within the meaning of Articles 17 and 18 of the statute. Moreover, the number of cases reviewed by the DOJ panel, namely 302, is very low when compared with the estimated number of killings that allegedly occurred in the context of war on drugs operations. Res ipsa loquitur. Mr. Duterte's administration has not criminally prosecuted the police officers responsible for these deaths. Last, Your Honor. The defense erred when it conflated Ms. Paulina Macida's statement that Rodrigo Duterte failed to prevent or punish with the theory that the prosecution has not charged command responsibility under Article 28. Ms. Macida's comment on the fact that Mr. Duterte did not take steps to investigate and prosecute was pronounced in the context of her submissions on the fact that encouragement of killings through public statements by Mr. Duterte sent a clear message that those responsible need not fear accountability and can act with impunity. Said comment cannot be extrapolated from that context, as the defense did yesterday. We do not suggest that Mr. Duterte should be liable under Article 28 of the statute. We maintain that there is ample evidence for confirming the mode of liability under Article 25(3)(a) as pleaded by the prosecution. Also, we want to emphasize, Your Honors, that there were indeed children murdered systematically under the charges that are being held against Mr. Duterte, Your Honor. And they are not mere collateral damage. In conclusion, the victims submit that the defense has not blemished the prosecution legal theory and evidence as provided in the document containing the charges and the pre-confirmation brief. The victims submit that the prosecution presented sufficient evidence to establish substantial grounds to believe that Mr. Rodrigo Roa Duterte committed each of the crimes charged. Consequently, all charges should be confirmed, and Mr. Rodrigo Roa Duterte committed to trial. Lastly, Your Honor, Your Honor, the victims want these charges to be confirmed because they want to be reintegrated to their communities, because they are still in the shadows of fake news, of fear and of threats from Mr. Duterte's supporters. Hence, it's important, Your Honor, that all of these charges be confirmed against Mr. Duterte so that the victims of these crimes will be taken out of the shadow of darkness into the light of truth and justice. Because in the end, Your Honors, the victims, they're also created in the image of God, and they also believe that the God of the universe is the God of justice. Madam President, Your Honors, thank you for your kind attention. This ends the presentation, the closing statement of the Common Legal Representative for Victims. May it please the Chamber.
Judge Motok. Thank you very much, Mr. Andres. We will now take our break and resume with the final submissions of the defense at 1400 hours. The hearing is suspended.
At mga kapuso, atin pong narinig ang closing statements ng prosecution at sinundan ng closing statement naman ng Common Legal Representative for the Victims. Initial impressions, Professor. Dean, sorry.
It's okay. Ang nakita natin dito, how the prosecution and, of course, the victims have emphasized on the strength of the charges. That's why one of the questions repeated by the prosecution and the victims is, should the case proceed with confirmation? So, makita natin dito that the prosecution has summarized its arguments in relation to, number one, on the direct attack, on the issue on civilian population, the question on neutralization, also those statements of Duterte as being under oath, and also that he is proud as to the killings, especially with the video that was presented before the arrest.
Paano niyo ikukumpara din yung presentation or yung closing statements ng prosecution and the common legal representatives?
Makita natin doon that they are actually connected, no? And in fact, we cannot also separate the victims here, no? That's why we saw in the victim side the humanization of all these accusations and the charges. While we speak about the law on the part of the prosecution, here we are presenting the humanity side, that there are people who are victims. In fact, sinabi niya that there are even children murdered actually. And this, sinasabi na ang operational reality is this, that there are deaths, children, and also even as to the questions on the operations of the police. I like the idea on how the victims presented their arguments because siyempre sinabi niya 10 points. And these 10 points were clearly said, especially that we have the Filipino presenting
using
that.
direct quotes from the defense.
Yes. And nakita din natin dito how the operations in the Philippines was viewed, the system of law and justice. In fact, we have exposed the Supreme Court also in the recent 2 days, no? And dito napakita na the Supreme Court even recognized, no, that the PNP cannot be presumed to be performing their functions on a regular duty, no? Presumption of regularity, because there are deaths. And how can you explain the death here? We have the constitutional provision on the right to life. We have no death penalty as of this time. So why, no? And also the statements of the victims here really supported the charges, especially on its 10 rebuttals on the impact of the speeches, on the widespread attack, the death rates, the war against the poor, and the statistics. The statistics here are very glaring in a sense that the Duterte administration, in fact, no, ang sinasabi dito na there were actually 20,000 or more than 20,000 plus deaths, and all these issues are supported by records. And also the questions on the ilang kaso ba ang na prosecute natin dito, and there are no prosecutions on on many of these cases, no? And the last one, which is a plea to the emotion, particularly of the people in the Philippines, as to the call for reintegration of the victims who are said to be in the shadows of fake news, and that we wanted to see the light of the day, consistent with their storytelling from the very start, that this is the last boat of justice for them.
Tsaka yun na parang continuation ng opening statement nila na itong Duterte clones are, I mean, they pose danger to the victims. This time, ang pandulo ni Attorney Andres, hindi lamang naman justice ang hinahabol natin dito, but reintegration to their communities because to this day, they are under threat from Duterte supporters.
Dean, kanina, kasi nabanggit niyo yung the play to emotions, di ba? Parang importante na gawin ito, lalo na nung common legal representatives, kasi nga ang kinakatawa nila yung mga biktima mismo. Napansin ko lang, nabanggit ko to siya habang naka-break kasi si Jeremy Nichols for the prosecution, nagpalabas siya, pinalabas niya muli yung video nung speech ni Pangulong Duterte nung siya ay nasa Hong Kong. Tinawag niya itong farewell speech ni President Duterte, yung mga sinasabi niya na parang ikukulong ako, ganyan. Tapos, pero napansin ko, parang yung defense, all throughout, they were quoting speeches, but they never played any of the videos of President Duterte. Sa tingin niyo po ba, sadya ito? Bahagi ba yun ng strategiya din?
So we have to take note also that the defense, if they will present counter videos, isang incident lang naman yun. Halimbawa, sa speech doon sa Hong Kong, so the same video, that will prove also, while we deny some parts, but there are also parts that would show that indeed may movement, nakuha-kuha nga ng prosecution yung sound effects, no? And these are items na hindi pwede ma-deny, no? And while they can deny based on the statements and pero the videos can speak for themselves. In fact, sabi nga natin kanina, narinig natin, the video can speak for itself.
Before we go to the individual issues na sinagot ni Prosecutor Nichols, pambungad pa lang niya, yung mga lahat ng sinabi ng depensa are precisely the same reason why we should go to trial. Parang nandun siya sa, we have achieved the bare minimum, so we should go to trial. Halimbawa, yung sinasabi niya, yung his word was his word and people knew it. Basically, ang ginagamit din niyang argument ay yung mga mismong sinasabi ni Attorney Kaufman. Pero yun nga, one cannot trust the words coming out of his mouth because 3 times during the House committee hearing, he lied under oath daw. So ito yung mga back to you moments ni Prosecutor Nichols.
Yes, and this was supported by the statement of the victims when saying about the Philippine Constitution and also the respect to the executive branch, the President. Ang sabi nga dito, his word is holy. No, especially to the administration, and also here the president has the power, and every statement that he gives is a policy.
Yes.
Dean, kasi dun sa yung mga sinabi ni Attorney Nichols, no, parang yung isa sa mga napansin ko, yung sabi niya na his argument was, i-expect talaga natin na sasabihin ng defense na sinabi niya, hindi niya ginawa. Kasi saan ka daw naman makakita na akusado na sasabihin na, ginawa ko talaga yun.
In writing or put it in writing.
Putting it in writing. Tapos sabi niya, well, you know, this is happening, si former President Duterte, kaya naman niya tinanggal ang Pilipinas sa Rome Statute dahil tingin niya, parang alam na niya na dadalhin na siya sa korte dito sa ICC. Parang, kumbaga, parang it's their version ba of discrediting the witness? Kasi if the defense was discrediting the witnesses, ito ba yung version of discrediting the suspect?
We know that this is the rebuttal stage already, no? So sinabi ng defense that these are baseless, walang ebidensya dito. But the one single incident of death, halimbawa, or one single incident of statement or speech of Duterte can already destroy the statement that there is no single witness, there is no single evidence that could prove to this according to the defense. But presenting just one can already destroy the defense, right?
So yun nga yung sinasabi natin, going back to yung just substantial grounds. Yun ang hinahanap natin.
Yun ang pinush extensively ng closing statement ng prosecution. Whereas yung sa victims naman, mas detalyado eh. punto por punto, direct quotes, at talagang dinedebunk nila yung kung naman yung ginawang claim
Listahan,
ni Attorney
no?
Kaufman.
May 10 rebuttals.
Oo,
no?
10 rebuttals.
10 rebuttals, and really good because it was Attorney Andres who was presenting that with conviction, with knowledge on how the Philippine system works, no, even the Constitution, no.
And especially, sila mismo pala yung nag-file ng petition questioning the war on drugs before the Supreme Court in 2017.
Yes, that's correct.
Kaya he has a very intimate knowledge of that particular petition and how it
And their
turned
attention
out.
to details here, even the graphs presented countering the 3% allegations there, no? Not the same report, no? But these are confronted by the reality, the operational reality nga sabi nila, and the number of death, the number of persons prosecuted, or the zero number of prosecution on this side can really affirm some of the charges, or the charges here, especially on the deaths or EJK deaths, no. And notable also dito yung mga inisa-isa yung the death rates, the number of death rates is it doesn't require that dapat 1,000 ba, dapat 500,000. So it's irrelevant, no. So ang death rate, the fact that there are death and consistent with the pattern and the policy, then that would prove. And what we have here, the requirement is simply beyond speculation, no. So there is evidence.
Isa rin sa napansin ko din, no, yung pagbanggit ni Attorney Gilbert Andres doon sa mga naging talumpati or yung speeches ni former President Duterte. Kasi sabi nga nung depensa, hindi naman pwede kasing aasa lang tayo sa mga naging speech ni Pangulong Duterte. Kasi sabi niya, hindi naman porket sinabi ito ng Pangulo, ibig sabihin, inuutos na niya yung pagpapatay, ganyan. Pero ang sabi ni Attorney Gilbert Andres, mahalaga na intindihin natin to in the Philippine context. Kasi sa Pilipinas, kapag sinabi ito ng isang person in position of power, ito parang utos na rin. Tama po ba yun? That it's very
cultural
different in the Philippine context.
So we have to take this using the strong cultural context in the Philippines by proceeding further sa statements niya and how people listen to him. And whatever word that he speaks would be policy, especially for the law enforcement. And he has a strong support from the PNP, for example, with Bato de la Rosa and others there. And these are presidential policies, ang sabi ni Attorney Andres. No?
At ito'y kapangyarihan na iginawad sa Pangulo ng Konstitusyon.
And yes, under the Constitution, ito ang powers ng presidente, and he has support. And the administration and the government system should comply with whatever statement that he says, because he is the president.
So, maituturing ba itong malakas na argumento pagdating sa ICC?
I would
Cultural
say
context?
it is an invitation for the judges to look into the strong cultural context of this case. That we have to look at this in not just in the elements and also the actions as to how the speeches were given, no. So tingnan natin dito kasi like the speeches are not just one or two, but from the time that he was president up to the end or before his arrest, consistent ang statements that there is a strong conviction to do this and that, and the people would follow.
Alright, Dean, himayin pa natin ito mamaya. Pero sa ngayon, makibalita muna tayo kay Rafi Tima na nasa pagtitipon ng mga kaanak ng mga EJK victims. Rafi, nakakapag-monitor ba yung mga kaanak ng mga EJK victims?
Gusto kong maiyak sa tuwa. Kung magkakaroon ka ng...
Piyesa ngayon na nagsasalita itong kaanak ng mga namatay noong panahon ng war on drugs matapos itong presentasyon ng prosecution doon sa kanilang rebuttal kanina. Nagpalakpakan Pia itong mga kaanak ng mga biktima na narito sa kanilang group watch nung ilatag ni Attorney Andres yung kanilang argumento at niribat niya yung iba sa mga argumento ng depensa. At ngayon ay nagpapatuloy nga itong pagsasalita nila. Isa sa kanilang mga sentimento, Pia, ay napakadami daw nila mga bashers ngayon sa social media. At dumami raw ito nung magsimula itong confirmation of charges hearing. At ang sinasabi ay deserve nila na mamatay yung kanilang mga kaanak dahil sila ay mga addict. Ginigiit ng mga narito na hindi naman talaga involved sa droga, yung inalan ng mga kaanak o kaya naman ay simple user lamang yung kanilang mga kaanak at may problema sa addiction na hindi dapat sila pinapatay. So, ngayon ay nagpapatuloy ko itong kanilang pagbibigay ng mensahe habang hinihintay yung resumption nitong pagdinig sa The Hague. Pia?
Alright, Rafi, so habang nagpapatuloy ang kanilang programa dyan, inaasahan ba na tatapusin nila hanggang sa hearing pa doon sa detention charges?
Para isara ang programa natin, tinatawagan ko po si Cristina Palamay, Secretary General ng Karapatan.
Alright, Rafi, narinig mo kami? Alright, mukhang nagkakaproblema tayo sa ating linya ng komunikasyon. Balikan natin mamaya si Rafi kasi ongoing pa yung programa ng ilan sa mga biktima or mga kaanak ng mga biktima ng extrajudicial killings.
Pero
Diyan po,
mahirap yung sitwasyon ng pamilya, yung kaanak ng mga biktima. No? Parang ikaw na itong namatayan, ikaw pa itong binabash.
Oo.
Kasi tulad na nabanggit ni Rafi, di ba? Matinding bashing, lalo na ngayon, ongoing ang confirmation of charges hearing, naglalabasan ulit yung mga narration, how thousands were murdered. Tapos, itong depensa, may, of course, defense lawyer siya, sasabihin niya lahat ng pwede makatulong sa kliyente niya, pero may pagmamaliit, sabi ng mga biktima, di ba? Pamilya ng mga biktima. Parang minamaliit yung bilang, minamaliit yung karanasan namin, parang nanlaban daw kasi, etc. Basically, those who died deserved it. Parang ganun, justified ang killing sa kanila. In the past, attorney, may alam ka bang ganitong similar case na former head of state stands on trial, pero yung mga biktima niya, sila pang nakakatanggap ng ganitong klaseng persecution?
Yes, especially kasi for several times no na mga kaso no we have halimbawa ang mga recent cases lang na decided by the ICC ang victims. That's why there is this provision no sa pag-protect sa mga biktima no. They even have relocation benefits just in case kasi if ever they are in a state where there is an authoritarian government and the government is using its power, so saan sila ngayon pupunta no. So that's why if you look at the benefits, not only the not so-called benefits but probably help and support that will be given by the International Criminal Court would vary from not only on the relocation but even as to their protection and that would come in so many ways.
I think sa punto ito, no, parang at least para sa atin dito sa Pilipinas, nagkakaroon tayo ng mas malalim na appreciation for the International Criminal Court. Kasi di ba dati parang maririnig mo ICC, The Hague, International Court of Arbitration. Pero hindi natin talaga alam kung ano nga ba talaga ang ginagawa nila at nagagawa nila para sa iba't ibang bansa, di ba, in the international community.
Kaya ang sinasabi natin, kasi for an international law student, even sa mga lawyers natin, parang abstract ang international law.
Yes.
But here, we are humanizing, we are immortalizing the international law na may mga tao sa likod ng ICC, may mga itsura ang mga judges, may mga nagre-represent sa mga biktima, no, and that there are people who counter the acts of the authority as well. So nakikita natin that after all may tao na involved and this is international law. But while this is international law, it involves people all over the world. The Philippines not exempted.
But then again, may ganun ding argumento na bakit kailangan natin ng isang international court? Bakit hindi natin litisin yung mga sarili nating mamamayan dito mismo sa mga local courts?
With more reason that there are policies or concepts na sinasabi natin tulad ng halimbawa na when the Philippines is not willing or unable to prosecute this kind of cases, doctrine of complementarity. We have many doctrines on this doctrine of command responsibility and a lot more.
Balikan natin yung puntong yan. Dean, bukod sa pagtitipon kasi sa UP na ibinilita kanina ni Rafi Tima, may hiwalay pong pagtitipon ng mga pamilya ng EJK victims sa Quezon City pa rin. At naroon si Jamie Santos. Jamie.
Ivan, nagsama-sama ang ilang kaanak nga ng mga naging biktima ng drug on war noong panahon ng administrasyon ni dating Pangulong Rodrigo Duterte sa isang lugar dito sa Mother Ignacia sa Quezon City para panoorin yung live streaming ng last day of confirmation of hearing charges ng ICC. Ilan sa mga kaanak ng naging biktima ng drug on war ang nagbahagi ng kanilang saloobin sa nangyayaring ang hearing sa The Hague, Netherlands. Isa sa nagbahagi ay si Tatay Rod Bailon ng kanilang malungkot na karanasan bilang ama ng batang nasawi sa kontrobersyal na war on drugs noong panahon ni Pangulong Duterte. Anya, ang kanyang anak na si Lenin ay 9 na taong gulang lamang, nag-aaral, grade 4 at may pangarap. Nadamay sa isang operasyon, sa isang trahedya na nag-iwan ng malalim na sugat sa kanilang pamilya. Bagamat mahirap daw tanggapin ang pagkawala ng kanyang anak, patuloy siyang naninindigan para sa katarungan at karapatang pantao. Pinapaalalahanan niya ang kanilang kwento ang lahat kung gaano kahalaga ang proteksyon sa mga inosenteng buhay sa gitna ng mga kampanya laban sa droga. Binanggit din ni Tatay Rod na ang kawalan ng malasakit mula sa pamahalaan at epekto ng pananakot sa takot sa mga ordinaryong mamayan noong panahon ng war on drugs. Kanina naging emosyonal siya dahil nagbigay siya ng kanyang komento sa nagiging hearing sa The Hague. Hindi daw niya maiwasan sumama lalo ang loob, pero hinahintay daw nilang makamit ang hustisya para sa lahat ng naging biktima ng drug on war, lalo na sa kanyang anak na si Lenin. Ivan.
Maraming salamat, Jamie Santos.
Kinwestiyon ng depensa sa pagdinig ang hindi umanong pag-usig sa anilay mataas na bilang ng pagpatay kaugnay ng droga sa ilalim ng Administrasyong Marcos. Ibinatay po yan sa report ng grupong Dahas Project ng University of the Philippines Third World Study Center na pumalag sa baluktot-an nilang interpretasyon sa datos.
Kung inuusig daw para sa pagpatay dahil sa drug war si dating Pangulong Rodrigo Duterte sa International Criminal Court, bakit hindi rin daw si Pangulong Bongbong Marcos? Ito ang tanong ng abogado ni Duterte na si Nicholas Kaufman. Gamit ang report ng grupong Dahas Project ng UP Third World Study Center, katwiran ni Kaufman sa unang taon daw ng Marcos administration, may napatay na 342 sa mga drug operations. 160 sa mga ito raw sa kamay ng mga state agents o mga law enforcement agencies. At ang bilang patuloy raw na tumataas.
I'm pretty sure that if they were to recreate them for the period of 2 years after Duterte left power, they wouldn't have room left on their computer screen. The numbers would be so sky high. Why are my colleagues sitting to their right, the victims' representatives, not clamoring for accountability for those deaths? Or is it of no consequence now that Mr. Duterte is sitting in the ICC detention center?
Pumalag ang grupong Dahas Project sa sinabi ni Kaufman na binaluktot daw ang interpretasyon ng kanilang datos. Sa datos nila, nasa lampas 300 taon-taon ang naitala nilang pagpatay kaugnay ng droga sa ilalim ng Administrasyong Marcos base sa mga ulat sa media. Mas mababa sa lampas 500 naitalang pagpatay sa huling taon ng Duterte administration noong taong 2021.
Ang hindi namin matanggap ay yung sabihin niyang sky high yung numero. Kasi malinaw kung ginamit niyo talaga ng makatotohanan yung ulat ng gawa namin, ay pinapakita nga ang patuloy na pagbaba ng numero, patuloy na pagbaba ng bahagda ng participation ng kapulisan doon sa mga pagpatay na ito.
Sa pagsasaliksik naman ng GMA Integrated News Research kung paghahambingin ang bilang ng mga namatay noong sa parehong unang 3 taon ng Duterte at Marcos administration galing sa datos mula sa Philippine Drug Enforcement Agency o PDEA, malayo ang pagkakaiba. Ayon sa Dahas Project ng Third World Study Center ng UP, may pagkakaiba ang drug war ng Administrasyon Duterte at Marcos.
Yung panahon ng Duterte administration ay talagang naging napakatalamak. Gustong mag-proceed ng Administrasyong Marcos sa kanyang drug war via propaganda. Ang naging spin ng administrasyon ay sabihin, wala naman na talagang namamatay, which is utterly factually wrong.
Meron pa rin. Mas
Nagpapatuloy.
konti lang.
mas konti lang pero nagpapatuloy.
Kaya hamon ng DAHAS Project maglabas ng opisyal na datos pa ang pamahalaan kasabay ng pag-iimbestiga pa rin sa mga nangyaring patayan.
Hanggat hindi bumababa sa talagang totoong bloodless drug war ito, kinakailangan patuloy natin itong tutukan. Kasi yung pagkarami-raming pagpatay at itong kumukonting pagpatay pa rin pareho.
Sagot dyan ng Malacanang,
Ang Pangulo, alam po natin, ayaw po ng marahas na paglaban sa illegal na droga. Kung ito po ay mabibigyan ng ebidensya at meron talagang dapat na mapanagot, ang PNP po, CIDG, NBI, kinakailangang mag-imbestiga rito kung mayroong sapat na ebidensya. Hindi po palalagpasin ng Pangulo ang mga abusado.
Dagdag pa ng Malacanang sa drug war raw ng Marcos administration, nirerespeto ang due process.
Even before, ang sabi ng Pangulo, walang dugong dadanak. Hindi po niya ginugusto ang extrajudicial killings. Kailangan madinig din po ang mga taong inaakusahan. Hindi po kinakailangang ipapatay agad nang hindi sila nadidinig. Hindi po yan at wala po sa konstitusyon natin ang salitang death penalty. Hindi po ito pinapatupad sa bansa natin.
Joseph Morong nagbabalita para sa GMA Integrated News.
Consistent actually ang Pangulo sa kanyang mga pahayag pagdating sa drug problem. Alam niya may drug problem at ginagawa ng pamahalaan. Pero every time may accomplishment ang PIDEA, ang anti-drug operations, ang sinasabi niya, with no one killed. Para lagi niyang, he will always emphasize na nagawa natin to, pero walang namatay.
Ilang beses niya actually nabanggit in his State of the Nation address, di ba? Lagi niya ipupunto yun. In other words, to point out na very different style from the previous administration.
Tsaka sinagot din ni Prosecutor Nichols yung kung bakit hindi nag-iimbestiga ang ICC sa mga sinasabi niya na pinupunto niya na nagpapatuloy daw ng mga patayan. Kasi dahil sa kliyente mo, di ba? Dahil pinol out tayo sa ICC.
Nag-withdraw na tayo Oo. And we have to respect the decision because even our Supreme Court has a decision on the withdrawal saying na tama na may valid yung withdrawal.
Dean, meron ba kayo nakikitang scenario in the near or far future na ang Pilipinas ay babalik or sasali ulit or pipirma ulit sa Rome Statute?
We have to look at this fact in the light of the functions of the Office of the President being the chief architect of foreign policy. So it is a political action on the part of the President. Whoever is the President as of the moment can always go back to the realm of the Rome Statute.
Tingin niyo based on what's happening now, na meron tayong former head of state na hindi pa naman nililitis, di ba? Pero nandito tayo sa pre-trial at the ICC. Tingin mo, isa itong bagay na dapat isama sa plataforma ng kung sino man ang tatakbo sa pagkapangulo sa susunod na eleksyon?
It's a good platform, especially when we speak about crimes against humanity and protection of the Filipinos. No? Because we have a law, but at the same time, we have in the past na may nangyari, like in the case of the EJK. And this could be a good platform also to reassure the people that human rights and humanitarian law are protected here in this country.
Definitely election issue siya. Kung hindi man maging plataforma, talagang kailangan tignan natin kung sino man ang iboboto natin, kung ano magiging posisyon nila sa mga mungkahin na mag-rejoin ng Pilipinas sa ICC. Because like you said, it's going to be a political decision whether or not the Philippines goes back to the Rome Statute.
At kung ibabalik natin nga doon sa sinabi ni Prosecutor Nichols, kung may mga similar cases na mangyari, sa punto ito, hindi na siya pwedeng imbestigahan dahil hindi na nga tayo bahagi ng Rome Statute.
Kahit sabihin niya pang at the time of the PBBM's administration, marami pa din patayan, patuloy pa din, but hindi siya maimbestigahan because we are not anymore part of the Rome Statute and wala ng jurisdiction.
Pero ang kontra-argumento laging pinalulutang din yung sovereignty, di ba? Parang bakit tayo sasali pa dyan? Meron naman tayong sarili nating korte, may sarili tayong justice system. Yung I heard the former Executive Secretary Medjaldea parang sinasabi, ito yung gusto nating gawin para linisin ang lipunan natin. Bakit nakikialam ang isang ang isang foreign entity or foreign institution.
Kasi babalik tayo doon sa konsepto ng state. The Philippines as a state has sovereignty and that under the UN principles, we are just equal. Kahit malaking bansa ka man or maliit na bansa, pareho tayo. You have to respect me, my sovereignty. And these are sovereignty issues. In fact, this has been resounding, even in the Senate of the Philippines on the questions on sovereignty. But I think sovereignty also involves the power of the state to implement its own laws. And not only to make its own laws, but to implement them and enforce them.
Din meron pala akong gusto itanong yung kanina, dun sa punto sa right to life.
Okay.
Kasi ito'y nasa konstitusyon, di ba? Isang batayang karapatan ng bawat isa sa atin ang mabuhay, right to life. At yung mga police operations kung saan may namamatay, no such thing as presumption of regularity. Paki-explain nga yun din. It is up to the police to prove na wala silang ginawang masama. Parang gano'n dahil walang ganong presumption of regularity. Ganun ba yun?
Kasi ang sinasabi natin na, halimbawa, nagkaroon ng misstep, no? Misstep on the part ng police when they are performing their functions. So there is a presumption under the law that they have performed their duties within the bounds of the law and the rules, no? But this time, you cannot say that it is within the bounds of the law when there is killing, because we do not subscribe to death or killing, because we have the right to life, and also there is no death penalty in this country.
Therefore, anong kailangan gawin ng police?
Therefore, they have to follow the rules, observe due process, and kung kailangang ikulong ang tao dahil nahuli siya na nag-violate ng rules or the law on anti-drugs, then they have to follow the procedure na dapat may prosecution, dapat may paglilitis sa korte, and dapat may judgment, no? Hindi na the police officers cannot just take into their own hands what the law is supposed to be, not within their powers. That's why there is no presumption of regularity.
Okay, malinaw. Salamat sa paliwanag. Samantala, okay. Kasi may report tayo, parang sort of look back to what led to us here na nasa pre-trial na sa dating Pangulong Duterte. But anyway.
Excuse me, sorry. Actually, Dina, ang gusto ko sanang balikan kanina, kasi binabanggit ni Prosecutor Nichols yung Article 7.1. Pero yung bang ipaliwanag kung ano yung Article 7.1?
Article 7.1 kasi ng Rome Statute, ito ang article na naglalatag ng elements, no? Ang mga elemento ng krimen, crimes against humanity. And this lay down all the components ng krimen or instances na pwedeng ang act ng isang tao ay magkakaroon ng and can be considered under international law as crimes against humanity. So may murder, torture, and other acts that would constitute crimes against humanity. And there is an explanation there even on the widespread attack on the civilian population. And in fact, the questions here would go back to what constitutes civilian population dito, no? And sabi nga ni Prosecutor Nichols, sabi niya na it would refer to any civilian population. So hindi dapat it's not supposed to be for the entire Filipinos, no? Kundi any portion of the civilian population is enough that could show that it is directed to this specific portion of the population of the Philippines.
Dean, as we speak, I would presume si Attorney Kaufman naghahanda na ng kanyang closing statement, no? Pero is this enough time? Kasi may mga binanggit, very specific itong si Attorney Andres to debunk or to rebut yung kanyang mga sinabi in the last 2 days. So, ibang level of ibang level of argumentation skills, if there's such a word, pag ganyang mga paglilitis ang nangyayari.
And I think by this time, we should be prepared already because alam niya namang nakalatag na din nakalatag na din ang mga accusation and he is ready na i-counter-argue ng prosecution ang lahat niyang mga sinabi. And yes, indeed, it calls for prowess in speaking and all that. And with this remaining hours or minutes na he has to prepare, I think he just have to focus on the elements na sinabi ng prosecution and even the defense. Pero medyo malinaw kasi ang paglatag nila. And this time we'll see, and we can imagine how he will do that.
At yun nga po inaabangan natin, sa loob na lamang ng ilang minuto ay maririnig na natin ang closing statement ng depensa. Samantala, bagaman idinulog po sa ICC ang mga pagpatay sa Pilipinas sa ilalim ng drug war noong nasa pwesto pa si dating Pangulong Rodrigo Duterte, inabot pa ng ilang taon bago natapos ang investigasyon dito. Ating balikan ang mga naganap mula noon hanggang sa pag-aresto kay Pangulong Duterte at ang mga naging hakbang ng depensa bago ang confirmation of charges hearing.
I'm not saying that you kill them, but the order is dead or alive.
Mula nang maupo sa Malacanang noong 2016, hindi nang himing magbitaw ng mga ganyang utos si dating Pangulong Rodrigo Duterte.
Lahat kayong natamaan ng droga, huwag ka lumawas ka, papatayin ko kayo.
Tuloy ang mga pagpatay sa ngalan ng drug war na umabot sa libo-libo.
Sinabi ko, do not kill intentionally, killing this murder. But kung may baril at nakabunot pa lang, una sa baywang na, barilin mo na. Kasi bubunot talaga yan at ikaw ang mamamatay.
2017 nang dumulog na sa International Criminal Court o ICC ang abogado ng nagpakilalang hitman ng Davao Death Squad na si Edgar Matubato. Nakokonsensya na umano ang huli, kaya gustong ipasilip ang umano'y mass murder sa Pilipinas na nagsimula sa Davao City pa lang. 2018 naman nang buksan ng ICC prosecutor ang preliminary investigation sa Pilipinas. Pero si Duterte hindi natinag.
Ang kasalanan ko lang yung mga extrajudicial killing.
At ikinalas ang Pilipinas sa Rome Statute noong March 2019, ang kasunduang nagtatag sa ICC. Giit naman ng ICC, nasa jurisdiction nito ang Pilipinas sa mga taong bahagi pa ito ng Rome Statute.
Kahit itong ICC, I will not, why would I defend or face an accusation before white people? You must be crazy.
Wala na sa pwesto si Duterte nang mag-imbestiga na rin ang Senado na dinaluhan pa ni Duterte.
Ako, di makulong, di masamkulong. I can make the confession now, if you want.
Mr. Chair.
Talagang niyayari ko. Meron akong death squad. Pero hindi yung mga pulis. Sila rin yung mga gangster. Yung isang gangster, utusan ko. Patayin mo yan, kaya kung hindi mo patayin yan, patayin kita ngayon. Call of duty of the President. May patayan. But it was not a state-sponsored killing.
Kanina sinabi nyo na in-encourage nyo ang PNP na i-encourage yung suspect na lumaban.
Yes.
Para mapatay, para
Yes.
masabing nanlaban.
Correct.
Sa hiwalay na investigasyon naman ng Kamara.
At tutunghayan po natin ang kabuuan ng ulat na yan. Samantala, makakapanayan po natin ngayon, Attorney Nery Colmenares, abogado ng mga biktima. Attorney Nery, good evening from the Philippines.
Yes.
Attorney, ayan. Attorney, can you hear us? Nako, kami naman ang hindi makarinig sa inyo, Attorney. Ayusin muna natin siguro ang...
Balikan natin si
Kasama
Attorney,
yata
no?
niya
Sorry.
si JV. Ayan, subukan nating balikan kasi of course, titingnan natin kung ano ba yung naging reaction niya sa pangalawang bahagi ng submission ng depensa. And of course, kung what he can tell us, kung what went to the closing statement, di ba? Kung paano nila binuo.
Consistently, di ba, itong mga nakaraang araw, sinasabi ni Attorney Nery Colmenares na siya ay very satisfied sa naging pagpresenta ng prosecution, pati na ng common legal representatives, at talagang tiwala siya na aabot tayo sa confirmation of charges.
And for sure, he has a participation in the rebuttal na mga sinabi ni Attorney Andres, no? And he's one with the victim. So I think that, of course, he will be very happy today with the outcome.
Tignan din natin kung paano kaya nila pinili yung 10 rebuttals. I'm sure meron pang iba silang gustong sagutin But given the limited amount of time, pinili lang siguro nila yung strongest arguments.
Ang sinasabi nga, dapat you have to choose your own horses for this battle.
Although technically, hindi po ba, Dean, parang 40 minutes yung break kanina. So the prosecution plus yung CLRV, meron silang 40 minutes to prepare their rebuttal. Technically, 40 minutes lang yun. Although, syempre, habang ongoing na yung submission of merits, nag-prepare na sila. Pero ito, parang mas mahaba yung break ngayon. So, mas mahaba yung panahon ng depensa para mag-prepare ng kanilang rebuttal.
And I think, unlike the defense, si prosecution tsaka yung victims were able to prepare. That's why with the citation on the minutes yesterday, no? So they prepared a lot also. So, kasi kung titingnan, parang 1 hour lang naman yung sinabi ng defense today. And the 2 hours, I think, would be enough for the defense to present a good rebuttal.
Pero
also.
napaisip nga ako, partner, tinanong ko kay Dean kanina nung when you stepped out. Ibang level of skill for sa pagdedebate o sa pag-argue ang kailangan for, in this case, the defense lawyer, kasi ang sasagutin mo, ang dami.
Tsaka dalawa. Parang kumbaga, hindi lang isa kalaban mo, dalawa.
Mismo parang pinagtutulungan siya, no? In this case.
So kumbaga, parang naka-break sila, pero hindi sila naka-break.
Yun. And kailangan niyang sagutin So, may choice pa ba? But I think looking at the arguments ng prosecution and the defense and the victims here, makukuha naman ni Attorney Kaufman yung gusto niyang sabihin doon from there.
Andito na yata si Attorney Nery Colmenares. Attorney Colmenares, sir, good evening from the Philippines.
Hi, good evening. Pakilakas ka ng sobra yung studio, please. Hindi namin marinig ni Attorney Nery, please.
Okay, pwede natin idaan yung ating mga tanong kay JV. Tama ba, JV? Ikaw naririnig mo kami? JV
Can you hear us?
Yes, we can hear you, JV and Attorney Nery. All right. Well, Attorney Nery, balikan natin yung naging presentation, in particular nung common legal representatives ni Attorney Gilbert Andres. Ano po masasabi niyo tungkol sa kanyang naging rebuttal?
Attorney Gilbert, na-rebut niya, 10 points pa yung rebuttal. At naikwento niyang context at siguro hindi alam ng, I don't know kung alam ng defense, abogado sila sa very petition na sinay ng defense. Kaya kung baga na-shatter talaga yung assertion ng defense on that Supreme Court petition. At talagang 4 na rebuttal point ang sinabi dun sa issue na yon. So basically, hindi totoo na walang recognition ang Korte Suprema doon sa nangyayaring patayan. And in fact, ang parang kinote doon ng CLRV, if I'm narinig ko ng mabuti, parang ang ganda na pagkasabi, sinabi ng Korte Suprema, nilagay nyo sa accomplishment reports nyo pagpatay ng 3,000 plus na drug suspects. So kung yun pala ang accomplishment nyo, therefore, policy nyo yun. Di ba? Napakasimple, no? Pero yung mahabang debate ni Mr. Kaufman na walang policy, di totoong nag-utos, hindi nag-order, the fact na nilagay nyo sa accomplishment report nyo, ibig sabihin, patakaran nyo yun. Kaya I don't think makaligtas doon yung depensa.
Attorney Nery, while we were listening kay Attorney Gilbert Andres, napansin namin talaga na paghandaan. Ito ho ba'y ilang araw niyong pinaghandaan? How did you choose the 10 points that you wanted to rebut? At ito lang po ba yung talaga napili ninyo? At may iba pa kayong pwede i-rebut sana? But given the limited time, ito po yung mga napili ninyo. At may mga direct quotes pa nga kayong nagamit.
Oo. Well, nag-usap kami a few days ago before the confirmation at ang focus naman talaga ni Gilbert was on ano ang expectation sa i-present ng prosecution at ano ang rebuttal. Bagamat nagdi-discuss ng konti kami on ano pang mga points for rebuttal, yung ginawa ni Gilbert, yung 10, kanya talaga sinulat yon. At kung may mga influence mo doon, yung mga nakakatandang abogado, minimal na lang yon. Mas malaking bahagi doon yung very well prepared. No? Handa na iyon at mabuti naka-adjust kasi kino-quote yung mga sinabi kahapon. So that's good. Ibig sabihin, mabilis na nakapag-isip yung mga abogado ng biktima at ma-articulate na naisabi ito sa korte.
Attorney, dun sa kanyang rebuttal, kumbaga parang pinapaalala ni Attorney Andres, no, kung sino yung mga biktima na naririto at nagtapos siya by saying na parang dapat matuloy yung confirmation of charges, dapat talagang i-confirm yung charges, dalhin ito sa paglilitis para to bring in his words, to take the victims out of the darkness. Yung mga kasama niyo po na nakakausap po ninyo ng mga biktima, nakikita na ba nila na malapit na silang umabot doon sa punto na may liwanag na?
Yes, actually may nakausap akong isang biktima, kaanak ng biktima, at natandaan niya yon, nasabi niya, tama yun kasi sa ngayon parang nasa anino kami ng kadiliman eh. Pero kung magkaroon ng trial, makakalabas kami unti-unti doon sa liwanag ng katarungan. So yeah, it was well captured para sa akin ni Attorney Gilbert Andres sa closing niya na kung bakit kailangan ma-confirm ang charges, hindi lang doon sa nabanggit namin previously, na pag hindi na-confirm ang charges, di babalik si Duterte sa Pilipinas, di lalong natitreten yung mga biktima, di ba? Pangalawa, dapat magkaroon ng trial para ma-historical record din ang buong pangyayari ng drug war para naman maituro sa susunod na henerasyon, katulad ng tuturo sa Germany ng ginawa ng Nazi at ni Hitler ng World War II para hindi na maulit, di ba? Dagdag pa yun, siyempre, is yung kalagayan ng mga biktima. Sila pa nga ang agrabyado, pero sila pa ang parang pinapahirapan dito dahil sa, grabe pa rin yung atake at pagdurusa nila na kawalan ng not nearly 6 years na namatay yung kanilang kaanak pero wala pang hustisya hanggang ngayon.
Itong nabanggit ni Attorney Andres na hindi lamang ito paghahanap ng hustisya, kundi ang pagnanais din na makapag-reintegrate itong pamilya ng mga biktima sa kanilang mga komunidad. Please tell us about this, Attorney Neri.
Hindi ko narinig mabuti.
Attorney Neri, yung tungkol sa pag-reintegrate sa kanilang mga komunidad, please tell us about this. Ano ho ba nagiging difficulty ng mga pamilya ng mga biktima?
In the first place kasi, pag may trial at least, lalabas, lalo na kung makonvict. Si President Duterte, parang na-vindicate ang hinaing ng mga biktima. Sa ngayon kasi, hindi nila alam, malay mo, hindi ma-confirm, di ba? Lalabas ka ba niyan? Hindi naman superhuman itong mga biktima na parang susuong sila na hindi man lang. Pero at least kung may trial na, kahit paano, alam na nila na hindi basta-basta makalabas ito para na-threaten kami. That's one. Yung reintegration, syempre rin, yung makakilos ka ba ng normal sa komunidad mo. Nang hindi ka tumitingin kung sino mga tao dyan, baka meron ba dyan supporter, yung gano'n. These things, malaki ang toll niyan sa biktima eh. Nang hindi ka ng normal, ikaw pa nga ang agrabyado, ikaw pa nga ang namatayan eh. Parang ikaw pa yung sinisisi, di ba? So, I guess that's what the victims feel. And we're very happy na isabi sa korte yun para makonsidera din nila ang mga kalagayan at hinanain ng mga biktima.
Attorney, meron lang akong pandagdag, no? Kasi nabanggit ni Attorney Andres na mahalaga na maintindihan ito, lahat ng ito, in the context of the Philippines, di ba? Parang sabi niya, yung mga speeches, yung mga talumpati ni former President Duterte, dapat napapakinggan ito sa konteksto ng Pilipinas. Sa tingin niyo po ba naipunto ng sapat, no? Yung Philippine context, naipaliwanag ng sapat itong konteksto ng Pilipinas during the course of the arguments?
Yes, oo. Maganda yan. In fact, ni-raise din yan ng prosecution. Kasi isa sa ni-raise ng nagdepensa, wala naman kayong forensic reports, wala kayong record, walang mga death certificate, na hindi nila alam ang context sa Pilipinas. Na pahirapan mag-imbestiga ang mga pulis. Doon din nag-imbestiga pag EJK yung kaso akala nila madali lang kumuha ng death certificate. May isa pa nga kaming experience. Ito yung anak niyang babae na minor, tapos nag-rail sa kilikili, tapos nang lumabas ang death certificate, bronchopneumonia. So, paano mo masisi ngayon ang mga biktima na hindi kayo nakakuha ng death certificate o birth certificate man lang? So, para sa akin, ang sabi ng CLRV doon, and even the prosecution, alam mo nga ang context sa Pilipinas muna kaya hindi ganon kadali yung mga sinasabi mo. Pero meron, sabi niya. May mga witness kami for that, in fact, at mga documents din. So, in any case, that's for the court to decide. Pero sa amin, I'm sure, ang korte na to, sinight ng prosecution, you were there in other cases. Alam nyo, pag crimes against humanity, o war crimes, ang mga leader, the most responsible, ang kinakasuhan. Sila, ginawa na nilang lahat para walang investigasyon sa mga krimen na nagawa nila. Kasi ngayon, kung sabihin mo, walang investigasyon ng pulis So parang ginamit pa ni President Duterte yung ginawa niyang utos na huwag niyong imbestigahan ng EJK para maabsuelto siya. Parang yung self-serving evidence, kumbaga na dokumento na mag-serve sa kanya na diniprive niya ang mga biktima at ang prosekusyon, gagamitin niya pa ngayon para maka-absuelto siya. I don't think i-act ng court yan sa ganyan na porket wala kayong death certificate, therefore walang namatay. Hindi pwedeng sabihin ng korte yan for me.
Attorney Neri, panghuli na lamang po. Anong ina-expect natin sa hearing on the detention? May pagkakataon din po ba ang CLRV na magsalita para tutulan para makapaglatag ng posisyon dito po sa continued detention ng dating Pangulo?
Hearing on the detention.
Well, ang hearing sa detention, of course, parang pagtingin sa kondisyon ng kalagayan. So, syempre, ang mga biktima, una muna, medyo maayos nga ang kondisyon ni President Duterte dito. Yung marami nakakulong sa bilibid natin dyan, grabe ang sakit, seryoso ang sakit, matanda pa kay President Duterte, hindi nga makalaya basta-basta. So, that's the first. Second, pwede niyo bang palayain siya on the ground na masama ang kalagayan sa detention? I don't think so. At sasabihin talaga namin, itong taong ito, walang respeto sa ICC. Ilang beses niya sinabi yan, pag palayain niyo yan on the ground na may medical condition na kailangan makalaya siya para naman makalanghap siya ng fresh air. Ay nako, bakit hindi na babalik yun? Bakit siya babalik sa trial ng isang korte hindi na kinikilala ang jurisdiction? So para sa amin, for all those arguments, we really hope that the court will see into this and not grant any form of interim release o ano pa man yung tingin nilang dapat i-demand nila. Of course, dapat alagaan ng korte yung health ng dating presidente. Kahit kami rin, ayaw namin may mangyari kay President Duterte din. Gusto namin at may kalusugan siya dyan talaga. Kasi pag may nangyari sa kanya, dismiss ang kaso. Diba? So sa amin, nasa interest din namin na maalagaan siya ng gusto. At I really hope that the ICC will also try to make the best efforts din na ma-ensure na ang prison condition niya ay nagre-recognize naman sa mga health needs niya and other needs ng isang tao sa isang kulungan.
Attorney Neri, maraming salamat sa oras na ibinigay ninyo sa amin. Ingat po kayo. At salamat din sa GMA News Stringer na si JV Marasigan. Live po yan mula sa The Hague.
So at least alam na natin mula sa panig ni Attorney Neri Colmenares kung ano yung naging reaction rin nila sa mga rebuttals. Maski siya, di ba? Parang very impressed siya dun sa 10 rebuttal points ni Attorney Andres.
I agree. And also as to the statement on the health of former President Duterte, no? Na nasabi niya, bakit natin i-release si President Duterte na mismo hindi niya kinikilala ang ICC. And I think this one thing is to be considered by the tribunal when it decides on the continued detention.
Actually, nabanggit rin yung kanina, di ba? Na parang they were saying that Mr. Duterte, former President Duterte, parang holds the court in contempt, short of saying that, di ba? Paano matitiyak din na walang bias in terms of that? Na parang, he doesn't believe in us. Parang, how do we rule on this case?
Kasi you cannot have something na hindi mo pinapaniwalaan, di ba? So dapat hindi ka humingi ng pabor doon sa hindi mo kinikilala. And I think that's one scenario na they wanted to prevent as well, no? Na kung i-release natin to, na hindi niya kinikilala, how sure are we that all our orders will be complied, or especially of the concept of kidnapping, that is still the argument.
Din yung ibang mga world leaders or former world leaders who are charged before the International Criminal Court, ganon din bang nagiging tema ng kanilang depensa or kanilang refusal to submit themselves to the ICC na hindi ko kinikilala ang jurisdiction mo, so therefore, do we see this often in similar cases?
I don't think so, because Duterte, on his case, is very vocal, and in fact, is being prosecuted because of his speeches. No, ang sa iba medyo hindi masyadong masalita, pero alam mong kontrolado nila ang buong bansa nila. No, so that's I think how authoritarian governments are, and in fact, many of those who were subjected to the ICC proceedings are in an authoritarian government. No?
Bukod po ba sa Pilipinas din, sino pa ba ang hindi bahagi sa ngayon ng Rome Statute?
United States is one example, no, and many other states also, no, because remember that kung gusto mo maging bahagi ng isang treaty, kailangan may consent, not only by the representatives of the government or by the president, but also it must comply with the constitutional requirements, such as, for example, on ratification.
Pero ito namang ICC, itinatag ito basically to exact accountability when it is impossible dun sa state mismo ng akusado.
Exact individual responsibility in particular. Yes, especially that based on history from Nuremberg trials to ICTY to ICTR and many other courts prior to the Rome Statute and the ICC, makikita natin doon how this kind of responsibility evolved, no? And makikita natin na even at the time ng Nuremberg trial, for example, where some participation of the leaders were taken. I mean, the concept that we are using also in this case, no, na halimbawa, direct, systematic, and widespread attack on the civilian population. Yung mga ganyan na line of argument, these are tested by history as well. And good thing that there are mechanisms that were created, because we know that the power that is being respected, and in fact, a policy within a state is something that is difficult to question. So that's why we have concepts like complementarity, that when the state is able and capable of doing the hearing, etc., then it can do so. But if it is unable and unwilling to prosecute the person who is holding the power as of the moment, then pwede tayong dumulog doon sa International Criminal Court.
Tsaka parang doon bumabalik no yung sinasabi nila na hindi mo naman talaga mag-i-expect or maaasahan ng mataas na conviction rate sa ICC because of the nature of the cases that it actually tries. Parang hindi naman high conviction rate ang habol niya, di ba? Ang habol lang dito is to be able to put to trial those who must be put to trial.
Yes, and if we know the cases under the jurisdiction of the International Criminal Court, we have genocide, crimes against humanity, war crimes, aggression, and all these cases are international crimes, universal crimes. And in fact, even if we are not a member to the Rome Statute, we have the obligation under the concept of erga omnes obligation, or the obligation na we have the right to question or to abhor this kind of acts, because this is contrary to international customary law. No?
Very interesting na naabot tayo sa puto ito. Kasi, I mean, iniisip ko din, sabi nyo, ang customary dito sa Pilipinas, ang required is only 3 units of international law sa law school. Pero di ba, yung 3 units na yan, parang, while you were studying those 3 units, din naisip mo ba na one day ang Pilipinas aabot dun sa punto na meron tayong former head of state na nasa
dahig
ICC.
ngayon.
I never imagined, especially when I was in fact, ang topic sa International Criminal Court, minsan pahapyaw pa ang discussion sa law school kasi sa dami ng topics on public international law, minsan mabilisan lang. Or sometimes the professor would just tell you, okay, just read the Rome Statute. And then ikaw na bahala doon. But without you imagining na merong mga leaders talaga na nahihear sa kasong ito, and at the same time that there are victims, no, that are really victims of these atrocities committed against them.
Nabanggit nga ni Dean Sarmiento, Ralph Sarmiento ng University of St. Lasal the other night, parang after this, yung mga law students, kailangan nilang i-consider ang international law as a possible professional track. Dahil ito, nangyari na nga eh. And I guess, it's reasonable to think na hindi ito ang last. Baka magkaroon pa ng mga ganito.
And this is what we are telling our public international law students, no, that they really have to study this and look at this in the perspective ng international law. Kasi ang problem sometimes in the Philippines, even looking at the decisions of the Supreme Court, is sometimes we do not treat international law as it is. Sometimes we combine international law and the domestic law. Kaya minsan yung pagkakaintindi natin, halimbawa, sa pagdala sa kay President Duterte sa ICC, so nako-combine natin yung constitutional rules tsaka international law rules, no, na dapat may distinction as between them. So ano bang gagamitin natin when it is the international tribunal that is deciding? Will it be the domestic law or is it international law?
Tsaka partner, pag nagkataon na dumiretso sa trial to, kailangan natin ng resource persons.
Oo nga eh.
Baka mapagod na si Dean.
Sabihin ko sa Sir
Marami
Dean,
pa mga resource, di ba?
kami ni Ivan, para na rin kami mga estudyante
Para kami law
ninyo.
students dito.
Itong
Actually, maraming assignment sa
Yes.
mga law students ngayon.
Itong nakarang 4 na araw, pakapal na pakapal yung binabasa
mga notes
natin, Ivan.
Samantala, nakapanayan po kanina ng ating stringer na si Sofia Balod, ang isa sa mga abogado ng mga biktima na si Attorney Gilbert Andres. Panoorin po natin.
Narinig po kakatapos lang po natin sa CLRV yung inyo pong closing statement. Can you walk us through the process, sir? Paano niyo po, kumbaga, ginawa yung 10 rebuttals na yon na inyong mga statement? Kumbaga, what was going in your mind when you drafted that response, and for also to make a lasting final closing statement also in behalf of the victims?
Well, una muna talagang pinag-aralan po namin kung ano po yung mga submissions ng defense. So talagang nakinig kami kahapon at pati nung Monday sa kanilang opening statement para naman malaman namin yung mga puntos nila. Para punto din namin silang isasagutin. Kaya sa tingin po namin na palabas naman namin yung mga punto namin laban sa kanila.
Apo. Yung very specific din po yung mga inyong arguments, no? What do you think now, sir? Are you confident? What are you feeling right now? Pagbibigay pa lang po si Attorney Kaufman ng kanyang closing statement. Pero what about you, sir? What are you feeling right now regarding the outcome po of the pre-trial hearing?
I think siguro relieved na we were able to show yung views at concerns ng mga biktimang nire-represent namin. Kasi parang nawawala sila dun sa lalo na may mga false news, fake news at disinformation laban sa kanila. So gusto naming maging talagang victim-centered itong proceedings na to. Kasi talagang sila po yung pinupunterya po nito.
Can you talk to me, sir, about yung sinabi niya na they want to reintegrate in the society and kumbaga get out of the shadows of fake news? Ano po ba, sir, kumbaga kung pwede niyo pong ibahagi sa amin yung mga nararamdaman din nila ngayon kasi nakita din namin na very tired na rin, ang haba po, very heavy rin sa kanila. Can you walk us through that process ng emotion nila?
Kasi usually yung mga victims galing po sila sa mga close-knit at mga low-income communities kung saan magkakakilala po sila. Pero syempre nandun na yung stigma nung panahon ni Mr. Duterte na kung namatay yung kaanak sa tukhang, natukhang yan sila. So may stigma na yun, kaya parang hindi nila ma-share talaga yung kanilang saloobin kahit sa mga neighbors nila. At lalo na ngayon parang tumaas talaga yung false news at disinformation at fake news. Kaya yun yung panawagan natin sa chamber na ilabas na rin sila doon sa liwanag ng katotohanan at hustisya.
Ito po sa 5 araw, no, kasama yung break, no, ano po ba, sir, yung kumbaga meron ba silang sinabi na hinaing nila or nararamdaman din nila throughout this process? Kasi kumbaga ito first hand nilang nakikita, this for the first time din nila makapunta dito to witness such a trial. Bilang representatives po ng victims, meron po ba sa kanila na sinasabi na okay, itong experience na to, did it make them feel more confident, more hopeful, or also a little bit reserved? Kumbaga kasi makikita din natin yung both sides, and they're sitting beside also yung mga lawyers ng dating Pangulong Rodrigo Duterte. Do you have an idea into how they're
Okay. Una, talagang security yung aming tinitingnan. Kaya hindi lang po basta-basta pumupunta dito yung mga kaanak ng biktima. Kaya talagang yun yung una muna naming interest. Ikalawa, talagang kinakausap din namin sila at kinakamusta sa kung kaya naming araw-araw ginagawa namin. At ikatatlo, inaano din namin kung anong mga reaction nila, anong naging saloobin nila. At I think generally sa loobin nila ay joyful sila dahil nag-start na nga itong unang hakbang tungo sa hustisya at katotohanan.
Okay po. Can you walk us through lang, sir, then yung mga next steps na po after this hearing? You said you're also confident about the proceedings so far, but what will happen po ba next in terms also din sa mga victims natin, families of victims natin?
So, ang mangyayari, after ng day na to, magka-count ng 60 days, so more or less, mga April 27, more or less, na yun yung maximum kung saan hintayin natin kung anong magiging decision on the confirmation of charges. At doon natin malalaman kung sana, ma-confirm, at kung kailan, if ever, yung magiging trial proper. Pero antabayanan natin yan.
And in the meantime po, meron po bang kumbaga plano po para dun sa mga victims na umattend dito, or they resume kumbaga their daily lives, or are there also like next steps for them as well after attending this hearing? There be a debriefing of some sort, or what would be the next steps also for them?
Syempre, kakausapin po namin sila at kailangan din namin marinig talaga yung kanilang mga saloobin. So yun pong magiging proseso po natin.
Last question na lang po, attorney. If there is one takeaway from kumbaga dun sa 10 points ninyo of rebuttals, what would you take away from it, from everything? What was the most important, kumbaga, if you say one final closing statement, really condensed into say a sentence or two, what would be your main takeaway from that rebuttal?
I think yung sinabi ng Supreme Court sa isang resolution, sa isang case, na talagang this may indicate na state-sponsored mga patayan na to. So, mahalaga yun.
You also mentioned, sir, na kumbaga yung mismong report ni dating Pangulong Rodrigo Duterte sa kanyang 2017 year-end report. It's also, kumbaga, in a way, an evidence in itself.
Opo, in fact, ebidensya sa dito sa proceedings na to, kasi doon makikita na talagang pinagmamayabang ng Duterte administration yung patayan.
And those numbers are actually represented by the government itself and written.
Yes, so mga government reports na po ito.
I'm not saying that you kill them, but the order is dead or alive.
Mula nang maupo sa Malacanang noong 2016, hindi nang himing magbitaw ng mga ganyang utos si dating Pangulong Rodrigo Duterte.
Lahat kayong natamaan ng droga, pagka lumabas kayo, papatayin ko kayo.
Tuloy ang mga pagpatay sa ngalan ng drug war na umabot sa libo-libo.
Sinabi ko, do not kill intentionally, killing plus murder. But kung may baril at nakabunot pa lang, una sa baywang na, barilin mo na. Kasi bubunot talaga yan at ikaw ang mamamatay.
2017 nang dumulog na sa International Criminal Court o ICC ang abogado ng nagpakilalang hitman ng Davao Death Squad na si Edgar Matubato. Nakokonsensya na umano ang huli, kaya gustong ipasilip ang umano'y mass murder sa Pilipinas na nagsimula sa Davao City pa lang. 2018 naman nang buksan ng ICC prosecutor ang preliminary investigation sa Pilipinas. Pero si Duterte hindi natinag.
Ang kasalanan ko lang yung mga extrajudicial killing.
At ikinalas ang Pilipinas sa Rome Statute noong March 2019 ang kasunduang nagtatag sa ICC. Giit naman ng ICC, nasa jurisdiction nito ang Pilipinas sa mga taong bahagi pa ito ng Rome Statute.
Kahit itong ICC, why would I defend or face an accusation before white people? You must be crazy.
Wala na sa pwesto si Duterte nang mag-imbestiga na rin ang Senado na dinaluhan pa ni Duterte.
Ako, di makulong, di masamkulong. I can make the confession now if you want.
Mr. Chair.
Talagang niyayari ko. Meron akong death squad, pero hindi yung mga pulis. Sila rin yung mga gangster. Yung isang
Mr. Chair.
gangster, utusan ko. Patayin mo yan, kaya kung hindi mo patayin yan, patayin kita ngayon. Call of duty of the President. May patayan. But it was not a state-sponsored killing.
Kanina sinabi nyo na in-encourage nyo ang PNP na i-encourage yung suspect na lumaban
Yes.
para mapatay, para
Yes.
masabing nanlaban.
Correct.
Sa hiwalay na investigasyon naman ng Kamara, hinamon niya ang ICC.
I'm asking the ICC to hurry up. Pagpunta na sila dito bukas, umpisahan na nila ang investigation. And if I am found guilty, I will go to prison and rot there for all time.
Matapos ang 4 na buwan, may isinalubong sa dating Pangulo pagkalapag niya sa NAIA mula sa Hong Kong.
Warrant of arrest. So, you will just have to kill me. Kung hindi ako papayag, kung kakampi ka dyan sa mga puti. We're just going through the process.
Inescortan siya papuntang Villamor Air Base at sinilbihan ng arrest warrant na inisyu ng ICC. Sa kabila ng tangkang pagharang ng kanyang mga kaanak at taga-suporta,
18 years old siya. 18 years old siya. 18 years old siya. Walang kaso. 18 years old siya.
Akin na yung anak ko!
Sino ba ang mas mataas sa iyo? Kausapin mo. Hindi, higher than you.
Hihilain ko yan. Hihilain ko yan. Naku, maniwala ka, hihilain ko yan.
naisakay si Duterte sa chartered flight papuntang The Hague sa the Netherlands. Ikinulong sa ICC Detention Center si Duterte at naging unang dating Pangulong ng Pilipinas na pinaharap sa ICC.
I'm Rodrigo Duterte. That's my first middle name is Roa. His surname is Duterte.
Habang nakakulong siya, kinwestiyon naman ng kanyang defense team ang jurisdiksyon ng ICC. Humiling din sila ng interim release o pansamantalang paglaya at ng indefinite adjournment dahil sa kawalan na umano ni Duterte ng kakayahang makaalala kaya hindi na kayang sumalang sa paglilitis. Pero karamihan sa mga petisyon nila ay mababasura kahit iapila pa sa appeals chamber. Pinagbigyan naman ang hiling noon ng depensa na may pagpaliban ang confirmation of charges na unang itinakda dapat noong Setyembre. Pero heto't tuloy na rin ngayong huling linggo ng Pebrero.
Chino Gaston nagbabalita para sa GMA Integrated News.
Thereby placing your jeopardy in your life.
Kahit pa ilang beses binabasag ng depensa ang argumento ng prosekusyon sa submission on merits nito sa ikatlong araw ng confirmation of charges hearing, kumpiyansa si Office of Public Counsel for Victims Head Paulina Masida na may sapat na basehan para makumpirma ang mga asunto laban kay dating Pangulong Rodrigo Duterte at tumulak sa trial proper.
I think that the prosecution made a very good presentation in relation to all the elements of the crimes, not only in terms of the theory and how to apply the notion of widespread and systematic attack and crimes against humanity, but also at the level of concrete evidence showing a pattern in the killings, showing how Mr. Duterte was implicated in the patterns, showing the policy.
Paggiit ng depensa, nabiguraw ang prosekusyon na maipakita ang direktang ugnayan ng mga hitman sa dating Pangulo at tinawag na mahina ang kalidad ng ebidensya. Pero sabi ni Masida, inaasahan na raw nila ang ganitong estratehiya ng depensa.
I think this is again a technique, a way in which the defense wants to portray the evidence.
Tinututulan din ng depensa ang interpretasyon ng prosekusyon sa salitang neutralize na anilay nangangahulugan lamang ng pag-aresto o pagpigil at hindi pagpatay. Ngunit ayon kay Masida, ibang nakita at narinig nilang mga salaysay mula sa mga biktima.
Neutralize in the victim's view was really used to meant that people had to be killed.
Iginiit din ng depensa na walang iisa o coordinated criminal plan at maaaring mga rogue acts lamang ang ilan sa mga insidente. Tinutulan nito ni Masida. Aniya, may ebidensya nagpapakita ng targeting ng isang tiyak na sibilyan na populasyon.
These crimes and these killings were certainly not isolated or spontaneous. We are talking of thousands of killings.
Kaugnay naman sa taunang pagrepaso sa detention, ipinaliwanag na may obligasyon ang pre-trial chamber na suriin kung nananatili ang mga batayan ng pagkakakulong, gaya ng panganib ng pagtakas o pakikialam sa mga saksi. Ngunit ayon kay Masida, dahil kakadaos lamang ng confirmation hearing at napagpasyahan na rin dati na nananatili ang mga kondisyon, wala raw bagong sirkumstansyang magbibigay daan sa paglaya. Mariz Umali nagbabalita para sa GMA Integrated News.
Young Rodrigo Duterte.
Meron akong death squad, pero hindi yung mga pulis. Sila rin yung mga gangster. Yung isang gangster, utusan ko. Patayin mo yan, kaya kung hindi mo patayin yan, patayin kita ngayon.
On 7 March 2025, pre-trial Chamber 1 concluded that there were reasonable grounds to believe that Mr. Duterte is criminally responsible pursuant to Article 25(3)(a) of the Rome Statute as an alleged indirect co-perpetrator for the crime against humanity of murder.
Nitong October 1, inaprobahan ng Senado ang Senate Resolution No. 144 na humihiling sa International Criminal Court o ICC na isailalim na lang sa house arrest si dating Pangulong Rodrigo Duterte bilang bahagi ng humanitarian considerations. Sa 20 senador na dumalo, 15 ang pumabor, 3 ang tumutol at 2 ang nag-abstain. Ayon sa resolusyong inihahin ni na Senate Minority Leader Alan Peter Cayetano at Majority Leader Mig Zubiri, dapat ipasuri si Duterte sa isang doktor na itatalaga ng ICC dahil sa kanyang katandaan at humihinang kalusugan. Kung mapatunayang makasasama sa kanyang kalusugan ang kanyang patuloy na pagkakakulong, maaari siyang isailalim sa house arrest, pero mananatili ang mga restriksyon at kondisyon na ipapataw ng ICC. Bago ang paghiling na ito ng Senado, balikan muna natin ang timeline ng paglilitis ng ICC kay dating Pangulong Duterte. Unang humarap si Duterte sa ICC noong March 14 matapos siyang arestuhin sa Manila. Sa pamamagitan ng video conference, binasa ng pre-trial chamber sa kanya ang kanyang mga kaso at ipinalala ang kanyang mga karapatan sa ilalim ng Rome Statute. Nagtapos ang unang session makalipas ang 25 minutes at itinakdang confirmation of charges hearing sa September 23. Pagkalipas ng 5 araw, opisyal lang na italaga bilang kanyang abogado ang British-Israeli lawyer na si Nicholas Kaufman. Noong March 21, inatasan ng pre-trial chamber ang parehong prosecution at defense na ilahad ang kanilang mga ebidensya. Agad na nagsumite ang ICC Office of the Prosecutor ng 181 items bilang bahagi ng prosecution's first communication of the disclosure of evidence. Ayon kay ICC Prosecutor Karim Khan, kinabibilangan ito ng mga item na nakasaad sa mismong warrant of arrest laban kay Duterte, maliban sa ilang item na naipabatid na sa chamber at depensa sa ibang kaugnay na application. Inanunsyo naman ni Kaufman noong April 4 na buo na ang defense team ni Duterte. At makalipas ang 3 araw, hiniling ng depensa na magpatupad ng mas mahigpit na standards para sa pagkilala sa mga biktima. Ito raw ay para maiwasan ng fraud at procedural delays. Pinunto rin ng defense team na dapat obligahin ng korte ang mga aplikante na magkaroon ng national identity card o passport na may updated na litrato. Kung wala nito, iminungkahin ng depensa na dapat i-require ang mga identification document na ginagamit sa staggered system ng Social Security System sa Pilipinas. Pero tinutulan ito ni ICC listed lawyer Joel Batuyan na counsel ng ilang pamilya ng mga biktima. Ayon kay Batuyan, karamihan daw kasi sa mga aplikante ay kabilang sa poorest of the poor na walang pasaporte, driver's license, SSS o GSIS ID o anumang professional license. Noong April 18, tinanggap ng pre-trial chamber ang mga dokumento ng registry bilang patunay ng identity ng mga biktimang aplikante sa kaso at ng mga kumakatawan para sa kanila. Humiling naman ang kampo ni Duterte noong May 1 sa pre-trial chamber ng partial excusal para kina Judge Ren Alapini Gansu at Judge Maria del Socorro Flores Liera, kaugnay ng usapin sa jurisdiksyon dahil daw sa posibilidad ng perceived bias. Posible raw kasing magkaroon ng bias dahil naglabas na raw ng ruling ang mga hukom na ito sa kaparehong issue kaugnay ng sitwasyon sa Pilipinas. Kasabay nito, nagsumite rin ang mga abogado ng dating Pangulo ng isang defense challenge with respect to jurisdiction sa ICC. Ayon sa kampo ni Duterte, walang jurisdiksyon ang ICC na mag-imbestiga sa Pilipinas noong September 2021 dahil epektibo na ang pag-alis ng bansa sa Rome Statute noong March 2019. Pero noong May 6, binasura ng pre-trial chamber ang apela ng kampo ni Duterte na ma-excuse ang 2 judge mula sa usapin ng jurisdiksyon. Paliwanag ng chamber, ang excusal ay maaari lamang hingin ng mismong hukom sa ICC presidency, samantalang ang disqualification ay pwedeng hilingin ng mga partido. At noong May 12, muling umapela ang kampo ni Duterte. Ngayon, ay para tuluyang ma-disqualify ang dalawang judge mula sa paghawak ng kanyang kaso sa usapin ng jurisdiksyon at inakyat nila ito sa ICC presidency. Makalipas ang 2 araw, humiling naman ang Office of the Prosecutor na extension para sa deadline ng pagsusumite ng mga item mula sa mga testigong binanggit sa warrant of arrest laban kay Duterte. Pinayagan naman ito ng pre-trial chamber noong May 21. Noong June 9, iginiit ng Office of the Public Counsel for Victims na dapat ibasura ang challenge ni Duterte sa jurisdiksyon. Ayon sa kanila, walang bisa ang withdrawal ng Pilipinas sa Rome Statute dahil nagsimula ang preliminary examination bago pa man ito naging epektibo. Kasabay nito, nag-convene ang plenaryo ng mga hukom ng ICC at ibinasura rin ang hiling ni Duterte na ma-disqualify ang dalawang judge sa pagdedesisyon hinggil sa kanyang hamon sa jurisdiksyon ng korte kaugnay ng kaso. Noong June 12 naman, formal ng hiniling ng mga prosecutor sa tribunal na tuluyang tanggihan ang challenge ni Duterte laban sa jurisdiksyon ng korte sa kanyang kaso. Kinabukasan nito, muling nagsumite ang kampo ni Duterte ng panibagong mosyon na humihiling na ilipat siya sa isang hindi pinangalanang bansa. Hindi naman daw kasi flight risk si Duterte at dapat bigyan ng humanitarian considerations for the interim release dahil 80 anyos na siya. Pero tinutulan ito ng Office of the Prosecutor noong June 23. Mahalaga raw ang patuloy na detention kay Duterte para matiyak ang kanyang pagharap sa paglilitis. Hindi raw kasi kinikilala ni Duterte ang legitimacy ng mga proseso ng ICC, bagay na makikita raw sa kanyang mga naunang pahayag laban sa korte at sa petisyong inihahin niya sa Korte Suprema ng Pilipinas para hadlangan ang pakikipagtulungan sa ICC. Binanggit din ng prosecution na iginiit mismo ng mga abogado at pamilya ni Duterte na siya ay kinidnap at nangakong ibabalik siya sa Pilipinas. Noong June 25, sumuporta rin ang principal counsel ng mga biktima sa panawagang tanggihan ang hiling ni Duterte para sa pansamantalang paglaya. Sa kabila nito, nagpatuloy ang prosecution sa paghahain ng ebidensya. Noong July 1, nagsumite sila ng 11th batch ng ebidensya at 12th batch naman noong July 4 na naglalaman ng mahigit 1,200 items na nakaayos sa 10 packages. Kabilang ang mga kaso ng pagpaslang sa ilalim ng Davao Death Squad noong panahon ng pagiging alkalde ni Duterte, barangay clearance operations at mga high-value target killings noong panahon ng kanyang pagkapangulo. Sa parehong araw, inilabas ng ICC plenary ang buong desisyon na nagsasabing walang bias sa dalawang judge na naisipa-disqualify ng kampo ni Duterte dahil sila ay kumilos daw batay lamang sa kanilang tungkulin sa lahat ng oras. Noong July 23, nagpasya ang pre-trial chamber na isuspende muna ang desisyon tungkol sa hiling ni Duterte para sa interim release at hintayin ang kumpletong dokumentong ihahin ng kanyang depensa bilang suporta sa kahilingan. Sinubukan ng depensa noong August 7 na ipa-disqualify si ICC Prosecutor Karim Khan dahil umano sa conflict of interest. Dati umanong kinatawan ni Khan bilang pribadong abogado ang mga sinasabing biktima ng drug war ng Administrasyong Duterte at tila inabuso umano ang mga impormasyong nakalap niya nang siya ang maging punong prosecutor ng ICC noong June 2021. Sinabi naman ni Khan na wala raw batayan ang pag-disqualify sa kanya. Samantala, noong August 18, humiling ang kampo ni Duterte sa Pre-Trial Chamber 1 ng indefinite adjournment o walang takdang pagpapaliban ng lahat ng legal proceedings. Kinabukasan ay muling iginiit ni Duterte ang kanyang kahilingan para sa interim release. Noong August 20, nakatanggap ang Victims Participation and Reparation Section o VPRS ng 303 application forms mula sa mga biktima ng drug war na nais lumahok sa pre-trial proceedings laban kay Duterte. Binawi naman ng Defense Counsel ang motion na disqualify si Kano August 24. Pagsapit ng August 28, 2025, naghain ng tugon ang prosecution sa hiling ng indefinite adjournment ng kampo ni Duterte. Humiling sila na makapagtalaga ng sarili nilang medical expert para suriin ang kalusugan ni Duterte. At noong September 6, ipinasa na sa pre-trial chamber ang aplikasyon ng 15 drug war victims para makilahok sa kaso matapos itong repasuhin ng VPRS. 2 araw ang lumipas, inanunsyo ng pre-trial chamber 1 na ipinagpaliban ang confirmation of charges hearing dahil hindi fit to stand trial si Duterte. Ayon sa kanyang kampo, ang lumalalang kalagayan ng kanyang kalusugan ay nakaapekto na sa kanyang kakayahang unawain ang ebidensya at magbigay ng instruksyon sa kanyang mga abogado. Noong September 16, nag-file ang kampo ni Duterte ng bagong defense notification na humihiling sa pre-trial chamber 1 na payagan ang dating Pangulo sa interim release habang nakabinbin ang kanyang kaso. Pero bago ang filing na ito, sinabi ng kanyang anak na si Vice President Sara Duterte na nakausap niya ang kanyang ama sa phone. Ayon sa kanya, nasa maayos na kalagayan ito at nakapagsalita pa tungkol sa kontrobersya sa flood control projects at maging sa usapin ng kanyang love life. Dagdag pa niya, pumayag na rin daw umano ang ikatlong bansa na tumanggap sa dating Pangulo. Noong September 22, inalabas ng ICC ang redacted version ng document containing the charges laban kay Duterte. Ang dokumentong isinumite pa noong July 4. Ang mga kaso ni sinampa ng ICC Prosecution laban kay Duterte ay sumasaklaw sa 78 biktima sa 49 na insidente ng murder at attempted murder kaugnay ng kanyang war on drugs ay tinuturing na crimes against humanity. Kabilang dito ang mga pagpasilang noong siya ay alkalde ng Davao City at maging noong siya ay Pangulo ng Pilipinas. Inilabas din ng ICC ang public redacted version ng pre-confirmation brief ng prosecution. Bagamat heavily redacted na ang dokumento, nabanggit pa rin dito ang mga pangalang De La Rosa at Aguirre. Hindi tinukoy ang kanilang mga unang pangalan, pero binanggit na si De La Rosa ay PNP chief. Matatandaang si Senador Ronald Bato de la Rosa ang unang hepe ng pulisya sa ilalim ng Duterte presidency. Samantala, bagaman walang binanggit na unang pangalan kay Aguirre, ang unang Justice Secretary ni Duterte ay si Attorney Vitaliano Aguirre. Noong September 27, ipinabatid ng kampo ni Duterte sa ICC na tila handa raw ang gobyerno ng Pilipinas na tanggapin ang anumang magiging desisyon ng korte kaugnay ng pansamantalang paglaya ng dating Pangulo habang dinidinig ang mga kaso laban sa kanya. Ayon sa lead defense counsel na si Kaufman, base raw ito sa pahayag ni Palace Press Officer Undersecretary Attorney Claire Castro na nagsabing susundin ng Administrasyong Marcos ang magiging desisyon ng ICC hinggil sa request para sa temporary release. Pero agad itong pinabulaanan ni Castro na giniit na twisting o maling pagbibigay kahulugan ang ginawa ng depensa sa kanyang sinabi. Anya, wala raw involvement ang Malacanang sa aktual na paglilitis ng ICC, lalo na sa interim release request ni Duterte. Gayunman, binigyan din niyang anuman ang magiging pasya ng korte, igagalang pa rin ito ng administrasyon. Nitong October 1 naman, isinumite ng kampo ni Duterte sa ICC ang resulta ng medical assessment na nagsasabing may cognitive impairment ang dating Pangulo. Ayon sa depensa, ito ay base sa ulat ng isang accredited medical professional na itinalaga ng ICC Detention Center's medical officer. Sa 5 pahinang redacted version ng kanilang submission, sinabi ng kampo ni Duterte na tugma ang mga natuklasan ng ICC-appointed doctor sa resulta ng kanilang sariling ekspertong neuropsychologists. Sa kaparehong araw, ayon sa report ng balita.
Please be seated. Veuillez vous asseoir.
Judge Motor. Good afternoon, everyone, once again. Mr. Kaufman, you have the floor for 30 minutes for your final submissions. Please proceed.
Thank you, Madam President. Thank you, Your Honours. I don't propose to present a long rebuttal. The defence has made its submissions comprehensively, and it stands by everything that it has said and presented. I am, however, forced to respond just to a couple of the most egregious observations made by the learned prosecutor and the learned victim's representative. I will start with Mr. Nichols, the prosecutor, who tried to convince you that I had admitted that you cannot trust anything coming out of Mr. Duterte's mouth. Well, he took it completely out of context, didn't he? What I was saying, and what everybody understood, is that Mr. Duterte's speeches alone are totally insufficient to substantiate the charges against him. And the learned prosecutor apparently agrees. He said, throw them all out for the purpose of the confirmation. Even without the speeches, we have enough to confirm the charges. And then he celebrated the fact that he had managed to find one, and I stress, just one example of a direct order, so he thought, to kill, emanating from Mr. Duterte, and that is to be found in Incident 1. So, for the benefit of the record, let me just clarify and repeat what I said, and I refer you to transcript 4, page 65, at line 14 onwards, and I quote, P26, who, redacted, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told it was the mayor on the phone. Hyphen pure hearsay. That's what I said during the hearing. And I stand by my word. But because I thought that maybe Mr. Nichols might have caught me out, I went back to the transcript and the record, and I looked long and hard, and once again I quote P26's words from the evidence. I asked who called, and the redacted third party said, Superman. And to make things clear, the prosecutor's investigator then asked P26, was the person who took the call, was the redacted third party? And the answer he received was yes. So I repeat my submission with even more emphasis, pure, unadulterated, and undiluted hearsay. What Mr. Nichols' rebuttal boils down to, maybe he didn't mean to infer it, but he did, all it boils down to is a plea that, well, Kaufman's pointed out a few problems, let's just leave it for the trial judges to sort out. And for that, he's quite happy to let Mr. Duterte fester in detention for years to come. In the United States, they call that kicking the can down the road. And as for the learned victim's representative, I've been restrained up until now. I have paid my respect to the families of those who have lost loved ones, and I repeat that expression of sympathy that I made as my very first statement on behalf of the defense. But I would like to remind the learned representative for the victims that he is not a mini prosecutor, and to regale the pre-trial chamber with unsupported allegations that many, many children lost their lives is utterly inappropriate. His stance and that of his colleague have reflected the media reporting of this case, namely complete disregard of the evidence, and to be frank, you haven't heard one single piece of evidence cited by them. That's why they have Ms. Massiter sitting next to them. Indeed, the media interest in this case has been intense, but it has followed a familiar theme. Rodrigo Duterte is finally behind bars where he belongs. And as a defense lawyer, I stand up and I talk about due process, fair trial rights, and the presumption of innocence. But what use is that when the whole world has already tried and convicted him, and furthermore, make emotional arguments to justify their position? What about the presumption of innocence? Mr. Butuyan talks about threats emanating from mini Dutertes. He says that people are threatened by Duterte clones in countries all around the world. He tells you about Rodrigo Duterte converting millions of peace-loving citizens into bloodthirsty disciples. Not dozens, not hundreds, but millions, so Mr. Butuyan says. What an insult to the Filipino nation. And Mr. Butuyan concludes by presenting an emotional ultimatum. Confirm or Duterte will be portrayed as the person who vanquished the ICC. Those were his words. These submissions were quite unique for this court, and of course, totally irrelevant for the purpose for which we are gathered here today. And as for the mainstream media, back in the Philippines, the situation is not much better. When I argue that there has been interference in this case at the highest level, relying not on documentation that I have invented, but on documentation given to me by the prosecution as exonerating, they say I'm making a political speech and that my defense lacks substance. And when I devote more time than the prosecution and the victims together to legal arguments and challenging the evidence, they say I'm nitpicking. Well, fortunately, we have this honourable bench which appreciates the presumption of innocence and the need to examine the evidence thoroughly in order to examine whether the prosecution has proved its case to the required standard. We are fortunate in that we have this honourable bench to review the various arguments dispassionately and professionally. And we know that this honourable bench, despite our struggling with the various redactions that have considerably reduced our ability to make comprehensive submissions in open session, we know that this bench will assess our arguments faithfully. We have provided a comprehensive analysis of both the law and the charged incidents. We have attacked every single count in open session while doing our very best to respect the restrictions imposed upon us and applied by the prosecution to its charging document and pre-confirmation brief. And these redactions have not just been a few here and there, they have been so sweeping that virtually nothing intelligible remains of the 49 incidents that we have been talking about for the public to read and to understand. Let me just screen you an example from the public record, from the public version of the pre-confirmation brief, so that the whole world can appreciate it. And the same goes for the redactions applied to the identities and roles of the various criminal cooperating participants. While I found this unfair and contrary to the spirit of transparency, which is meant to govern the conduct of the proceedings at this institution, I approached my counterpart in the prosecution and complained that the nature of his redactions would mean that most of my meaningful submissions, namely the attack on the evidence substantiating the 78 deaths, would require me to go into closed session. Don't worry, I was told by the learned prosecutor. We're going to release a lesser redacted version of our charging document and confirmation brief. Wonderful, I said to myself. But what in due course did we get? A document which merely released the names of the 8 so-called co-perpetrators and which caused a storm in the Philippines. It even caused the Secretary of the Interior to state that his department had begun tracing the whereabouts of these so-called co-perpetrators. And in its lesser redacted version of the document containing the charges and pre-confirmation brief, the prosecution also released the names of certain high-profile victims which it had selected, thereby enabling it, and it alone, to talk freely in open session about certain incidents that it felt crucial to its case. From this, I submit, Your Honours, you can really appreciate the true inequality of arms facing the defence as it attempts to defend a client in the public eye, I stress in the public eye, at the International Criminal Court. This inequality of arms in the public eye expresses itself in the way the prosecution controls the narrative by arbitrarily lifting redactions so that it can make its narrative of a grand scheme of co-perpetration known to the public in open court, while the defence can only meaningfully attack the real meat and the substance of the charges either obliquely or in closed session, including that hotly disputed incident with the CCTV. Well, we hope that we have found a way around that by referring Your Honours to the relevant places in the evidence, and we do trust you to pick up on the problems without the benefit of our full explanations in open session, even if the remaining part of our plea was rendered rather dry. But I do assure you, the general weaknesses that we have identified pervade throughout and are so recurring that the total value of the prosecution's evidentiary matrix drops not just below the substantial grounds threshold that the prosecution must meet, but hits the very rock-hard bottom. And I will summarize these weaknesses once more for the record. Layered hearsay, conjecture, over-reliance on accomplice evidence with offers of virtual immunity at the ICC, contradicting statements between participants in a crime, absolute lack of any linkage whatsoever to Mr. Rodrigo Duterte, and the total lack of support for an alleged crime both in the documentary and forensic record. And regarding these documents, it is not enough to argue that the Duterte administration destroyed them. There is absolutely no evidence for that. It is an outrageously unsubstantiated accusation which is not alleged, and where the documentation does exist, the prosecution is quite happy to rely on it. But what is this threshold, this substantial grounds to believe threshold? Well, clearly it is not beyond a reasonable doubt. That's the standard required for a conviction at trial. But it is considerably more than reasonable grounds to believe, which is the standard applied for the issuance of an arrest warrant. If I may, let us take the analogy introduced by Mr. Butuya, that boat of his that set sail in order to avoid leaving his victims stranded on an island. Your Honours, this boat is the confirmation process, and its captain is this honourable bench. We are all passengers in this boat. The favourable winds in the sea and in the sails are for the prosecution, the incriminating evidence, and the sharks and the rocks in shallow waters are the exonerating evidence, the hearsay, the contradictions, and the accomplice witnesses. I ask you to consider how many sharks and rocks that we have discovered and pointed out to you through our binoculars. Would you board that boat if you knew that there was substantial grounds to believe that the boat would sink if it encountered one of the aforementioned perils? Let me define the test using more strictly legal language. The evidentiary standard applicable, namely substantial grounds to believe, is met with respect to a discrete incident when, and I quote from paragraph 38 of the Said confirmation decision, there exists concrete and tangible proof demonstrating a clear line of reasoning underpinning the specific allegations. By way of parenthesis, I should state that this quote from the Said confirmation decision recognizes the fact that each pleaded incident in a document containing the charges must be proved to the requisite standard for it to be adduced at trial. And that is what we request the Honourable Pre-Trial Chamber to consider. I have been asked by the many journalists who literally mobbed me outside this court building whether I have been reporting on the proceedings to the former president. And I tell them, yes, of course, that's my duty as a lawyer. I have to report to my client. It would be unethical otherwise. And they ask me, what has he to say about the case? Well, I'm going to enlighten you all a bit. For the best part of a year, we have been litigating the issue of jurisdiction and fitness. Your Honours have delivered your rulings. However, even though you found him capable of standing trial, I permit myself to tell you just a little bit about what really goes on in prison. No more than a kilometre from here. I permit myself first to tell you about his reaction to the demand of the prosecution and the victims that he appear. I won't hide the fact that I thought it best for him to appear, not out of a need to satisfy the desire of the prosecutor and the victims who desperately want him to face his accusers so that they can wave their collected finger at him despite the presumption of innocence. I did not want to disappoint his many supporters. That was my reasoning. Those mini Duterte clones, as Mr. Butuyan derisively calls them, who have been deprived of seeing their former and beloved president for more than a year. I told him that Your Honours could have rejected his request to waive the right of attendance. We even had a barong specially fitted for him so that he would not have to suffer the humiliation of being put into an out-of-size blue suit, which would now dwarf his meagre physical body. The same blue suit in that dreadful photograph, which still remains on the ICC website and that I would ask to be removed. But he took his decision, and as his counsel, I was obliged to respect it. And the day before yesterday, when Your Honours gave us a break, I went to that prison and I sat with him for an hour. I tried to engage him concerning the evidence, and he lost the desire to follow me within less than a minute. I offered to show him excerpts of the confirmation proceedings, a few minutes of the deputy prosecutor, a few moments of Ms. Massiter, and hoping that it might excite him a bit more, some of my own opening statement. He shook his head firmly. I implored him. I said, "Sir, look at what we are doing for you. We're doing our utmost to get you out of here." But once again, he politely declined. And I asked him why. I said to him, "Sir, don't you understand? They accuse you of murder. They say that you murdered thousands when you were the mayor and when you were ruling your country." And then he repeated the question that he has always asked me for a year or more. "How does the prosecution say that I did this?" "Well," I replied, "I thought until Monday that it was because of those speeches of yours. But then your prosecutor told the honourable judges the other day, throw them all out. They're not necessary for the confirmation. He claims that he still has enough evidence to convict you without all the bluster." And the former president repeated the question, "But how? I've never murdered anyone, and they talk about thousands." And then I tried to explain to him arcane concepts such as indirect co-perpetration, and then his eyes simply glazed over. And who can blame him? As I mentioned, it is the only highly technical means whereby the prosecution can artificially connect him to criminal activity not of his own doing. I then tell him that the people who are incriminating him are self-confessed murderers cooperating with the prosecution, whose names we can't mention in public. I tell him that in return for their dubious services and their expressions of so-called remorse, as the prosecutor puts it, they will not face trial at the ICC, probably nowhere in the world, and will be rehoused with new identities. Mr. Duterte, the ex-prosecutor, like me, can't understand the fairness of that, relying on not one, but a number of vicious criminals to convict him, when he remembers that he is supposed to be presumed innocent. I tell him the names of those criminal cooperating witnesses, because apart from us, he is the only person who is entitled to know. He tells me that he has not heard of any of them, apart from two, who he vaguely recalls from his days as mayor. Concerning one, his comment is liar, and concerning the other, scallywag. And then, exactly in the spirit of the waiver filed with this court, he looked at me solemnly and said, "Mr. Kaufman, Nick, I have done my duty and I have left my legacy. Go to court and do your job, but I can no longer help you. I no longer remember much at all, and I can't comment on people who I do not know and on statistics that mean nothing to me." He then concluded and pronounced as follows: "I was a faithful servant of the people, and that is how I wish to be remembered. I have now accepted my fate, and I realize that I could die in prison." And on that somber note, my team and I realized that there was no point in continuing. So we tried to humor him We told him that next month he will be 81. And we reminded him of the many people who visit Duterte Street and Ducality, just outside the ICC detention centre, referred to by the many, many pilgrims who have visited The Hague to feel closeness to his presence, even if they cannot witness his actual person with their own eyes. We remind him of the mountain of cards and greetings and of the forest of flowers that he received both at the detention centre and at the court's premises on his 80th birthday. So many cards, all of which were read by his family, that we had to provide 2 sacks to take them back to our office. So many bouquets of flowers that the prison had to bring a van to take them away. The flowers that reached the court premises were strategically placed around the building, and although so appealing and desirable and coveted by the staff, were avoided once the staff was told of their origin. So these flowers just rotted in the corridors until the smell forced them to be thrown away. We showed him some photographs of his family. We showed him photographs of his youngest daughter, Veronica, Kitty, who writes to him every day so often that the letters are piling up in his room. His face starts to light up. We showed him pictures of civic events in the Philippines with Sebastian Baste and Paulo Pulong present. He laughed and told us what he remembers of their days as young men in Davao. We showed him pictures of Inday Sara greeting the enthusiastic crowds of people in the Philippines, and then finally his face beamed with pride. Your Honours, it is so easy to choose as a target for prosecution a politician because of the way he presents his policies. If Rodrigo Duterte is to be faulted for anything, it is for his inappropriate choice of language. But he murdered no one. Out of that huge database of evidence on which the prosecution relies, I repeat that there is absolutely nothing to directly link Rodrigo Duterte to the 78 deaths alleged. That is why they rely on a few selective and vociferous individuals in the Duterte administration, calling them co-perpetrators, just so it can artificially superimpose their fantasy common plan theory linking Rodrigo Duterte to the victims. Your Honours, I beg you to be guided by evidence, which must reach a minimal level of integrity. Be persuaded by your own innate sense of justice and by your own collective years of experience. But most importantly, be guided by coherent evidence and by common sense. I ask you, I beg you not to confirm any of the charges. I ask you to let Rodrigo Duterte return to the Philippines, not to govern, but simply to let him live out the rest of his days in peace, in his humble dwelling in Davao. And with that, Your Honours, I conclude, and I wish to thank you for your patience, and to thank the parties and the participants, and most importantly, my team, Dov Jacobs, Havnit Nikisetti, Sandrine De Sena, Davide Rancati, Alexandra Dezev Davi, Nicholas Russo, and Kaylin Chen, all of whom have worked throughout the last year for one cause alone, and that is to serve our client, Mr. Rodrigo Duterte, faithfully.
Merci beaucoup. Judge Motok, thank you very much, Mr. Kaufman. The chamber, my colleagues, and myself, we have the duty to recall certain issues. First of all, the reductions that you have mentioned now, it was already raised by the defense, and the chamber had taken a decision rejecting the position of the defense. The number of the decision is 388. And I should say that the quality of arms is ensured because the defense has access to the redacted information. It just is not available to the public. Secondly, you talked about the health and capacity of the suspect. As you have clarified, this issue was already addressed by the chamber, and the defense must not make submissions on that point now because it is not appropriate. The decision is already available in the public domain. I thank you very much, and with that we come to the end of the confirmation of charges hearings. I thank the parties. Did you want the floor, Mr. Prosecutor?
Yes, whenever is convenient for you, Your Honor. Yeah, thank you, Your Honor. I don't want to stand up and object to my friend, but I would request and ask that you strike and not take any account of any word that my friend said came from his client. None of that was responsive to arguments, which is what these last 30 minutes were about. You made that clear on pages 24 and 25 of the transcript today, and it's in paragraph 9 of your order on the conduct of the hearings. Second of all, my friend can't testify for his client or make a speech for his client. That's governed by Article 67H. If he wanted to come here, he didn't want to come here, he could have come here and talked about whatever he wanted to, but he chose not to. Mr. Kaufman's conveying this. He's been complaining about hearsay all day. It's not reliable, but beyond that, if Mr. Duterte wants to speak to the court and speak to the gallery, he should come here, request to make an unsworn statement. He shouldn't do that through his counsel. So I ask that all of that be given zero relations. Thank you.
Thank you, Mr. Prosecutor. You want the floor again, Mr. Kaufman?
Madam President, but I do believe that the defense has the right to respond.
Wait.
Yes, says Judge Moto.
And I say to Mr. Nichols that this was not testimony. It was purely an explanation for him not coming to the hearing. He has the maximum respect, obviously, for your honours, but he has his arguments, which we shan't repeat here once again. They were all set out in the waiver. That was not testimony, I assure you, Mr. Nichols.
Merci. Judge Moto, thank you very much. Now the bench will withdraw to deliberate, and we will render a decision on the confirmation of hearings within 60 days in accordance with the instruments, the provisions. We will come back to this court for a hearing on Mr. Duterte's detention. Court is suspended.
Ayan, kaka-anunsyo lamang po, magbabalik pa ang pre-trial chamber para naman talakayin ang detention ni dating Pangulong Rodrigo Duterte. Attorney, ano bang masasabi mo? Kanina pinag-uusapan natin, we expect speeches, impassioned speeches, appeals to emotion. At mukhang nakita natin yun sa depensa.
And he did not fail us for that, no? And nakita natin how passionate the defense is on the issues. In fact, he was accused by the prosecutor of really not only appealing to the emotion, but his speech, and he should not testify on behalf of the former President Duterte. But going back to his main arguments here, he started by attacking on the victim's common representative here, especially on alleging that he is not a prosecutor, and he cannot just say some things there without evidence, and these are irrelevant according to him, and that also that the statements, for example, on comprehensive attack, I mean on the single count or every single count, he answered that, and also he went back to the media and the public confirmation aspects, no, and this has been an issue that is an argument by the defense, but the main points there are attacking the prosecution's evidence on being a hearsay, conjecture, contradictory statements, absolute lack of linkage, the lack of support, such as forensic records, and also the no substantial arguments were mentioned here. And also, as to the question on substantial grounds to believe and to proceed, na dapat daw we look into the concrete and tangible proof. He mentioned about this case of Said, no? And this is a case involving the Central African Republic. And in that particular case, I would suppose that during the confirmation decision, the decision was that there is a confirmation of the cases for crimes against humanity, saying that the judge here considered that there was a widespread attack against a civilian population and it has met the contextual requirements. No? And after that, by presenting all this, he went back to the statements that they were deprived to tell openly to the public and to the followers of Duterte. Some redacted, their redactions are actually impeding them to proceed on presenting their own narrative or storyline. And here, we have also heard about the speech or the statements in relation to the case of President Duterte. And in fact, he was saying that he was deprived of some sense of justice, and that's why he begs that this confirmation will not proceed.
Oo. At ang binanggit niya, medyo naging striking para sa akin to. Ang tanging naging kasalanan daw ni dating Pangulong Duterte ay ang kanyang paggamit ng inappropriate choice of language. Dahil nga nagamit sa kanya ginagamit sa kanya ng prosecution yung mga parte ng kanyang mga speech kung saan sinabi niya ang kill, 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 kung saan ipinagmamalaki niya, ganun ang kanyang polisiya. May open threats or may open warnings to those involved in illegal drugs and so forth and so on. So, yun daw ang naging problema niya. Pero again, hindi raw napatunayan, according to the defense, na may criminal intent at hindi naman nangahulugan na porket sinabi niya yon ay nagkaroon nga ng mga pagpatay on account of those words.
Yes, ang daming statements ng prosecution on the words, no, and the speeches, the videos, and all this. No, so this was expected also on the part of the defense to question on the words used by the former President Duterte, and if he went to actually looking at the evidence here and the elements of or requirements for the crimes against humanity. And we take note here that the threshold that we need is only substantial grounds. That we have to go beyond the speculations or conjectures, and we have to go to the possibility of going to the trial, and then there is enough evidence that is admissible.
Attorney, tanong ko lang sa inyo, bakit parang napaka-fixated nitong si Attorney Kaufman sa Philippine media? Mula nung day one, mula nung kanyang opening statement, hindi niya banggitin ng media para bang na may tonong paninisi na ang media ay kasali rito, kaya nandito sa ganitong sitwasyon ng dating Pangulo, ay may papilang media rito. Ito naman, why does he feel compelled to respond to how media reported on his opening statement or on his arguments?
I'll take his word, and he said when there were redactions on the statements nila, they were not allowed to state their own narrative. So that's why, pero titingnan natin from the opening statements up to the closing statements that the media here is at the center. In fact, the reports are coming from the media, from the NGOs that were presented by the media also. So siguro on that end, no, makikita natin that the words of Duterte were all taken from this media reporting.
Okay. Dean, maraming salamat for sharing your expertise with us tonight. Nako, napakarami na para tayo nasa law school dito. Dean Rodel Taton, maraming salamat po sa inyong tulong na lubos nating maunawaan itong confirmation of charges hearing ng International Criminal Court. Dean,
thank you very much, Ivan.
Thank
you very much po sa inyo lahat.
At magpapaalam na rin po ako, pero tuloy-tuloy pa rin po ang ating coverage para naman sa hearing on the review of detention ng ICC. Sa ngalan ni PR Kanghel, ako po si Ivan Mayrina. Magandang gabi.
We can now move on to the defense and their submissions on the merits. Mr. Kaufman, you may address the court.
Now, before I start, I would like to make one general comment, and it's a comment which every defense counsel who appears before this court is obliged to make. So if the mainstream media in the Philippines and the NGOs reporting on his case today report anything about the defense's submissions, I hope that they will at least communicate the following faithfully. The defense does not disrespect the soul of any deceased person, nor does it make light of the loss of life. Any criticism made by us today will not be leveled at the loved ones of those such as the tearful relative who I saw in the gallery here on Tuesday. The defense's criticism will be confined only to the prosecution's document containing the charges, which governs these proceedings, not what has been reported elsewhere in the media. It's not the defense's role to give an alternative narrative, nor to give an explanation for the facts and figures presented by the prosecution. The defense's role is simply to persuade your honours that Mr. Rodrigo Duterte should not remain in detention for years to come, simply because the prosecution cannot make out substantial grounds to believe that this individual committed the crimes with which he is charged. Now, Mr. Julian Nichols confidently said the other day that you can ignore Rodrigo Duterte's speeches. Disregard every speech ever made by Mr. Duterte, he said. Throw them all out. There is still ample evidence of the substantial grounds based on the other evidence. That's transcript T4, page 45, lines 5 to 6. Helpful advice from no less than the day-to-day prosecutor in charge of this case, because we will show that the evidence is not substantial, rather totally inadequate. But in any event, since I can leave no stone unturned, I now turn to those speeches. Now, if there's one thing that I've learned from the domestic media coverage of this case, it is that journalists and their editors have a tendency to fixate on the salacious elements of a person's speeches while ignoring the less interesting parts. And so it was with Rodrigo Duterte. The prosecution has had its opportunity to show you a selection of these speeches and seems to believe that the more they show, the greater the chances of convincing your honours to confirm the charges. But what the prosecution has not told the public is that in its document containing the charges, which governs these proceedings and nothing else, it has only supplied 20 of these speeches as proof of criminal intent. And as I mentioned in my opening statement, 10 of these speeches, including 2 referred to by the deputy prosecutor, actually contain an exhortation to the use of lawful self-defense. Thereafter, we found a further 35 speeches, which will be found at tab 9, 11 to 26, 29 to 35, 37 to 41, 43 to 46, 137, and 152. Now, this is obviously not a competition. The point we really merely wish to make is that relying on the former prosecutor's speeches as a means of proving criminal intent is impossible. Now, I'd like to go back to that one speech which I promised the other day to show you. This is a speech, the second speech that the deputy prosecutor referred to in his opening statement. And this refers to the responsibility that Mr. Duterte said that he would shoulder, promising to shield rogue officers from prosecution. If we may, the first of these speeches, and I quote what the deputy prosecutor read from this speech. So the police is under the DILG, so I have to believe the story of the police, for simply they are my subordinates and I am ultimately responsible for their deeds. Now let's look at what the deputy prosecutor didn't state from the same speech. And the order is simply this: go out, arrest them if you can. But if there is no peaceful method of doing it and you're presented with violent resistance, thereby placing your jeopardy in your life, you shoot, well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, this is, I apologize, PHL OTP 00001127 at page 5. And I quote, "But if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility." Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, "Just do it right. We have our trainings that you can only kill if your life is in danger, and you are there performing the duty of a law enforcer. That's about it." Now I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find. And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech which the prosecution either missed or ignored because it doesn't suit its case. And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this, "I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today. Make no mistake about it. I repeat, again for all and for everybody's consumption, do not kill if you are not in danger of losing your life." Well, it goes on. You can see it there on the screen. Well, of course, the prosecution knows that we are going to argue that many of these speeches, in fact, the majority of these speeches, I would say, contain this exhortation to the lawful use of self-defense. And the learned counsel, Mr. Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel concept of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask your honours and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had a speech of 2 pages prepared, but to his regret, it didn't come from the heart. And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colourful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy, quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth, and that hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to produce, the prosecution on the matter, is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers. The same goes for another witness's outlandish assertion that bodies were thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced. As for counts 2 and 3, Ms. Croft showed us some maps with coloured dots to indicate the magnitude and geographical spread of what the prosecution alleges, without, of course, proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, for this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the appeals chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432 in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient. Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered, but she neglected to contextualize these numbers by reference to other parts of the same report which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages. So, if I may just conclude, the only thing that is widespread here, or rather spread wide, is the utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory, with respect to the definition of the targeted population, is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting two alternative propositions, hoping that this pre-trial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, comprised prison detainees, professors, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? It was not as if it had been denied the arrest warrant for El Hishri that it had sought. Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10 February 2025, the prosecution rushed out its application for Mr. Duterte's arrest. believing that a unique opportunity to apprehend him had arisen. In this application, the prosecution defined the attack perpetrated by Mr. Rodrigo Duterte as being aimed at the entire population of the Philippines. Let us now fast forward to 10th July 2025. The pretrial chamber, this same pretrial chamber, ordered the arrest of Khalid al-Hishri for an attack on an objectively identifiable civilian population of detainees, while finding no justification to suspect him of crimes committed against a discrete subsector of that population, exhibiting characteristics distinct from those of the general population. Well, as you can guess, the prosecution didn't like that decision and hastened to appeal it. Not, I would suggest, out of any true concern for the purity of international humanitarian law, but rather because it put a spanner into the works of the Duterte case. That is, the only other active case that it is prosecuting before this court. After all, if we apply the resulting logic of Your Honour's decision in al-Hishri to the prosecution's case theory in the Duterte case, at least as it stood as of 10 July 2025, then alleged drug pushers and alleged criminals would be deemed a separate, subjectively defined subgroup of the general Filipino civilian population, displaying different characteristics and, as a result, excluded as targets of the attack. So, 8 days passed between this decision of yours, Your Honours, and the notification of the confidential version of the prosecution's pre-confirmation brief on 18 July last year. And I'm prepared to wager that while beavering away with their attempt to appeal the al-Hishri decision, the gurus on the top floor of the Office of the Prosecutor were also frantically discussing how to deal with this inconvenient fly in their conceptual ointment. They had to think of a way to accommodate this pretrial chamber's ruling while not compromising their appeal. So, lo and behold, and rather unsurprisingly, the pre-confirmation brief contained a new feature, namely the second scenario to which I referred earlier, that the target of the attack was not the Filipino as a whole, but the suspected drug pushers and criminals. Now, even if the former president did promulgate an organizational policy of eliminating suspected criminals and drug pushers, which he most definitely did not, this policy did not and could not constitute an attack directed against a clearly definable civilian population. Firstly, the segment of society victimized cannot be said to display objective characteristics distinguishing them from other members of society and thus rendering them susceptible to an attack. After all, how does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count one, where there were no HVTs or high-value targets or PRD lists or kill lists or what have you? It is not as if criminals have identifying features such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. It is a shifting and mutable concept. It is a subjective determination. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group such that they can be deemed a civilian population for the purposes of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection. and as cited quite clearly in the Al-Hassan confirmation decision at paragraph 149, the prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorising an investigation in the Kenya situation, where at paragraph 81, the pre-trial chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole and not merely against randomly selected individuals. So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole or at a subjectively defined subgroup of perceived or alleged criminal offenders. The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly. Even according to the prosecution's own witnesses, who talk about quotas of neutralization that had to be met, and their motives for target selection, which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards. With that, Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration. Now, I have racked my brain for many a month pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after Rodrigo Duterte pulled his country out of the International Criminal Court? After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, it didn't take too long for the penny to drop. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred. And so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b). But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the pyramid of Giza. The most they can do is allege that their cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso, understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers, or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case. And that is not for want of a desperate attempt to find one on the part of the prosecution, with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone. Let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges levelled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say,
dumami nga po ang kapatid kong lalaki dahil sa paiba-iba na picture na nilalagay nila. Isa lang po yung kapatid ko. His name is Ephraim and he's 2 years younger than me.
Can you comment after that, yung mga manipulated photo? How are you after maging victim ka ng mga manipulated
Last
photos?
year po, ginawa na rin po nila yan sa aming mga families ng victim nung na-arrest ko si Duterte. Sa akin na lang po, we try our best not to engage kasi wala naman po siyang ang bad sa case na mayroon. Bully us, harass us, threaten us. It won't change the fact that Duterte is still in jail and yung decision will still be up to the judges. Hindi po kami yung magpapasya. Yung judges po yung magpapasya kung anong mangyayari kay Duterte kung makakalala po siya.
Kanina po sinabi ni Attorney Gilbert Andres na yun nga yung mga biktima, pamilya ng mga biktima na kumbaga ito na yung pagkakataon ninyo na makalaya dun sa shadow o yung anino ng misinformation and disinformation. Ano pong masasabi nyo dito, ma'am? At ano po ba yung kumbaga experience nyo? Baka pwede nyo po maihalahad din po sa amin yung sinasabi po ni attorney tungkol dito sa misinformation.
Oo, tama yun na itong umpisa ng confirmation of charges at saka yung mga paglahad ng mga prosecution natin ng kanilang mga arguments ay sana maano po nila mapag-aralan, tingnan mabuti kung ano yung argumento. At ito po yung talagang ito po yung umpisa na talagang hindi man totally na makalaya kami, kundi unti-unti kaming makalaya. Kikilalanin nila na talagang kami ang mga biktima at hindi si Duterte dahil si Duterte ay nakakulong kaya nakakatakulan kasi nakakulong. Pero ang totoong biktima, kami po yun. Kasi kami ang nagdudusa. Kami po ang nakaranas ng mga panlalait, pangbubuli, kung ano pa man na sinasabi na you deserve to die, mga ganyang salita. Siyempre napakasakit po sa amin. Kaya ito na po ang umpisa at hopefully ay inaasahan po namin na magtuloy-tuloy na po hanggang sa dumating yung trial. Sunod-sunod na po.
Ma'am, sa experience niyo po dito sa The Hague, meron din po ba kayo naranasan na kumbaga na outright na pambubuli, bukod po doon sa nakita nating online na kumakalat, mga pagpapalit ng photo, pati yung mga bags ninyo, may mga experience din po kayo personally na naramdaman habang nandito po dito sa The Hague?
Kanina may lumapit pero hindi kasi namin alam, sabi niya natuwa daw siya sa mga namin ni Sierra, yung aming mga yung videos daw. Napanganga ako, sabi ko ano yun? Tapos yun, sabi naman ni Sierra, sabi niya kasi natuwa daw siya kaya i-ano daw niya, i-upload ba yun, Sierra? I-share. So iniisip namin ano bang mga videos yun, mamaya video na kung ano-ano na naman, yung pala nalaman namin na ano pala siya, reporter na supporter.
In relation to that, ang Duterte Panagutin Network Europe, we want to issue a statement officially. So I hope this gets covered. So in the past few days, the victims' families and their legal representatives have been subjected to bullying both online and offline by Duterte supporters and bloggers that support the former president. On February 22, our contingent was heckled by Duterte supporters, calling us supporters of drug addicts. Our security team has also been filmed without their consent and have been subjected to slanderous comments on social media. On February 24, Shira and Nanay Llore in particular were filmed while in transit without their consent, and said footage was used as a means to facilitate derogatory remarks from troll armies. On February 22, they have also been subjected to AI-generated fake news by a Duterte supporter, Cathy Binag, showing them supposedly with luxury bags. So we appeal to the good nature of our fellow countrymen, fellow Filipinos. Please respect the right to privacy. We ask you to cease from relentless targeting of the victims. They have suffered enough. And as supporters of the victims, we will hold the line for them. Duterte Panagutin Europe intends to file legal charges to the said individuals, both here in the Netherlands and those in the Philippines. What they did are clear violations of the EU General Data Protection Regulation, or GDPR, and the AVG law in the Netherlands, and we are already consulting with Dutch lawyers regarding this matter. And in the Philippines, we will also explore filing cyberbullying cases under the Cybercrime Prevention Act. We are preparing to file official police reports to the concerned individuals as well. In addition, we intend to submit reports to Meta and to request these posts to be taken down, and if necessary, to take down the said pages or profiles entirely and permanently. Thank you.
Any more message, ending message from the...
May tatanong sana ako sa kanila, Nelly and Shira. So, ilan lang kayo sa mga nagkaroon ng pagkakataon na makabiyahe dito sa Netherlands at masaksihan niya personal yung pre-trial. Sa pagbalik ninyo sa Pilipinas, pag nakita niyo mga ibang group, mga biktima, anong ibabahagi ninyo sa kanila pag balik ninyo doon sa Pilipinas?
Pagbalik namin doon, napakaraming ibabahagi. Ang aming mga karanasan, maganda man o hindi maganda, kailangan malaman nila. At kung ano yung laman nung ilang araw na confirmation of charges from the start to the end. Yes, yes.
Siguro po sa bahagi ng Rise Up for Life and for Rights, actually po, yung mga pamilya po ng biktima ay nandun sa Pilipinas. Sinusubaybayan po ito mula pa nung Monday, Tuesday, tapos yung Thursday at hanggang ngayon po. At nagkakaroon din po ng ganitong mga pagpapahayag. Kaya sa pagbalik po namin, nais po rin namin ibahagi din sa kanila at magkakaroon ng pagbabahagi namin, processing din kasi hindi po biro ang naranasan namin dito. At ganoon din po yung mga pamilya na nandun sa Pilipinas. Actually, dala ko rin po yung mga ilang larawan ng mga bata. Sila, yung isa pong nanay natin ay siya rin core leader din po na nagsasalita po sa Pilipinas. So, sana po, nandito man o sa Pilipinas, patuloy po natin supportahan yung kalawagan ng pamilya sa Pilipinas. Naririto po sila bilang kinatawan. At pinag-usapan po yan ng proseso kung paano dadalhin ang ating kampanya para sa pagpapanagon. At nagpapasalamat kami sa kapag-araw na ito na pansamantalang natapos. Medyo, sabi nga namin, parang roller coaster yung mga emotions namin, pagtaas, pababa, pataas. Pero ngayon, naririto po. At asahan po natin na sana makontinue sa doon.
Huling mensahe po, ma'am, sa inyo pong lahat para po maintindihan po kayo ng mga taong bayan.
Para po sa amin, we stand, para po sa amin, mananatili po kami nakatutong sa katotohanan at we'll never stop fighting for justice. Even if it will take us more years, we're very willing to participate sa kung ano man po yung maging proceeding ng ICC, and I'm very excited to finally go home pagkatapos po nito at ikwento sa mga nanay kung ano yung itsura ng due process na pinagkait sa amin ng mahabang panahon.
Thank you po sa inyo lahat.
Salamat po. Thank you po.
We can now move on to the defense and their submissions on the merits. Mr. Kaufman, you may address the court.
Now, before I start, I would like to make one general comment, and it's a comment which every defense counsel who appears before this court is obliged to make. So if the mainstream media in the Philippines and the NGOs reporting on his case today report anything about the defense's submissions, I hope that they will at least communicate the following faithfully. The defense does not disrespect the soul of any deceased person, nor does it make light of the loss of life. Any criticism made by us today will not be leveled at the loved ones of those such as the tearful relative who I saw in the gallery here on Tuesday. The defense's criticism will be confined only to the prosecution's document containing the charges, which governs these proceedings, not what has been reported elsewhere in the media. It's not the defence's role to give an alternative narrative, nor to give an explanation for the facts and figures presented by the prosecution. The defence's role is simply to persuade your honours that Mr. Rodrigo Duterte should not remain in detention for years to come, simply because the prosecution cannot make out substantial grounds to believe that this individual committed the crimes with which he is charged. Now, Mr. Julian Nichols confidently said the other day that you can ignore Rodrigo Duterte's speeches. Disregard every speech ever made by Mr. Duterte, he said. Throw them all out. There is still ample evidence of the substantial grounds based on the other evidence. That's transcript T4, page 45, lines 5 to 6. Helpful advice from no less than the day-to-day prosecutor in charge of this case, because we will show that the evidence is not substantial, rather totally inadequate. But in any event, since I can leave no stone unturned, I now turn to those speeches. Now, if there's one thing that I've learned from the domestic media coverage of this case, it is that journalists and their editors have a tendency to fixate on the salacious elements of a person's speeches while ignoring the less interesting parts. And so it was with Rodrigo Duterte. The prosecution has had its opportunity to show you a selection of these speeches and seems to believe that the more they show, the greater the chances of convincing Your Honours to confirm the charges. But what the prosecution has not told the public is that in its document containing the charges, which governs these proceedings and nothing else, it has only supplied 20 of these speeches as proof of criminal intent. And as I mentioned in my opening statement, 10 of these speeches, including 2 referred to by the deputy prosecutor, actually contain an exhortation to the use of lawful self-defense. Thereafter, we found a further 35 speeches, which will be found at tab 9, 11 to 26, 29 to 35, 37 to 41, 43 to 46, 137, and 152. Now, this is obviously not a competition. The point we really merely wish to make is that relying on the former prosecutor's speeches as a means of proving criminal intent is impossible. Now, I'd like to go back to that one speech which I promised the other day to show you. This is a speech, the second speech that the deputy prosecutor referred to in his opening statement. And this refers to the responsibility that Mr. Duterte said that he would shoulder, promising to shield rogue officers from prosecution. If we may, the first of these speeches, and I quote what the deputy prosecutor read from this speech. So the police is under the DILG, so I have to believe the story of the police, for simply they are my subordinates and I am ultimately responsible for their deeds. Now let's look at what the deputy prosecutor didn't state from the same speech. And the order is simply this: go out, arrest them if you can, but if there is no peaceful method of doing it and you are presented with violent resistance, thereby placing your jeopardy in your life, you shoot, well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, this is, I apologize, PHL OTP 00001127 at page 5. And I quote, but if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility. Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, just do it right. We have our trainings that you can only kill if your life is in danger, and you are there performing the duty of a law enforcer. That's about it. Now I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find. And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech which the prosecution either missed or ignored because it doesn't suit its case. And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this: "I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today. Make no mistake about it. I repeat again for all and for everybody's consumption. Do not kill if you are not in danger of losing your life." Well, it goes on. You can see it there on the screen. Well, of course, the prosecution knows that we are going to argue that many of these speeches, in fact, the majority of these speeches, I would say, contain this exhortation to the lawful use of self-defense. And the learned counsel, Mr. Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel concept of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask your honours and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had the speech of 2 pages prepared, but to his regret, it didn't come from the heart? And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colourful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy, quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth, and that hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to bruise the prosecution on the matter is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers. The same goes for another witness's outlandish assertion that bodies were thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced. As for counts 2 and 3, Ms. Croft showed us some maps with coloured dots to indicate the magnitude and geographical spread of what the prosecution alleges, without, of course, proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, for this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the appeals chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432 in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient. Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered, but she neglected to contextualize these numbers by reference to other parts of the same report which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages. So, if I may just conclude, the only thing that is widespread here, or rather spread wide, is the utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory, with respect to the definition of the targeted population, is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting two alternative propositions, hoping that this pre-trial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, comprised prison detainees, professors, history, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? It was not as if it had been denied the arrest warrant for El-Hishri that it had sought. Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10th February 2025, the prosecution rushed out its application for Mr. Duterte's arrest.